Welcome, everyone, to the hearing that's happening in Harney County, um, in Oregon. So, actually going a little live early because they're going to be calling everyone into the courtroom here in about a minute or so. So, I want to be able to make sure I'm live streaming from the very get go so that you guys can all see what this is all about. I may talk over someone, I'm going to try not to talk too much over what's going on in the courts, but I may kind of give my opinion. So I'm going to play my little intro, and then I'm going to start screen sharing the courtroom. So,
in a world of uncertainty and turmoil, one man stands alone, along with his faithful sidekick. A man who entertains and educates the masses weekly, 70% of the time. Born out of the dusty plains of Washington State, now from the coastal forests of Oregon. The man, the myth, the man. G23.
So, I want to thank Jerry Parker, Clem, and C-Dub. I know CB is over here in Oregon, and Mr. M. Gabriel. So let's start the screen share. So, um, so you can see on the screen is the WebEx that they're showing over for the Harney County Courthouse. So if there's any questions about this, we can talk a little bit before we start having the actual court proceedings. So this is to find out if we're going to get the temporary restraining order that's in effect right now, stopping Measure 114, which would require a purchase permit to buy a firearm. It would also require 10-round magazine ban. So anything over 10 rounds will be banned in the state of Oregon. And I don't know if anyone's going to introduce into evidence that this actually violates Oregon Constitution in two separate occasions. It violates the ballot measure part of the Constitution, where you cannot have more than one thing on the ballot measure. So the fact that it's the pistol purchase and magazine ban automatically violates. So. Yeah, and Gabriel, those 50%ers are Portland people. So that's where this actually barely passed, like 50.6%, and yes to no. So having it pass versus having it fail, separated by right about 25,000 votes. So um, we shall see. Um, thank you, G-Webs, for posting a link during your chat. Um, so I do know we have about 12 people watching, maybe more. So hopefully here in the next couple of minutes they'll actually start discussing. You can kind of hear people in the background. But yeah. Welcome Triggerfish. Welcome Bernie Sanchez, Joe Morgan, Mr. Jacob S. So hell, it sounds like there's a hell of a lot of laughing, so I don't know what the joke is. Wow. Did somebody hit a hot mic? So, so this is scheduled for 9 a.m. And
Thank you everybody for coming. I just think over the rules and everybody kind of knows them. These released a couple hats. If everybody could remove hats. We're looking at pretty much no essential rules that are out there. No weapons, and we obviously thank you for your patience with the metal detectors and screen stations, all that. We were tasked with providing support security for no weapons, no hats, no recording devices, and no cell phones recorded. You can have those on mute, so will not record, please. I know this is an emotional subject, but no emotional outbursts. If you love it, they would just record. So that's basically it. And everything goes good. Thank you.
So this is a court hearing, and they should be getting ready to call it into order here right now. Um, it's supposed to start at like 9 o'clock, so should be within the next couple of minutes that we should start hearing the judge and everybody.
Please rise. Circuit Court is now in session. Honorable Robert S. Ratio presiding.
Good morning. Please be seated. We'll go on the record now in Joseph Arnold, Cliff Asmussen.
Well, hopefully we get the court back. Looks like they just dropped audio. They dropped completely out of the live stream. So hopefully we can get this.
The parties are ready to proceed. This is a preliminary injunction hearing.
Okay,
We're
we're
going to
back.
start with the limited question of maintaining a temporary restraining order with regard to the permit to purchase question. The way this argument, the way this situation's been framed to the court is we have a permit to purchase component of ballot measure 114 and a large capacity prohibition, large capacity magazine prohibition. Those are the two issues as I understand them as they've been framed to me so far. So the court has issued on sections 1 through 11, which is the permit to purchase and the remaining sort of administrative functions, including background checks, et cetera. The court has issued a temporary restraining order because the defendants have told the court that they're not prepared to deploy that program in the last hearing. And then on the and of course, that has also been subject to action by the federal court, district court, where there was an agreement by the parties that that would be stayed for a period of 30 days as the state got prepared to move forward with it administratively. And then The separate issue is on large capacity magazines, which that was not stayed by the federal court, was subject to a temporary restraining order from this court. And we're going to have a full hearing on whether the court should grant a preliminary injunction. The burden of persuasion is on the plaintiff to prove by clear evidence that there's irreparable harm if it goes into effect. Am I accurate so far about where we're at for the plaintiffs,
Yes, Your Honor.
for the defendants?
Yes, Your Honor.
Okay. So let's start then with the question of the permit to purchase, whether or not the court should continue the temporary restraining order until the defendants are prepared to ask the court for review, because they're prepared at that point in time to start a permit to purchase program.
Thank you, Your Honor. Starting with where the federal court is. The federal court had put in a stay order that is a binding order on the state defendants that requires that the state not be able to require or permit to purchase a firearm under the law for 30 days, as the court said. The parties have also informed the federal court that we intend to extend that stay until February 8th. We provided a status report to the federal court last Thursday or Friday of last week, providing that information. We have requested a status conference to present that to the federal court. And so we would be talking about a period all the way to February 8th. The federal court acted before this court had an opportunity to hold the temporary restraining order hearing. And so our view is, under ORCP A1A, the only thing that the court has authority to restrain is something where the commission or continuance during the litigation would produce injury to a party. And under 79B1A, that immediate and irreparable injury, loss, or damage will result to the applicant. There is no damage to any of these plaintiffs because the federal court order prevents any possible damage. Baker, the Oregon Supreme Court case that we cite from the very early days of Oregon law, says that the plaintiff has to show a danger of suffering irreparable injury, and they are in no such danger. Judge Emerget's order is binding on the court. And that also distinguishes the authority that my friends on the other side cite from Judge Irwin in Washington County. And in Washington County, Judge Irwin decided that it was insufficient that Washington County said it alone decided that it would not implement or not enforce a particular requirement of Washington County law. And he said the reason that wasn't sufficient was because it wasn't binding on Washington County. This court, the federal court's order, is binding on the state defendants. And so there's no basis for, under Rule 79, for the court to enter any sort of order prohibiting the state defendants from acting. There's a second reason, a second source of authority that prevents the court from entering a temporary restraining order on this issue, and that is that the plaintiffs have sought a declaratory judgment. And Beck against City of Portland says that the controversy must involve present facts as opposed to a dispute which is based on future events of a hypothetical issue. The test is whether a claim for declaratory relief is justiciable, is whether the existing state of facts threatens the plaintiff's legal rights. And the existing state of facts does not threaten the plaintiff's legal rights, because the existing state of facts is that the federal court acted before this court did, and that prevented any possible injury to the plaintiffs from requiring a permit for the firearms. The case that they present to the court is hypothetical in two ways. It requires first that the federal court's order expire. That's the first way in which it's hypothetical. We don't know whether the court will continue to extend that beyond the 30 days, beyond the February 8th that the parties have requested. And secondly, it's hypothetical in the sense that the court has no way to adjudicate the as-applied challenge that they're presenting, that it will be too hard to get a permit whenever this requirement goes into force, is their basic argument. The court can't adjudicate that. It doesn't know what the state of affairs administratively will be at the time it goes into effect. So there's no basis for the court to provide a temporary restraining order or a declaratory, based on its declaratory judgment jurisdiction today.
Though, as things stand right now, the state of Oregon, if the permit to purchase process goes into effect today, there's no process available, which means that it would be an outright ban on the ability to purchase firearms until that process went into effect. Is that accurate?
I would say that there is a process. I would say that there is a barrier to that, which is that certain local law enforcement officials have not designated certified trainers in order to provide live fire demonstration. So now granted, that's relief that doesn't make a great deal of sense to seek against the state. That's really relief that should be sought against.
I'm not interested in that. I'm
Okay.
just interested, I mean, sheriffs are going to follow the law. That's what they're required to do because they're law enforcement agents. They don't get to pick and choose what they want to enforce. However, in these circumstances, if it were to go into effect today, under Oregon law, nobody could purchase a firearm.
No one has been issued a permit yet, so no one could purchase a firearm.
No
Correct.
administrative process in place that would allow them to get a permit.
I don't agree with that, Your Honor.
Okay, well, tell me why I'm wrong
So
on that. 'Cause I'd be
there's
interested.
an application online. I'm just disagreeing with the administrative process piece. There's an application available online. Any person who is in unincorporated Harney County can print that out and present that to the Harney County Sheriff. The only barrier that really exists to them getting a permit is the fact that the Harney County Sheriff has not identified any one to provide a live fire demonstration of their capability to fire a firearm. Everything else is ready.
There's a class ready to go?
Yeah, it's online.
Okay.
It's online. It's
Why are you
provided by the
agreeing-
Sheriff's Association.
Why are you agreeing to a stay in the federal process?
The main reason is that we do not have, local law enforcement has not identified sufficient numbers of individuals who they can certify to provide live fire demonstrations. And so without that piece, which is an essential component of the permit process, we are not able to issue permits.
Go ahead.
Morning, Your Honor. Defendants have asked this court not to enter a preliminary injunction or continue the temporary restraining order because plaintiffs cannot show irreparable harm. Defendants appear to ask in the alternative that this court issue injunctive relief that parallels the federal courts. Plaintiffs assert that they're entitled to a preliminary injunction today, or at the minimum, a temporary restraining order lasting as long as the federal court's temporary stay. The state cannot today defend the constitutionality of a law that does not currently exist, or a process that does not currently exist and is not capable of examination. However, plaintiffs can have, Your Honor, as Your Honor stated, demonstrate that in its present form, Measure 114 acts as a complete ban on the purchase of firearms, which is presently and unquestionably violative of Oregon's Constitution. This is because the law presently would act as a complete ban because the permit to purchase program has not been employed and licenses are not obtainable. It is unquestionable that an outright ban on the sale of any firearm would violate Oregon's Constitution. Defendants state that plaintiffs cannot show imminent and irreparable harm. The uncertainty surrounding Measure 114's implementation is causing confusion and harm today for Oregonians, including firearm dealers. Do they place orders to meet high demand? Will they be forced to lay off employees soon? Should they spend money on a firearm and risk the inability? Should Oregonians spend their money on a firearm and risk the inability to complete the purchase due to the sudden lifting of the federal court stay? I would submit to the court that the plaintiffs in the federal case could dismiss their lawsuit, and the temporary stay is gone at that point. It evaporates. Further, with respect to the state enjoining enforcement of the permit to purchase program, enjoining the permit to purchase program produces no harm to the state whatsoever. They've already stipulated to the stay, so they cannot show any harm on their end. So even if the state would suggests that the harm to plaintiffs is minimal, it still tips the scales when measured against zero harm for the state. In the recently decided Washington County Circuit Court case, Schwartz v. Washington County, and that's case number 22 CV 04836, a circuit court judge faced a similar question. I represented the plaintiffs in that case, and a copy of the court's opinion is attached as Exhibit 12 to the ILO supplemental declaration. There, the county was unable to enforce the ordinance due to lack of personnel and asserted by counsel for Washington County. The county attempted to use non-enforcement against the plaintiffs to defeat the imminent harm element of the analysis. However, the court in that case found that using the inability to enforce a law to defeat imminence weighs in favor of the plaintiffs in that case because of the public interest element. The state cannot simultaneously claim to champion the public's interest while also not enforcing the law. Plaintiffs are further prejudiced by the federal court because the federal court's already ruled against further preliminary relief. So if the case were dismissed or if the stay was lifted, the law would go into effect right away and plaintiffs would be forced to rush back to the courtroom. So at a minimum, there should be a temporary restraining order lasting beyond that of the federal court judges to allow the plaintiffs time to come to court and present their evidence and argument to the court. However, plaintiffs assert that defendants cannot show any harm on their end. They cannot claim to champion the public interest. They cannot say the balance of harms tilts in their favor, and they cannot defend the constitutionality of a program that does not exist and is not available today.
What was the ORCP site? I think I wrote it down incorrectly. That you gave me,
79A and 79B.
okay. I thought I heard you say 8, so let's look here. We would agree this court has original jurisdiction on the Oregon constitutional questions.
In principle, yes.
I mean, under the Constitution, not in principle. Under
They
the
brought
Oregon
it declared-
Constitution, Article 7, subsection 6 of the original Constitution, which was not amended, says that this court has original jurisdiction. You agree, right?
The courts, the species of jurisdiction the plaintiffs have invoked is declaratory judgment in jurisdiction. Declaratory judgment jurisdiction is a creature of statute, and that they have to meet all the requirements of declaratory judgment jurisdiction. They have not. That means that there's no, at least with respect to the permit to purchase component, that's insufficient. They have not invoked any other species of jurisdiction.
And you agree then also that the section A1A that you cite to the court talks about injunctive relief during the course of the litigation or during the litigation, right?
Yes.
And so this litigation is on a separate track than the federal litigation. You would agree with that as well.
I would.
And there is, if the court finds that there's an irreparable harm, the court can issue, if there's clear evidence of an irreparable harm, the court can issue a temporary restraining order.
Are we only talking about ORCP 79? Or are we talking about that and declaratory judgment jurisdiction?
Well, ORCP 79, because the declaratory judgment issue is, they've asked for both. They've asked for injunctive relief and declaratory judgment. It's not, they've asked for two separate remedies in their complaint.
They have asked for injunctive relief as a supplemental remedy to the declaratory relief.
No, Your Honor, it is an action for declaratory and injunctive relief as stated in the caption of the complaint and in the prayer.
Do you want to respond to his arguments regarding the federal litigation and the instability of relying on another judge's determinations?
The notion that the Oregon Firearms Federation is going to voluntarily dismiss, the likelihood of that is not, they cannot prove that that is more likely than not. It's not a reasonable fear. And The 30 days plus the state's commitment to extend it to February 8th is also not a reasonable fear today to continue the injunction. The notion that, with respect to the public interest component, first, it's their burden to show irreparable injury. So if they don't show irreparable injury, that's the end of the conversation. They need to establish that they haven't, they lose. The second piece of it is on the public interest. Having 2 court injunctions on this issue is not in the public interest. It's important that there is that on this particular issue, if there are details with respect to the scope of the injunction and so forth, it is more, there are 4 sets of plaintiffs in that federal litigation. They are doing an extraordinary job of representing the same exact interests that Mr. Aiello is representing in this court, and they will be able to represent those interests there. We trying to negotiate this where there's a possibility that one court interprets the scope of its injunction one way, the other court operates it a different way, is not in the public interest.
Wait a second. When you say interest, you mean just the right to bear arms, because obviously this is litigation under Article 1, Section 27, and that litigation, that judge has no jurisdiction to interpret Oregon law unless it's in the context of a finding that the Second Amendment applies.
And the federal judge already ruled that magazines are not part of the Constitution. So therefore, the federal judge cannot rule on any part of what is being sought in court today. And for some reason, we've lost audio. Hopefully we can get some audio back. I'm not sure. Okay, well, this is... I don't know what is going on because I have no audio. I don't know if they accidentally muted. I know they've had issues already, but this is quite lovely. Is anyone else hearing the court's audio? Because I am not hearing anything from the court's audio. Yeah, I don't know what's going on. I'm not going to use the call me function because then you guys wouldn't be able to hear any of this. So I don't know if I should try. I'm going to stop screen sharing and try bringing it back. So I've closed out the meeting. I'm going to try to I'm going to try to re-log into it. Hopefully they'll let me back in. I don't know. You gotta live. Yes, this is. Hopefully we can get back in. Yeah. Well, have a good day in New York. Hopefully we'll get this thing working again. Otherwise, this is going to be completely irritating. Yep, I don't know what's going to happen. Guess I'm missing some cool stuff that's going on. So, I guess we got video back, but still it's not connecting to the audio. I am not hearing any audio. at all. Well, guys, I'm completely hopefully we can figure this out, because people in the side chat are saying how great this is. So, I mean,
after 5 p.m., plaintiffs did receive a filing, but the issues were narrowed by this court at the last hearing as well as previously.
And the court is enjoining a provision that was not challenged by the plaintiffs. We would like to be heard as soon as the court is available.
Okay. Ten o'clock on December 23rd.
Your Honor, may I check my calendar on my
Yes.
cell phone?
And now tell me what we're talking about specifically with regards to sections what and what?
Mr. Wilson is gonna talk about what the particular sections that we are objecting to.
Thank you, Your Honor. It will be to sections 6, 7, 8, and 9. And there are particular provisions within each of those sections that apply only to the Charleston loophole.
I'd like to have a written request that clarifies to me what you want to talk about so that I can be properly prepared.
We will provide that, Your Honor.
I'd like that before Friday.
We can do that, Your Honor.
And we can set the hearing at 10 o'clock on December 23rd.
Your Honor, plaintiffs would state that today is December 13th and December 23rd is at 10 days. So I guess if defendants want to provide written notice and today, that would comply with this court's earlier order, but if they did not, it would not comply with that order. I would suggest that we have that hearing after the new year.
The court slows down during the intermediary between Christmas and New Year's with regards to my staffing. I just don't have the capacity to do it other than on the 23rd. So that's when we're going to do it. And I wanted identified specifically what sections the state is wanting the court to make findings on. Okay, so that will be the order of the court with regards to sections 1 through 10 of the, let me just make sure that's completely accurate. And of course, on section 13, I mean, obviously the order's directly on sections 13 in terms of enactment date. So that'll be enjoined as well. Section 12 is on the severability question. Okay, well, I think that resolves those issues for 10 days. So we can move forward then with the question of a large capacity ban or prohibition question and whether the court should issue a preliminary injunction. The burden is on the plaintiffs to show by clear evidence that the ban should go into or should be, that the court should continue its preliminary enjoyment of the enactment of that portion of ballot measure 114.
Are we to witnesses, Your
I
Honor?
think we're to witnesses.
Okay.
Thank you.
Thank you, Your Honor. Plaintiffs call Mr. Callaway to the witness stand.
It's a separate proceeding, Mr. Callaway, so I'll swear you in again. If you'll stop right there and raise your right hand. Under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Have a seat up here. Once you're seated, you can state your name for the record and spell your last.
Benny Callaway, last name Callaway.
Go ahead, please, Mr. Aiello.
Morning, Mr. Callaway.
Morning.
What do you do for a living?
I own and operate spent cartridge here in town.
How long have you done that for?
Oh, a little over 8 years.
Are you required to be licensed as a firearm dealer to operate your business?
Yes, sir.
What licenses are though?
I have a federal license and a state license.
Who issues the federal license?
The ATF,
And what about the state license?
Secretary of State.
As a part of your job, do you regularly review which firearms are available and legal to purchase in the state of Oregon?
Yes, sir.
What sort of research do you need to do to ensure that you comply with those laws?
Make sure everything I'm selling is legal. You know, you gotta keep up with all the laws. You know, I'm not really sure how to expand on that.
Are you familiar with the requirements of ballot measure 114 insofar as they apply to magazines capable of holding 10 rounds?
Yes.
Your Honor, at this time, plaintiffs move to qualify Mr. Callaway as an expert on modern firearm technology and firearm sales in the state of Oregon.
Well, I mean, I think you've talked about sales. I don't know about modern firearms technology at all. I don't think there's been any showing under 701, 702 of that. So,
Mr. Callaway, as a part of your job as a licensed firearm dealer, do you look at how firearm technology interacts with new and emerging laws in Oregon?
Yes, we certainly try to.
And do you have to make sure that this firearm technology complies with Oregon law?
Yes.
Do you have to make sure that firearm technology comports with federal law as well?
Absolutely.
Your Honor, plaintiffs move again to qualify Mr. Callaway as an expert on modern firearm technology and firearm sales.
go ahead, Ms. Wilson.
We'd object to that, Your Honor. We don't believe that the testimony shows that Mr. Callaway has any legal training to review whether the ballot measure or any other law complies with a particular firearm. We also don't believe that plaintiffs have shown that the kind of research that Mr. Callaway does is consistent with what Oregon law requires in sorts of education, training, review of scientific research, that sort of thing that is required to qualify as an expert.
Your Honor, Mr. Callaway has to make sure that the firearms he sells as a licensed firearm dealer comport with the laws of the state of Oregon and federal law. It means he's looking at the way this technology works, including, as Mr. Callaway has previously testified, the way the law interacts with magazines, which is at issue in this hearing. Mr. Callaway gave excellent testimony at the last hearing and spoke at length as to the way Measure 114 interacts with the firearms and firearm magazines that he sells and must be licensed to sell.
Under Oregon Rule of Evidence 702, I do find that Mr. Callaway has technical and specialized knowledge on the sale of firearms that will assist the trier of fact in understanding the evidence and determining a fact at issue, and that he qualifies as an expert based upon knowledge, skill, experience, and training. Don't think there's been a showing on the educational component, just to his training and his skills are sufficient to qualify him as an expert, and I will do so. Go ahead, please.
Mr. Callaway, in the course of your work at your business, have you placed any successful orders for California compliant firearms or magazines?
No.
Why is that?
Because I'm not sure what is or Oregon compliant. It may be California compliant, but that's not necessarily Oregon compliant with the new laws.
Have you tried to place any orders recently for California compliant weapons?
Yeah,
Have you tried to place an order? When you place those orders, what feedback do you get back from the distributor?
that these firearms cannot currently be shipped to Oregon because of the magazines having a base plate that's removable and can be readily modified.
So-called California how many rounds do the firearms you are attempting to purchase hold?
10.
What California compliant firearms have you attempted to purchase?
I've tried to purchase a Beretta 92, Ruger Security, and a Ruger American rifle in 223 and 300 blackout.
What action does the Ruger American ranch rifle you just mentioned use?
Bolt action?
Is a bolt action firearm a semi-automatic firearm?
No.
Why can that firearm not be purchased by your store?
Because of the magazine it accepts. It accepts standard AR-15 magazines, but it ships with a 10-round magazine. But that standard magazine can be converted to hold more than 10 rounds, so they will not send it.
Have you attempted to purchase any magazines capable of only holding 10 rounds?
Yes.
Through whom did you attempt to purchase those magazines?
Midway USA?
Is that a popular distributor in your business?
I think it's known nationwide.
What responses did you receive from Midway USA when attempting to purchase these magazines?
That these magazines are not Oregon compliant and cannot be shipped to Oregon
Why, in your opinion, are these magazines not Oregon compliant?
because they can be modified to hold more than 10 rounds.
Are you aware of how magazines that are already capable of holding more than 10 rounds are permanently altered to be made California compliant?
They can't be permanently altered.
In
That I'm aware of.
In California, are you aware of how California goes about altering those magazines?
It depends on the magazine, but let's take the AR-15 magazine. They put a rivet in the magazine that restricts it to hold less than 10 rounds or 10 rounds or less
Where do they put the rivet?
in the side of the magazine.
Is it at the bottom of the magazine?
No,
Where is it on the magazine?
on the side.
How might one go about restoring a magazine that has been altered with that rivet in order to allow it to again hold more than 10 rounds?
That's a simple hand drill.
How would that work?
You just drill the rivet out. It's simple. I mean, you could do it potentially even with a pocket knife. Those rivets are aluminum and you can just scratch it out of there with a pocket knife. And with a hand drill, it takes less than 3 seconds.
In your opinion, would that require specialized firearm knowledge such as a gunsmith?
No.
What sort of 10 round magazines have you attempted to purchase recently for which you've received a denial?
Glock, Beretta, Ruger, 6 Hour. Yeah, any of them. You select any of them in Midway USA, they will not send you a 10 round magazine.
Why is the removable base plate an issue for Oregonians wishing to purchase 10 round magazines in Oregon?
Because they make an extension for those base plates. You can slide that base plate off and slide a extension on there.
To the best of your knowledge, are there standard size magazines for handguns that are below 10 rounds?
I'm sorry, I didn't understand.
I'll phrase it another way. What type of handguns do you sell at your store?
6 Glocks, Rugers,
Now, I'm not talking about brand. What sorts of sizes of handguns do you sell at your store?
full size, compact, mid size, the micro compacts.
What's another name for a micro compact handgun?
Concealable, pocket pistol.
So those full-size handguns, what size magazine comes standard with those handguns?
It depends on the gun, but generally 15 to 20.
And I believe you testified earlier that those firearms can hold fewer than 15, a magazine capable of holding fewer than 15 rounds in a 10 round magazine.
So yes, most of those companies do make a 10 round magazine for those firearms, but not all.
Do they make smaller than a 10 round magazine?
Not that I'm aware of,
So,
for most of the full size guns.
so in your opinion, would any full-size handgun be capable of being sold in Oregon under Measure 114?
No,
Why is that?
because you could potentially modify the magazine to hold more than 10 rounds.
Aside from attaching extenders, what are other functions for that removable base plate, if any?
To clean the magazine, to replace the followers, to replace the springs.
Are you aware of any firearm magazines for a full-size handgun that do not have a removable base plate?
I'm sure there are some that do not have one, but I cannot think of one.
Have you been able to locate magazines that do not have a removable base plate through Midway USA?
No.
Moving down to a smaller size firearm, what's the next smaller size of handgun besides a full-size handgun?
A compact.
How many rounds? How many rounds can a typical magazine for a compact handgun hold?
Generally between 8 and 17.
Up to 17?
Mm-hmm.
Do those magazines also have a removable base plate?
Yes.
What size extenders are typically offered for those types of magazines?
Anywhere from 1 to 5.
So in your opinion, to have a compact pistol comply with Measure 114, it would have to be a magazine capable of holding X number of rounds with an extender of Y number of rounds, and the total has to fall below 11. Is that correct?
Yeah.
What is a subcompact? What size magazines does a subcompact handgun hold?
Most of them hold 6 to 10.
Are you aware of extenders that can be affixed to those magazines to make them non-Measure 114 compliant?
Yes.
In your opinion, what percentage of handguns will you be unable to sell due to ballot measure 114?
The way I see it, probably 90%. If not all of them. Depends on how far you take 114. 114 states in there, in any kit or such parts. So if you have two 10-round magazines because you're trying to be compliant and a roll of tape, you could be in non-compliance because you could use that tape to couple those magazines together. And coupling the magazines together is stated in 114 that is not legal.
I'd like to move on to rifles here for a moment. What, in your opinion, is the most popular rifle at your store?
The Remington 700.
Is that a semi-automatic rifle?
No, it's a bolt action.
Does that rifle accept a magazine?
Some of them do, yes.
What size magazines do those rifles accept?
Anywhere from 3 to 10.
Are you aware of extenders available for that rifle?
Yes.
What size extenders fit the magazines for that rifle?
So some of those still take the standard AR-15 magazine. So they make a 6-round, I believe Lancer makes a 6-round extension for them.
What size magazine comes standard with an AR-15?
30.
Are there magazines that are smaller than 30 offered for an AR-15?
Absolutely.
How small do they go?
I believe down to 5.
And Lancer offers an extension up to 6 rounds, correct?
Yes, sir.
In your opinion, would that make the firearm capable of holding more than 10 rounds?
Yes.
I'd like to talk to you for a moment about shotguns now. At your store, do you sell semi-automatic shotguns?
Yes, sir.
What's the most popular shotgun? Semi-automatic shotgun.
Probably a Weatherby Element.
What size magazine does that shotgun accept?
I believe that one's a standard 6-round.
Are you aware of any extenders offered for that shotgun?
There is.
What size extender is that?
Usually between 4 and 6. But if you use the mini shells in conjunction with that, you can get a whole lot more shells in there. So if you have a standard 6 plus a 4-round extension, you're at 10. You'd think you'd be all right. But you can shove about 12 mini shells in there.
Are you aware of any provision in ballot measure 114 that differentiates between shell sizes?
No.
So would it be safe to assume that Oregonians need to assume that they are loading their shotgun with mini shells in order to make sure they're compliant?
Yeah.
So that was a yes.
Yes.
You can
Yes,
say
sir.
yes, not
Sorry.
yeah. Go ahead, please.
No.
Well, I don't know what's going on. I don't know. The audio is not wanting to work. I'm gonna try this again. See if I can back out of the meeting and then come back in to the meeting. So we shall try this for another time, and hopefully we don't keep losing audio. And hopefully it doesn't take us another half hour to get reconnected. So, G-Webs is asking what's happened so far. So most of Major 114 is going to get another temporary stay until December 23rd. And they were hearing testimony on the magazine issue. And we've lost audio. So we're going to try. Trying to connect audio again. This is all being a real pain in the ass. I don't know if maybe I just need to stay on the page, on the meeting page, instead of switching back over to the StreamYard side. So I'm going to open up the live chat on my cell phone and then just keep this over here on the WebEx page, and maybe we'll be able to hear the audio whenever they decide to connect my audio. So yes, Maggie, at least this time I wasn't talking when the audio dropped. So I'm gonna okay, so we will allow access.
Located in Oregon?
No.
What did What did Midway USA represent to you when you attempted to purchase that firearm?
They said these.
Your Honor,
these
at
are
this
not-
point, I'm gonna object on hearsay grounds. Going to conversations with manufacturers.
Test his knowledge, since I've authorized him as an expert at your request, he can go into the basis of his knowledge, which includes written treaties, hearsay, any number of different forms of evidence. So I'll overrule. Go ahead, please.
Thank you, Your Honor. Do you recall the question?
No.
Let me try again. When you attempted to purchase the Beretta from Midway USA, and they said no, what did they represent to you as the reason they would not sell it to you?
Because of the base plates of the magazine.
And was that representation in the form of an email? How did you receive it?
It comes up on the screen when you try to check out with it.
When you attempted to purchase the Beretta from Xander's, what happened?
They just won't let you add it to the cart.
Was there any other representation that they provided to you other than not letting you put it in the cart?
I called my representative with them and said, what's the deal? And they said, same thing Midway USA said, you know, and the only firearm I could currently purchase from them was a firearm that ships without a magazine.
What is the name of your representative with Xander's?
Stephen?
Do you know his last name?
I don't remember it off the top of my head. I do have it. Stephen Walsh.
Stephen Walsh.
Yes.
Is Mr. Walsh located here in Oregon?
No.
When you attempted to purchase the Ruger from Midway USA, did you receive the same response?
Yes.
Did you also attempt to purchase the Ruger from Xander's?
Yes.
And did you receive the same response?
Yep.
Mr. Callaway, have you attempted to purchase a Glock 19 with a 10-round maximum capacity magazine?
Yep.
And when did you do that?
Oh, yesterday, I believe.
And where from?
Midway.
What was the result of that attempt?
Same result. Will not ship because of the base plate.
Mr. Callaway, you mentioned that you talked to your representative with Xander's. Did you call anyone at Midway USA to inquire about their policy? And other than Midway USA and Xander's, have you attempted to purchase firearms with a maximum capacity of 10 rounds in the magazine from any other vendors?
I have not.
Have you had any phone calls with any other vendors about whether they would sell such firearms?
They said until the law was in effect, I have called Lipsy's. They said until the law was in effect, they would continue to ship as long as they figure I can receive it before the law goes into effect.
And what was the name again? Lipsy's?
Mm-hmm.
Can you spell that for us?
LIPSEYS, I believe.
Okay. Other than Lipsy's, Xander's, and Midway USA, any others that you've spoken with?
No.
Mr. Callaway, you testified that approximately 90% of your handguns may not be saleable because of Measure 114. And as part of that testimony, you mentioned that a person could potentially tape two magazines together. If you taped two magazines together, would that create a functioning magazine?
Yes.
How so?
You have two functioning magazines, one pointed up, one pointed down, and all you have to do is flip them over. And it states right here in 114 that coupling two magazines is against the rules.
Mr. Callaway, magazines have a spring in them that pushes the ammunition upwards, isn't that right?
Yep.
And is that spring designed to have a specific tension for a specific kind of magazine?
Yes.
Okay. So would taping two magazines together allow the springs to work in such a way that that magazine would be safe and functional to use with
Yes,
firearms?
because you're not combining the magazines and you're not messing with the springs at all. You're just simply taking two magazines, flipping them this way, and taping them together where it hangs outside of the firearm.
What do you mean by flipping them this way? That
So-
you
so the
you
feed
made
lips-
hand motions, but
yes.
you need to describe it
Yes.
orally.
So the feed lips on one magazine will be pointed up while it's inserted in the firearm, and the feed lips of the other magazine pointed down while the other magazine is inserted in the firearm and taped together what's remaining out of the firearm.
Go ahead, please.
They'd be side by side, not end to end.
Mr. Callaway, does a revolver take a magazine?
No.
Could you continue to sell revolvers at your store after the implementation of Measure 114? Just to ask you
Yes,
again.
sorry.
No
Yes.
problem. Mr. Callaway, you talked a little bit about the factory magazine for the Glock 19
Mhm.
during your testimony. Is the Glock 19 factory magazine made with a single stack or a double stack magazine?
For which capacity of magazine?
I'm sorry, for a 10-round capacity magazine.
For a 10 round, I believe it's a single stack.
And is it your testimony then that there is extenders that would attach to a single stack Glock factory magazine?
Yes, I believe they do.
And who makes those extenders?
Glock themselves, many manufacturers online.
Can you identify some of those other manufacturers?
Not off the top of my head.
You also testified some about the AR-15, correct? Are you familiar with Sentry Tactical, sir?
No.
Are you aware that Sentry Tactical makes a magazine that can be attached to an AR-15 style rifle and that has its base plate riveted shut?
No,
You're not aware of that?
I'm not aware of that.
Okay. Have you ever done any research or investigation into Sentry Tactical?
No.
Generally speaking, Mr. Callaway, is it correct that most firearms that are capable of holding a magazine with a capacity of more than 10 rounds can also take a magazine that has a maximum capacity of 10 rounds?
So, yes, most, but not all.
Most, but not all. So for example, we were talking about the Glock 19. You can purchase a Glock 19 that takes a 10-round magazine, correct?
Yes, but that magazine can also be converted to hold more.
Understand that. That's your testimony. So when we spoke earlier about the Beretta that you attempted to purchase and the Ruger that you were attempted to purchase, those were firearms that were going to have a maximum capacity 10-round magazine, correct?
Yes.
Mr. Callaway, you talked some about base plates and how they're removable. Is it the case that there are some magazines that have base plates that are not removable?
There maybe, but not in common use that I know of.
And could it be that a base plate could be permanently fixed to the bottom of a magazine, either with glue or some other kind of rivet or something like that?
You may be able to, but that would also prevent you from maintaining your magazine.
And as we just spoke a moment ago, we discussed single stack and double stack. I think we better try to explain that for the court. Can you explain what a single stack magazine is as opposed to a double stack?
The single stack magazines, the ammunition stacks one on top of another. As where a double stack magazine, they stack side by side in the magazine.
So it is the case that there are some magazines that are single stack and some magazines that are double stack, correct? Mr. Callaway, when you attempted to purchase 10-round magazines from Midway USA, did you attempt to purchase any magazines that had their base plates permanently fixed on?
There was none that I could find.
And when you spoke with the representative from Xanders, and I believe that was Mr. Walsh, did you ask Mr. Walsh if Xanders sold magazines with base plates that are permanently fixed on?
Magazines themselves, no. We talked about purchasing firearms, not the magazines.
Okay, so you didn't talk about whether Xanders was able to sell you a magazine with a base plate permanently fixed on, correct?
Yeah.
When you spoke with Mr. Walsh, did you discuss whether Xanders was able to sell you any single stack maximum capacity 10 round magazines?
No, we talked about firearms.
Did you attempt to purchase any single stack 10 round maximum capacity magazines from Midway USA?
I couldn't find any.
When you spoke with Mr. Hopp, and that is the Glock representative,
Mhm.
correct? Did you ask Mr. Hopp whether Glock manufactured extenders that could be affixed to Glock factory 10 round magazines?
I'm sorry.
Sure, let me try again. When you had your conversation with Mr. Hopp, did you discuss extenders with him?
Yes,
And did you ask him whether Glock manufactured extenders that could be affixed to
Yes.
10 round magazines?
yes, they do.
And what was his response to you?
They, 1 to 2 round extension.
Mr. Calloway, you talked a little bit earlier about state compliant firearms, and I want to just ask you a little bit about that. A California compliant firearm, what do you understand that to be?
California compliant firearm is a firearm that does not accept a magazine that holds over 10 rounds,
Okay. And so
or has a magazine that holds over 10 rounds.
the vendors you discussed earlier, Midway USA and Xanders, do they sell what are sometimes called California compliant firearms?
Absolutely.
Okay.
Yes.
You spoke with Xanders, Lipsy's, and Midway USA. Is it possible that there could be some vendors that would sell 10 round magazines into Oregon that you haven't called or spoken with?
Oh, it's certainly possible.
No further questions.
Redirect.
Yes, Your Honor. Mr. Calloway, to your knowledge, are there currently sold any firearms that are advertised as Oregon compliant?
Not that I'm aware of.
Are you aware of the difference between California compliance and Oregon compliance?
Yes.
Objection calls for legal conclusion.
Your Honor, we've been talking about his interpretation, or his
You
application.
need to establish a foundation for the question before I'll admit an answer to it. So go ahead and establish a foundation if you can.
Mr. Calloway, as part of ordering these California compliant firearms, have you reviewed the different requirements between California's magazine requirements and Oregon's?
The only difference I have found is the removable base plate. In California, it's allowed, and in Oregon, it's not, according to certain vendors.
So would you agree that the difference between Oregon and California's requirements when it comes to magazines is that base plates are allowed in, removable base plates are permitted in California, but not Oregon?
That I'm aware of, yeah.
You testified a moment ago about, or you were asked about a specific magazine that defendant's counsel represented to you had its removable base plate riveted shut.
Mhm.
Call that testimony.
Yes.
Would riveting a base plate to the bottom of the firearm operate as a permanent change to that firearm?
No.
Why is that?
Because the rivet could be removed.
What about gluing, as defendant's counsel suggested?
Glue can be cut.
In your opinion, can one readily restore a firearm that has been altered with a rivet or glue to make the base plate no longer removable, to make the base plate removable again?
Yes, absolutely.
Mr. Callaway, you were asked about other distributors who said that they would ship you magazines. Is that correct?
Yes.
On what condition, if any, did those distributors say they would ship you those magazines?
As long as they feel that I can receive those in time to sell them before Measure 114 goes into effect.
Did you ask them at all about the effect of the injunctive relief granted either at the federal or state level and with regard to Measure 114?
I'm sorry.
I'm sorry. Did you ask them how their phrase this differently? Did those distributors tell you that they would not ship you a magazine if it could not be sold by the date that Measure 114's ban on large capacity magazines goes into effect?
Yes.
So would you agree that the only thing stopping, or the only thing allowing presently the distributors to ship you those magazines is the injunctive relief already granted by this court?
Yes.
Do you believe that if this court did not continue its injunctive relief, they would continue to send you magazines?
Objection, Foundation.
Yeah, I'm going to sustain.
The firearms, the firearms that we've been questioning you about that you attempted to purchase, were those advertised as California compliant?
Yes.
No further questions, Your Honor.
I do have a question, and I'll let each side follow up. You said something, and the things I don't know are important to me. So it says that, you said that if there's a permanently fixed base plate, that the magazines cannot be maintained. Can you please describe what you mean by that and what the consequences would be of being unable to maintain your magazine?
If you don't maintain your magazine, dirt and everything else from the use of the magazine gets down inside. So you get all that gunk down in there, and the spring and follower doesn't work right and will not allow the firearm to function properly. So it could malfunction when you need it.
And how often do you need to maintain your magazine to have it functional?
Probably about every other time you use it. You should make sure everything's clean and ready to go.
So your testimony is that if there's a fixed base plate, that gun owners would need to purchase new magazines every other time they use their firearm?
That could be argued either way.
Well, then tell me just argue it then. I want to hear what you have to say.
My apologies. When you use the firearm, the magazine gets dirty as well. The debris from the shells going off gets everywhere and down into the magazine. So you should clean your magazine every other time. Can you go more? Yes, you can. But you would need to purchase new magazines rather than clean them when they do get dirty, depending on how much you use them.
Why?
Because you couldn't get them apart to get everything out of there and make sure everything's cleaning and working properly.
Go ahead, Mr. Wilson.
Mr. Callaway, how much does a magazine cost at your shop?
Depends on the magazine. Anywhere from $20 to $50.
Is it impossible to clean a magazine without removing a base plate?
To clean it properly, may not be impossible, but it's improbable.
What do you mean by improbable?
That you cannot ensure that everything's out of there.
there are some cleaning procedures you can do even with the base plate affixed, correct?
There are some, yes. But not entirely.
No further questions.
Not entirely what?
You can't clean the magazine entirely.
Do you have any follow-up to that?
No, sir.
Any
Miss-
follow-up to those questions?
Yes, Your Honor. Mr. Callaway, what portions of the magazine would you be unable to clean without, or would you be unable to clean without removing the base plate?
The bottom of the magazine and where around the spring, the follower sits on top of the spring. So you could compress the follower all the way down and clean what's above the follower, but nothing below. Other than soaking it in fluid, and that couldn't make sure that you get all the big particles out.
When individuals use firearms, would you agree that it's typically outdoors?
Yes,
Would you agree that Oregon is a wet climate?
yeah.
How does one avoid rust from forming on a spring in a magazine that's used outdoors?
Oil,
Would you be able to oil the bottom of the spring to prevent rust if you could not remove the base plate?
you could only spray it in there and hope it gets everywhere you want it to go.
Would that be messy?
Yes,
Could it cause any malfunctions with the firearm to over oil the spring?
yes. If you got too much oil in there, plus the oil would collect the dirt faster.
No further questions, Your Honor.
And that accumulation causes the magazine not to be able to function over time.
Yes, sir.
Okay, thank you. You can step down.
Thank you.
Attorneys can come up, please. We're going to take a 15-minute break and take up the next piece of evidence from there. Thank you.
You don't want to take the aisle seat when you put right with me.
Yeah.
So right now they're on a 15-minute break, and yeah, we're so far this judge has been just knocking it out of the park, doing a great job of really digging in and getting as much information and making sure that it's absolutely clear what's being discussed so that everybody can really understand. So that's pretty cool.
So technically, a couple of months. That would be kind of sheriff's.
Yeah, absolutely, hobbies. When when they put out the law, they didn't. I don't think that they completely understood the ramifications of what would come of this, and so I'm gonna double check and see. Okay. Because it's going to affect shotgun owners. It's going to affect rifle owners. It's going to affect pistol owners. It's going to affect law enforcement. Because an off-duty law enforcement officer, if they want to buy a new firearm for like their personal, they're going to have to get a purchase permit, and then they'll have to abide by the 10 round because they weren't given an exemption. So that means in their personal carry is going to have to be a 10 round magazine. They won't get the qualified immunity for like being a law enforcement officer. That's only going to be when they're on the job. So at this point, as more and more law enforcement officers are really starting to understand, they're like, wait, I can't carry my standard magazine? So yeah, KV, that's hopefully exactly what we're doing, that we're going to do. And truly, I really start hoping they argue that this violates the Oregon Constitution under two separate measures, not only under the constitutional, the fact of the Second Amendment, also it violated the Oregon Constitution on ballot measures. So, in Oregon Constitution, it says that no ballot measure can have multiple items in its ballot measure. So they can't say the pistol purchase permit and then magazine issue. That then becomes unconstitutional. Once they put that second issue in there, then it should never have been able to go onto the ballot. So Wow, there's a hell of a lot of people just chatting away in the courts. So, and so they have a live chat function, and I had it open earlier, and so I don't know if having it open was causing any other kind of stress, and that's the reason why one of the reasons why I'm just trying to only keep the actual courts going. So, yeah, actually, they have been talking about the constitutionality of this, and since this is just a preliminary hearing, no side has made a motion to dismiss any parts of Measure 114, like saying, "Hey, we've presented enough evidence to prove, beyond a reasonable doubt that this completely violates." So I don't think we'll get to that point at this hearing. They'll definitely keep drawing this through the courts. And I guarantee you the state's already running to the Supreme Court right now asking that whatever this judge rules today be overturned so that they can be tyrannical, and hopefully that the state Supreme Court sticks with what they've already said and say, you know what, tough it out, deal with the courts. They've already told the state that they had to wait and come to this hearing, and there's going to be another hearing on December 23rd, which is the Friday before Christmas at 10 a.m. to redress the permit issue. So I'm going to try to live stream that as also. We shall see what's going to happen with there. Yeah. Just gonna check the StreamYard side for just a second. So, and the part of the 10-round mag, that's what we're listening to right now. We've heard testimony so far, and now they're in a 15-minute recess. And when they come back, they'll be hearing more testimony. So the 10-round mag issue hasn't even been decided if they're going to keep the stay in place What's going on, Smeggy? Are you there?
Okay, now I'm here. Thanks for giving me the invite.
Oh, you're welcome. I think G-Webs is in your gilded, isn't he? Mr. Smeggy.
Okay, sorry, my connection's being weird. I'm trying to get everything else set up. But anyways, yeah, thanks for the invite. Like I said, I wasn't quite ready. I didn't know you would pop a link right now. I was thinking after the whole day, I was in the middle of
Yeah.
doing something. But I do want to touch on something real quick. I put it in the chat there, and the dude was asking about if you clean the mags without a removable base plate, blah blah blah, all this stuff. It popped into my head, and the idea is like, can you do it? Yeah. Like, should you do it? No. But the analogy would be, can you drive your car on a flat tire? Yes, you can, but it's not advised. His logic would then be, well, then you don't need air stems or valve stems. Like, that's the removable base plate is a valve stem. You can air in and out of it. Make the base plate. You can change the string. You can clean it all out. You can do whatever. It's funny, like, well, technically you could do this, but it wouldn't be great. Therefore, our law should be allowed to stand. Like, doesn't make any sense to me.
Yeah, absolutely. The way this judge has been going, I honestly, I think he's going to keep his stay in place. And the more and more I hear from him, the more and more I realize how much of a constitutional judge he is. He's not really giving a crap like what your feelings are. He wants to know exactly, like, give me the facts, give me the evidence. I don't want to hear all this other BS. And that's really kind of good, you know.
Yeah, he seems okay. I mean, we'll see. It all kind of depends on whatever happens. But really, the other thing on this law, like really the hang up is the convertible or may be able to use blah blah blah. Like whatever the phrasing is, I forget exactly off the top of my head. Because that really is like, if somebody can do something they're not supposed to, then none of us are allowed like anything. That doesn't make any sense to me. Again, just from a philosophical thing.
Please rise. Circuit Court is now in session.
All right. Well, I'm going to go ahead. I'll drop off for now and just listen. And then if there's another break or at the end, I wouldn't mind jumping back in.
Yeah, the link will be in Smeggy Cave.
Witness.
All right.
Yes,
Thank you. I appreciate
We'll
that.
call Mr. Isaac Botkin to the stand. He is appearing via WebEx.
Mr. Botkin, are you there? All right. Sir, if you'd raise your right hand.
Sure.
And tell me when it's, and there it is, raised. Under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I so swear.
Thank you. Go ahead and lower your hand. Before I do that, I just wanted to make a note I forgot to make right on the outset. My understanding is that there's a chat going on the WebEx lines. I cannot see that chat. That chat is not a part of this court's consideration. I won't be looking at it into the future, just so everybody knows. That has no relevance to me in terms of the court's determinations today. So go ahead, please, Mr. Botkin, state your name for the record and spell your last.
My name is John Isaac Botkin, last name spelled Dotkin.
Your witness.
Morning, Mr. Botkin. What do you do for a living?
I work at T-Rex Arms. We're a small manufacturing company. I'm currently the technical and education officer at T-Rex Arms.
How long have you worked in that profession?
I've been full-time for about 6 years. I've been working with T-Rex Arms from the very beginning. We're almost 10 years old at this point.
Can you spell the name of the organization you work for? Because I'm having some difficulty hearing it.
Yes, sir. That is T.Rex, REX, ARMS. Do I need to mess with my microphone settings?
No, it just wasn't coming clear to me. Go ahead, please.
Are you or your company licensed federally or at the state level?
We have an FFL, a federal firearms license, that allows us to transfer firearms. Yes, sir. And we're also licensed as a Class 3 manufacturer as well.
Where is T-Rex Arms based out of?
We're based in Middle Tennessee. Even though we are licensed to manufacture firearms, primarily we are manufacturing firearm accessories, holsters, and nylon goods, chest rigs, plate carriers, rifle slings, belts. But a lot of holsters made of plastic, a lot of mag carriers. We also have a retail side of the shop where we do sell other weapon accessories, weapon lights, and magazines.
Aside from the retail and manufacturing side of your business, do you do any work with manufacturers?
We do. So when a manufacturer is coming out with a new handgun, they often will send us that firearm so that we can begin to make a holster for it, so that we will actually have the holster available for customers who are purchasing that firearm upon its release. And we have also worked with some other manufacturers on some other projects. We've put together some light mounts and optic mounts and have tested those with various manufacturers. So it is, it's a pretty wide variety of things.
So you testified a moment ago that part of your work with T-Rex Arms concerns education. What does the education portion of your business look like?
Some of it is training videos for our specific products. Some of it is training videos for the products that we carry. We also carry medical and safety equipment like body armor. But we also try to do some historical, some technological, and just get into some of the history and political side of the firearms culture and firearms, I guess, history. So educating people as to how products work, how they've been developed, but also as to firearm rights, the Second Amendment, et cetera. So we do that through a YouTube channel, podcast, email newsletters. So those are the main platforms.
How do you prepare for your YouTube videos, podcasts, and newsletters?
Generally with a lot of research, if it is going to be a video on those topics. So I can give you a couple of examples. One of them is one on the history of suppressors and the National Firearms Act, talked to a number of other researchers, read a number of documents from the 1930s surrounding that debate. Recently, I did a video about the history of firearms development leading up to the AR-15, and just a number of reading as many source documents as possible, talking to a number of experts in the muzzleloading community, since that was something that I had less hands-on experience with, and just trying to write a really solid script and get that reviewed by other people in the industry who have sufficient knowledge to fix that script and make sure that it is tight.
As part of your video concerning AR-15s, did you have occasion to handle firearms that have existed throughout history?
Yes, I was not able to get my hands on a early 1500s handgun, hand cannon, but a gentleman named Ethan Hardy was able to bring several not reproduction, but original firearms, flintlock, muzzleloader. He brought along original issue Sharps carbine and several other firearms that were originally issued by the United States military or owned by private citizens prior to the war between the Civil War. And I'm trying to remember the exact dates on some of those. I can go back and check notes if you want to know every single one.
In preparation for your testimony today, did you perform any research to prepare for this hearing?
I read more about some of the arguments that have been presented in the past on magazine restrictions. I attempted to look into Oregon's militia laws. I'm more familiar with Tennessee, where I live. I just wanted to get a better sense of what was happening in the mid 1800s at the time of statehood.
In preparation for today's hearing, did you review any documents that I sent you?
You sent documents related to, I don't know the actual term, but documents related to the filing of this case from both sides. And you also sent some documents covering, I think it was acquisition by Oregon forces, different Union Army acquisition of different rifles throughout the mid 1800s, 1860s.
Prior to reviewing those purchase orders that were attached to the supplemental ILO declaration, did you have knowledge from your educational research?
Identify them, please, as the exhibit number.
Oh, yes, I'm sorry, Your Honor. That would be exhibit. I believe it's 3.
Exhibit 2, 1 through
Exhibit
6. Go ahead, please. Door's locked.
Specifically the Sharps rifle that shown as purchased on Exhibit 2 to the ILO declaration. Had you performed research prior concerning the Sharps breech loading rifle?
I have. The Sharps breech loading rifle, there's a number of different models, but at the time, many of those that were purchased by the U.S. military, by the Union forces, they were a single shot breech loading rifle with a falling block mechanism, but they did actually have attached to the side a small magazine for primers. So that did not contain the propellant or the projectile, but the primer was actually magazine fed from a small spring-loaded tube magazine. And that was a feature that was used in the field. It actually depended more on logistics. If those primers were available, they were used, but the rifle could also function with other percussion caps. So the use is somewhat sporadic depending on supplies.
From your research, I'm sorry, T-Rex arms, does T-Rex arms specialize in all sorts of arms or any specific arms?
Well, we specialize in small arms for private citizens. So we do not actually sell firearms on our website, but we provide holsters for a number of different handguns, and we provide optics, lights, and other accessories for a number of different rifles.
And is your research in that area focused on small arms as well?
For the most part, I find a lot of military history fascinating, but individual soldiers and militias and equipment that pertains to stuff that I do in my day-to-day job is the most fascinating.
What did the first what did the early small arms firearms look like?
Objection.
Basis?
Lack of foundation. The gentleman isn't a historian, and it calls for expert testimony. There's been no foundation laid for his basis of knowledge for the first firearms.
Your Honor, plaintiffs have no issue with qualifying Mr. Botkin as an expert, but the issue here, no one's a witness to history. He's done firsthand research, including looking at primary sources such as early firearms. So he's just testifying about firearms he's personally reviewed. But if Your Honor would like to consider him as, would like us to qualify him as an expert, we believe we've laid the foundation to do so. I just don't think it's necessary for Mr. Botkin to give his opinion. It's just from his research, what were his findings?
The question, if I'm recalling correctly, was what is this category of early firearms? If he wants to ask questions about specific firearms that this gentleman has reviewed and used, we have no objection to that. If he's going to make broad sweeping conclusions about history, he doesn't have the qualifications. He's someone who provides public communications based on his assessment of reliance on professional historians. The testimony was that he doesn't even believe he himself is qualified to make a YouTube video without checking with people who actually know the history.
That was not Mr. Botkin's testimony. However, Mr. Botkin has performed primary source research in the form of looking at firearms and working with other experts in the area of firearm history and in preparation of making educational videos. So at this time, plaintiffs would move to qualify Mr. Botkin as an expert on firearm history, as well as in his capacity as working in the small arms manufacturing space. But at a minimum, plaintiffs should be able to ask Mr. Botkin about the firearms he's personally reviewed. Plaintiffs will concede that Mr. Botkins does not have a PhD. However, degrees are not necessary in order for Mr. Botkin to be a learned expert in the area of firearm history. He's reviewed primary source material as he just testified.
And again, the question asked required a sweeping conclusion about history writ large, not about specific firearms that the witness has personally inspected. We have
So, I mean, I look at those as two separate issues, Mr. Marshall. The first question is whether he's an expert under Oregon Evidence Code 702. And then the next question is he asking a question that is too broad to give any kind of clear, it calls for a narrative, essentially, I think. But
that's not my objection. My objection is if the narrow question is as a participant in the firearms industry and within the scope of his professional duties, does he have special knowledge? Certainly, regarding modern firearms. Does he have special knowledge because he has inspected certain firearms? Yes. But if we're talking about conclusions about what in general the early firearms are, that's outside of the scope of his expertise. He's not a professional historian. He testified that he relies primarily on people who actually know the history, even when he's just making public educational videos, not even at the level of court testimony.
Your Honor, would it assist the court in ruling on defendant's objection for plaintiffs to ask some questions of Mr. Botkin about the content of his video and what he reviewed specifically for that video where he handled primary source firearms?
I think what it would be useful for me to know is what exactly what are you offering his expert testimony on, so that I can then test against what's been testified to for expertise, because obviously the case law is clear under Oregon Department of Transportation versus Montgomery Ward, 79 ORAP 457, that an expert in one subject may not qualify as to give an opinion on another subject, even if they are within the same related area. So what I'd like is clarification to what you're offering his expertise for, and then I can then adjudicate the question of whether you're asking a question that falls within that scope.
Yes, Your Honor. Mr. Botkin, what I'm going to question Mr. Botkin about is how firearms developed from early rudimentary firearms to the modern day AR-15, and how specifically for this court's examination of the merits of this case, about how these firearms are essentially the same firearm, just modified by modern design and function, which is part of the Kessler analysis that this court has already spoken about. So essentially, plaintiffs intend to show that the firearms banned under Measure 114 are rifles, shotguns, and pistols that have existed since the 1500s. Mr. Botkin has handled primary source firearms shown to him by their owners, who are also historians. He's performed ample research in this area.
So to that, do you say he has not laid a proper foundation for that testimony?
He has laid proper foundation for individual firearms. The notion that Mr. Botkin is qualified to describe the entire sweep of history based on his examination of a handful of weapons, we object. That is not, he doesn't have expertise.
Is that the question was overbroad and called for narrative. I mean, so we're back to what I said originally.
That is not our objection. Our objection is under 702, that he is asking a question beyond the scope of his expertise under Montgomery Ward, which the court cited.
Okay. Well, I mean, the concession is that he is able to testify to firearms development from rudimentary firearms to what they refer to as the modern AR-15, which is a weapon that's been in production for 40 years. But my understanding is that's what they're going to offer the questions for.
And in terms of the interrelationship and the development over the sweep of history, we object.
Okay, well, I'm not sure who could give that sweep of history analysis. Mr. Marshall, is there anyone who can do so? So what I hear you saying then ultimately is the Kessler analysis is useless to us because nobody can testify to the sweep of history and the changes in technology from 1857 to now.
We have provided declarations from two professional historians in this case. One of them is available to testify this afternoon. They are able to say, based on 12 years of study as a professional historian, that that these are PhD level historians in 19th and 20th century, 18th, 19th, and 20th century American history, that they have looked at the arms trade throughout history and actually inspected the entirety of the historical record and can provide grounded opinions that are actually, in fact, based on all of the factors under Rule of Evidence 702. And Mr. Botkin has testified that he doesn't feel comfortable providing educational videos without it being reviewed by someone who is more qualified than he is to make historical conclusions. We don't think that is sufficient education, training, experience, and so forth in order to provide these historical claims.
The state's objection is essentially that he does not have a PhD, which is not what's required by the Oregon Evidence Code. However, Mr. Botkin did not testify that he did not feel qualified to give an opinion on the history that he's reviewed. Mr. Botkin testified that he, like every other qualified individual, engages in peer review and speaks to others who who are aware of the history as well. It's no different than checking a secondary source document, which plaintiffs and defendants have offered in this case. Even tertiary review, even tertiary sources such as law review articles that cite secondary sources that cite primary sources.
The good news for the record is I'm not required to adopt any particular opinion from experts. And so that's the good news. And you're welcome to test his knowledge through cross-examination and to offer additional evidence that's different and distinct from his. And I will wander through the credibility determinations to decide who the court's going to rely on for purposes of this historical record, if it's possible. There's a piece of me that doesn't believe it is, but I will listen to the arguments of the parties as we move forward, and I'm going to allow them to offer him as an expert witness based upon his knowledge and his interface with the field.
And Your Honor, can I offer a standing objection so I don't have to interrupt the examination?
You know, that's fine. If that, I believe standing objections can exist. I think the Court of Appeals has said they have it from time to time because you want to make sure that it's very specific to an area. But I'm happy to allow you to have a standing objection that he is not an expert under Oregon Evidence Code 702.
And to be more specific, our objection is to him making, not to testifying about specifics of contemporary firearms, nor about particular features of firearms that he has personally inspected. It is about making historical conclusions. That is the basis of our objection.
Right. I understand, and I think I understand what you're saying. And I would just note for both parties, because it's going to be, might be important at some point in time, that Kessler is dicta on the question of the development of firearms, because Kessler was dealing with a non-firearm weapon, the billy club. And so all of the stuff that we're evaluating from Kessler lays out a standard, but it doesn't relate directly to firearms. All right, go ahead, please.
Thank you, Your Honor. Mr. Botkin, when you were making, I'm sorry, Mr. Botkin, could you give the title of your YouTube video again?
I believe it was Why Everyone Needs an AR-15. I may have gotten some of the contractions wrong there. Why everyone should own an AR-15. It was one of those.
In your overview of the firearm history, in that video, what's the first firearm that you handle?
First firearm was essentially a hand cannon. It was exactly the same operating principle as a full-size cannon, but small and on a stick. So an individual soldier could handle it and operate it like a cannon, loaded with propellant, and then a ball, and then touch it with a torch. With the touching a torch to the touch hole provides the ignition.
How did that fire? How, if at all, did that firearm improve from the handheld torch to the next phase of firearm development?
So essentially, there have been very few fundamental changes to the way that firearms work. There's always a propellant, there's always a projectile, there's always a means of ignition. The first upgrades were to the means of ignition. And so they went from a swinging match on a matchlock, a number of different wheel locks and dog locks, and eventually ended up at the flintlock. The flintlock was a superior technology. It was much more robust and resilient. Guy came into common use in the early 1600s. It emerged out of France, and that was the dominant form of ignition. That was the dominant form of firing a firearm for almost 200 years. That's one of the longest periods of time that some of this firearm technology has been relatively stagnant, even though there were developments with minor projectile developments and manufacturing developments.
Are you aware of any firearms in the essentially the hand cannon phase, as you phrased it, that could fire more than 10 rounds?
Objection, vague.
There's no examples.
Hold on, please, sir. The objection was that it was vague.
Okay, I can rephrase your honor.
Is that an objection?
It is. I said, I'm sorry. I tried to say objection. I should have risen.
Oh, that's all right. You said objection vague?
Vagueness, that it's an ambiguous question with firing 10 rounds is, I'm unclear what he's asking. Is it requiring reloading, without reloading, et cetera?
I don't think this is,
I'm gonna overrule. If the question is relevant, then it's relevant. I don't know what vague is exactly under the evidence code, but I would assume it is a 401 objection, and I'll say that it's relevant. Go ahead, please.
Mr. Bakken, do you need me to restate the question?
I'm not aware of any examples of a hand cannon that would fire 10 rounds simultaneously. It would be relatively simple to make, but it would be just ridiculous. So I can't imagine that there were examples of that in use.
Are you familiar with the 16 shot wheel lock rifle?
Yes.
Okay.
After there is a move from hand holding a torch to different ignition systems, there are a number of repeaters that are built. Some of them have parallel barrels, multiple barrels. Some of them have rounds loaded sequentially in series and have different ignition sources for each of those. There are many examples of individual firearms created by individual craftsmen that are capable of repeated fire of several different rounds.
Do you know when the 16 shot wheel lock was introduced?
I believe it was in the 1580s. I'm not confident in that exact date.
Who led the development of did civilians or military technology advance firearm technology more quickly?
Nearly all of the developments that we can see up to the 20th century are individual private citizens. So most of the major developments that we can see, individual craftsmen, anytime there is a major leap, it is civilians, it is private companies in the private sector developing those. And it is usually private citizens adopting those as well. Militaries are often very sluggish, partly because they already have armories filled with yesterday's technology. They have manual of arms and training that is designed for the previous generation of equipment. But the development, manufacture, and adoption, I would say, are primarily driven by the private sector. And I can give some examples, some specific examples, if that would be helpful.
I'd like to first ask you specifically about percussion cap technology. Do you know who created percussion cap technology initially?
I cannot think of his name right now, but he was a Scottish pastor. So a good example of a civilian. His interest was in hunting birds. He wanted a faster ignition for his flintlock fowling pieces, and he developed a percussion cap that contained a mercury fulminate. So when that was crushed by a falling hammer, that provided a much faster ignition of the propellant inside of the barrel of the rifle. And that was a great example of a technology developed by an individual private citizen and then rapidly adopted by hunters, and then much more slowly adopted by large militaries that had large armories filled with flintlock rifles, slowly converting those over.
I'd like to ask you about the Sharps breech loader. Do you know when the Sharps breech loader was introduced?
Developed for sale, or I'm afraid that I'm not clear on exactly what you're asking.
When was it developed for sale?
I believe it was the 1840s. There were several different versions of it, and I'm afraid I wouldn't want to be too specific at this point.
Why would you not want to be too specific?
Just based on wanting to be extremely accurate for the purposes of this proceeding. It definitely predated the Civil War, and it predated the adoption of advanced repeaters. But prior to the war, there were a number of civilians who were on the cusp of developing a number of these technologies. There were a number of repeaters that were being patented in the 1840s. And the Sharps rifle was adopted by people who wanted extreme accuracy, but also by primarily the Union. Confederates also fielded some, because it offered a very fast reload compared to the muzzle loaders that they had been issuing up to that time.
You testified a moment ago that the Sharps breech loader could accept up to 25 primers. Could you explain what you mean by that?
Yes. So the primers that they accepted were almost identical to the percussion cap invented by the Scottish pastor, and they were smaller and slimmer, and they sat in a vertical tube with a spring on the bottom and a little arm just pushed those out underneath the magazine, underneath the hammer. So from the magazine, it just lifted up and slid it forwards. It's really similar to a modern firearm action, where bullets are raised vertically and put into a firing position under a striker or a firing pin. And but that was only the primer. That was only the ignition source. The propellant and the projectile still had to be inserted one at a time through the breech of the barrel.
Who adopted rifling earlier, civilians or the military?
Civilians adopted rifling in larger numbers and earlier, because civilians who were operating individually as hunters or defending their own property wanted accurate shots. Military doctrine of the time desired firing speed over accuracy, and the musket balls of the time, if you had rifled muzzle balls, you had to actually drive those down past the rifling with a ramrod. So it took additional effort and it took additional time to actually reload a rifle over a smoothbore musket. It was a great advantage to civilians. It was not an advantage for predominantly the militaries of the day.
I'd like to ask you about the Henry repeater. Do you know when that was developed?
That went into production in 1860, and that was one of the first firearms that really made the most of the new metallic cartridges, and it was able to hold 15 of those in a tubular magazine underneath the barrel.
Was that rifle used in any wars?
That rifle was used pretty extensively in the Civil War. It was issued by the Union Army, but it was actually privately purchased by a number of individual soldiers, even prior to it being adopted by the Army. So by the end of the war, there were an estimated 5 times as many individual soldiers who had purchased that rifle privately with their own money than the War Department had purchased and issued.
Do you happen to know whether which side of the war Oregon fought on?
I believe Oregon fought on the side of the Union. The Union was the army that was primarily fielding the Henry rifle. There were definitely Confederate soldiers who captured Henry rifles, but they found it very difficult to find ammunition for the Henry rifle. So the Henry rifle was used almost exclusively by Union forces.
Now, you testified that the Henry rifle was introduced in 1860. Is that correct?
That is correct.
Are you aware of any firearms that existed prior to 1859 that were capable of firing more than 10 rounds without reloading?
Yes, there's a volcanic rifle, and it it directly predates the Henry rifle. Prior to that, there was a Jennings rifle. And these are rifles that, I'm trying to remember the exact dates. The Jennings rifle was patented in the 1840s, 1849, I believe. And there were several thousand that were ordered. I haven't been able to confirm exactly how many actually made it into production because the gentlemen that were building that rifle made so many improvements along the way. They turned the Jennings rifle into the Jennings Smith rifle. Those ideas were adopted by the volcanic rifle. The volcanic rifle went into much wider production and saw much wider adoption. And it was able to carry, there were 3 different barrel lengths. Each barrel length had a different magazine length. So it came in 20, 25, and 30 round magazine capacities.
To the best of your knowledge, was the Girandoni air rifle developed before 1859?
It was developed before 1859, and it was used on the Lewis and Clark expedition. That's the most famous example of one in use, and they actually had some pretty glowing things to say about it in journals and documents reporting on their expedition.
What about the pepperbox revolver? Are you aware of when that was developed?
That is not an incredibly precise term, but there are a number of handguns with multiple barrels and revolving barrels and a single ignition source that start showing up in the 1830s. And I couldn't tell you about an actual adoption date of one that had more than 10 barrels.
I'd like to shift from history and go into your work now. You testified in that T-Rex Arms sells magazines. Is that right?
That is correct. We don't sell a wide variety, but we definitely sell the Glock magazines and the AR-15 style Stanag magazines that are the most common.
Do you sell any magazines to the state of California?
We do not.
Why is that?
The state of California requires magazines to be modified to accept only 10 rounds, and that is just something that we would prefer not to carry, and so we've decided not to sell those to California. We do sell magazine extenders to California because those are legal there.
And I'm sorry, I'm going to shift back to history here for a moment. Looking at the way firearms developed, were rifles in existence prior to 1859?
Oh, certainly. Rifles were in existence very early on in firearm development.
And how have they changed from pre-1859 to modern times?
So in 1860, with the Henry rifle, that was pretty much the death knell of non-metallic cartridges. So essentially, ever since that time, all ammunition has contained the ignition source, the primer, and the propellant, and the projectile together. And those metallic cartridges are more resilient to moisture, and they're just better in every possible way. And so ever since then, rifles have essentially just been slightly different mechanical mechanisms of loading and containing the ignition of that ammunition source. So as there's been a movement from the lever action, where you have a lever that actually automatically loads that cartridge into the chamber, there have been other developments like bolt action rifles that have a slightly different motion that does the same thing, generally from a box magazine, up through semi-automatic rifles. Essentially, it is just more elegant solutions for the exact same problem. And oftentimes, it isn't necessarily a new idea of how to do it. It is manufacturing technology that develops, oftentimes so that an idea that has existed long in the past that cannot be mass produced suddenly becomes capable of mass production it becomes something that can become a product, something that can be used by a large number of people. So that, I would say, has been the main driving force, is just more elegant, more reliable, more cost-effective, and more accurate ways of doing the exact same process of loading the ammunition into the firearm itself.
Would you agree that these are changes in function?
Speaking legally or from an engineering perspective?
No, just from your perspective as, I mean, it sounds like the firearms have changed, but they still fire a projectile. That's a very base level here?
Correct. And at a very base level, the function of the firearm has not changed. There have been minor changes to the function of loading the projectile and ammunition into the firearm. There have been minor changes to the ergonomics of using the firearm as a result.
Is that the same for handguns and shotguns as well?
It has been, and oftentimes those are in direct parallel. When flintlocks were the best way to fire a rifle or a musket, all shotguns were also flintlocks. All pistols were also flintlocks. When the percussion cap technology develops, all handguns, all shotguns become ignited by percussion caps. They are really in sync with only a few minor exceptions.
No further questions at this time.
Defendants.
Good morning, Mr. Botkin. Is it Bachman with a B or with a D?
With a B.
Okay. You testified that your company doesn't sell California, any magazines to California. Do your competitors sell magazines to California?
There are a number of retailers, I would say, who are a similar size. I guess I would call them competitors that do indeed sell California legal magazines to California, yes.
Going to the history, how many firearms roughly were owned by civilians in the United States in the 1850s in aggregate?
That is a question that I don't believe can be answered, because there were no real records kept of firearms being manufactured or sold. Those would have to be really, really wild guesses, in my opinion.
Do you believe it's more?
I believe that it would not. Sorry.
Go. I apologize, sir. I thought you were done. Go ahead.
I certainly think that it would be reasonable to assume that there were at least as many firearms as there were adults.
So you think the best estimate for a lower bound, so the lowest possible number of firearms, would be the number of adults in the 1850s who lived in the United States, 1-to-1?
I think that would be a decent ballpark, and that would be something that we could start with, so we're all on the same page. I would say that's probably a reasonable assumption based on historical documents.
And I apologize for this. It's just to get the historical pieces correctly. Do you mean all adult humans, or did you mean a subset, by race or by sex?
Oh, well, that's an excellent question, because states would have answered this at different times. at that time. But I would say, generally speaking, all human adults. That would be, I think, a pretty safe starting number as well.
The 16-shot wheel lock, am I getting the name correct?
That is correct.
When you said that it was in the 1580s that it first became available, did you mean that's when it became invented or when it became commercially available?
I'm not confident whether that was commercially available. Some of these proof of concept devices, it is not clear whether they were created for a commercial client, whether they were created as a proof of concept for an artisan. A number of them are known and talked about in journals, but it is not clear whether they were available for sale or whether they were part of a commission.
What is the most possible number of 16-shot wheel locks that could have been sold worldwide?
Well, they probably would not have left Europe, but it would have been, I would say, dozens. Those would have been a very complicated piece of machinery to build with the tools of the time.
Can you provide me some brand names for breech-loaded loaded rifles that you were describing being available in the 1840s?
So the Sharps rifle is the best and most common example. There were a number of other smaller rifle manufacturers at that time. There really weren't large mass production houses the way that we think of them now. That was just on the cusp of happening. In fact, just if I could go back to the Volcanic for just a second, the guys that worked on that rifle were a Mr. Smith and a Mr. Wesson, who went on to create a manufacturing company, a Mr. Henry, who went on to create the Henry rifle, and a Mr. Winchester, who went on to create Winchester. So the large firearm manufacturing houses, as we think of them, that was just on the point of happening when the Sharps rifle and the Spencer repeater were hitting the market. And a lot of these smaller companies were bought up by larger companies and ended up being owned by Smith & Wesson or Winchester or Remington.
So the three that I heard from you there are Sharps rifle, Volcanic rifle, and Spencer rifle. Am I getting that correct?
The Spencer was actually a repeater. It had a 7-round tubular magazine in the stock, and then the Volcanic was a repeater with a 20, 25, or 30-round magazine in the 1850s.
Which of those would you consider to be breech loaders?
Well, technically, they are all breech loaders, but they are. The Sharps rifle is being manually loaded by human fingers. The Volcanic and the Sharps, the Sharps is a manually loaded breech loader. The Spencer has a lever action mechanism that loads from a magazine. The Volcanic is also a lever action mechanism that loads from a magazine, but they are loading into the breech, which is the rear of the barrel, not the muzzle of the barrel. All modern firearms are all technically breech loaders at this point, but we refer to the action like a bolt action, a semi-automatic action, or a lever action as opposed to where they're being loaded, simply because muzzle loaders are their own thing. Everything else is a breech loader.
Sharps rifle, would you consider that a fixed magazine or a detached magazine or something else?
The Sharps rifle had a fixed magazine for the primers and no magazine for the projectile.
For the primers, would you consider that a tubular magazine or some other type of magazine?
It was a tubular magazine, and it was fed from a clip.
What was the maximum number of rounds that a Sharps rifle could carry?
Well, it could carry 20 to 25 primers, depending on the thickness of the primer. It could only carry one projectile in the chamber. in the breech of the barrel.
So the answer is 1 round.
1 round of ammunition complete, 1 round of projectile and propellant.
When was the Spencer invented?
I'm afraid I don't have that off the top of my head. I believe it was 10 years before the Henry, so that would have been in the 1850s. But again, the way that these weapons develop, oftentimes there are prototypes, there are patents. It was certainly available for purchase in the 1850s.
How many were sold?
Well, there were thousands sold to the Federal Army and considerably more sold to civilians, but I don't have numbers on those because that wasn't something that was tracked by the government at that time.
You said that was a 7-round maximum for the
Correct.
Spencer? Okay. On the volcanic.
7. Sorry,
Oh,
yes,
go ahead, sir.
Go ahead. Yeah, 7 rounds for the Spencer. The magazine was located in the stock. So even though there were multiple barrel lengths, you always had the exact same magazine size.
Was the volcanic a semi-automatic weapon?
No, it was lever action. It required that you actually move the lever to cycle the action and eject the old round, insert a new round.
How long would it take to fire 20 shots with the volcanic?
Aim shots, I'm sure that it could be done in 10 seconds if you were not worried quite as much about aiming, less than 5.
Per shot or in aggregate?
You could fire, I believe, a 20-round magazine in 5 seconds if you were not aiming as carefully between each shot.
How
You
long
could
would
mag dump that very quickly.
how long would it take to reload a volcanic?
I'm actually not sure because that would kind of depend on how you had your ammunition staged. And I don't actually know the retail packaging of those volcanic rounds. I imagine that it would take probably a couple of seconds per round to get those into that tubular magazine. The Jennings rifle was a little bit faster, but the volcanic was improved by a spring that actually made reloading a little bit slower. So I would have to guess a couple of seconds per round for someone who had practiced.
How many volcanic rifles were sold in the United States to civilians in the 1850s?
Several thousand were manufactured. We don't have exact numbers on those that I'm aware of. Some of the reason for that is it's not clear which of those numbers were pistols and which of those numbers were rifles.
How many were sold in Oregon?
I'm not sure how many were sold in Oregon.
Could it be 0?
It's very unlikely that it would be 0.
You have any records to show that?
I have no records to show that other than Oregon was a very prosperous state of the 33. And it just seems very unlikely to me that advanced weaponry would not be interesting to the folks settling Oregon and the very lucrative fur trading operations that were here at that time.
How many Gerardonis were in the United States in the 1850s?
I don't have a number for that.
Dozens, maybe?
Oh, certainly dozens. Yeah.
Probably not hundreds.
Again, it's very, very hard to say. Without the ATF keeping track of serialized firearm numbers, it would be guesswork outside of any actual importation lists from merchants.
Correct me if I misheard you. Pepper box revolvers did not have more than 10 rounds at a time. They didn't carry more than 10 rounds at a time.
They came in a number of different sizes and varieties, so they were almost always an even number. It was generally 4, 8, but there are definitely models with 12.
And when was the first model that had 12 rounds become commercially available in the United States?
I'm afraid I couldn't tell you. Again, this is early enough that there's a lot of individual gunsmiths manufacturing these as opposed to factories. And so oftentimes it's very difficult to tell when a model appears and when people start making copies of it.
Were these detachable magazines or fixed magazines or something else?
They certainly were detachable. The cap and ball style revolvers, the easiest way to reload it was often to remove the cylinder. The same was true of a pepper box revolver. Some of them, in the interest of cost, were not detachable, and it was a very laborious and painstaking procedure to load those.
How long would it take for the less laborious procedure? How long would it take to reload per round for a pepper box revolver?
That's hard to say. I wouldn't even want to comment on the time for that. Again, we're talking about a sort of a marketing term for a revolver, not a specific model type, and a very complicated procedure that isn't really systematized. So the numbers would be wildly different from person to person and from revolver to revolver.
Fair to say that a modern handgun could be reloaded more quickly than a pepper box revolver could have been reloaded in the 1850s?
Oh, certainly. That's the main reason we don't have pepper box revolvers today. Because they sure look cooler.
No further questions.
Redirect.
Mr. Botkin, would you agree that that multi-shot firearm technology, firearms capable of firing multiple shots, were somewhat experimental?
In the early days, they were very experimental, and they were very well known. For example, double-barreled rifles and double-barreled pistols were commonly used by a few people, but most would prefer a single-shot rifle because it was lighter, because it was cheaper. So this is something that everyone was well aware of, but common adoption is harder to put your finger on. And some of those more advanced experimental devices, like the Jennings rifle, are a good example of something that was widely discussed but not widely sold.
Would you agree that multi-shot technology was a common goal amongst these many manufacturers you've discussed?
Absolutely. The capability of a firearm is going to be some combination of accuracy, reliability, and then power. And the easiest way to improve the power of a firearm is to be able to get off multiple shots. So that has always been a very clear, obvious pursuit of weapons developers, gunsmiths, and artisans.
Were manufacturers attempting to move backward, stop progressing this technology?
There is no evidence of people moving backwards without external regulations enforcing that, and generally not until the 20th century.
Were the multi-shot firearms being developed intended for civilian use?
I would say that they were, without exception, developed for civilian use, unless you were talking about field artillery, heavier weapons that are specifically for a more military use.
The military use technology you just referenced, were those handheld firearms?
I was thinking more of cannons and mortars, although I should say that at the founding, many, if not most of the cannons that were being used by the colonial forces were privately owned. So they, even those were designed and being built by gentlemen like Patrick Henry for private customers and private ownership.
Would you agree that firearm developers pre-1859 were trying to develop firearms capable of holding more rounds than their predecessors for civilian use?
Certainly.
No further questions.
I think some of that would be on the scope of your cross-examination. I'd allow you to follow up on that if you wish to.
We have no further questions.
Okay. Thank you. Is this witness released then?
Yes, Your Honor.
Okay. Thank you, sir. You're released from further testimony. Okay. What's the plaintiff's next witness?
Your Honor, plaintiffs do not have a next witness, so it would be.
Pursuant to what we discussed in chambers, I'm going to admit your declaration along with exhibits 1 through 12 for the court's consideration in on this preliminary matter. So are you resting then?
Until closing, Your Honor, yes.
Okay. All right. 17 minutes isn't a lot of time to get going. Did you want to have till after we come back?
I think that's fair, Your Honor.
All right. So the court has hearings at 1 and 1:15, which means I'd like everybody back in the courtroom no later than 1:20, because I don't have the 1:15 should be very, very short. And if it's not, there's going to be questions about why it isn't short. So if we can be back in the courtroom at 1:20, I would appreciate that. And we'll get started with the defendant's case at that time, unless there's anything else before we take the break.
No, Your Honor.
All right. You folks are welcome to come back this direction, and we'll go off the record until 1:20. Thank you. Sheriff, you have a moment. Okay, Robbie, make sure they get out the pulse. Thank you.
So, sounds like we're going to be taking a break until 1:20 on this case. So, y'all are more than welcome to stay. I'm going to hopefully pull up a couple of these firearms that we've thrown out in the chat, and we can look at some of them. So the first one I think I'm going to pull up is the rifle from 1779. So I'm gonna stop screen sharing that. Pull up. So this is a Giradani wind gun. It's an air rifle. So looks pretty fucking interesting. You got a repeating. So not exactly sure what this ball is, but yeah, that's says 700 to 950 feet per second velocity, deadly at a range of 125 yards, delivers 30 shots at high power on a single reservoir. Tubular magazine carries 20 .46 caliber balls, capable impact to a 45 ACP. So, yeah, that's pretty damn interesting rifle. And thank you, OR3 Gun Gaming. Sorry, for bringing this to my attention, because holy crap. So, we'll stop that. We'll go back and we'll pull up the Joseph. I'm not going to try pronouncing that last name because it looks like it's French or something. Oh, wow, that is just I mean, look at this damn thing. How the hell would you even go about reloading it? I mean, wow. And just I mean, some of these look like now they're starting to get into. I mean, look, you got all these different 3 barrels. I mean, some of this is some, kind of crazy looking firearms. If anyone tried to introduce something like these today, they'd probably be laughed out of existence, So, yeah. Huh. Yeah. Yeah, that was kind of cool to find out that Lewis and Clark carried an air rifle. Here I thought the entire time that it was like a flintlock or, something like that. Because they never really in history, in school, like dove deep into the exact firearms that were used. You got to. Yeah, maybe I do underestimate the appeal of steampunk to some people. So, um, yeah, I guess we'll keep this going. It's been already over 3 hours. I don't want to shut this down and then refire it back up. So if anyone wants to come on and we can talk about what we've heard until we get back from the break, or we might have some dead air, because I know the TRX representative who was testifying was doing a great job at holding his own and making sure that he didn't get off track, and didn't let the state attorney get him from being able to testify to what he knows. And he was definitely able to make sure to keep explaining that, hey, one person may be able to reload in seconds, while it may take somebody else minutes. Again, it comes down to if you're practicing with a firearm you own, and you're working on your reload drills and everything, and somebody has the same exact firearm, and they just are like, whatever, I don't really care. When it comes down to in a life or death situation and you need to reload, you're going to be able to be a lot faster reloading than the guy who doesn't really practice it. So definitely you want to be able to practice and make sure that you're proficient with your firearms. And you want to definitely, the first guy was talking about, you've got to make sure you clean your magazines every once in a while. I don't know if I would say clean them every other time that you go out shooting. It really depends upon how many rounds you're going to be putting through your magazines, how you take care of your firearms and your magazines. I've put over 500 rounds through a magazine and didn't clean it. And then I have where I've put 20 rounds through a magazine and cleaned it. So definitely yes, Cobalt, it does seem that we're winning. The judge has ruled on most of 114 right now, that the stay is going to stay in place until December 23rd. And we're listening now to the magazine ban portion of the court case, and if he's going to keep that stay in place until the next court hearing, which will be December 23rd at 10 a.m. And if I'm free, I will definitely be live streaming that. So I definitely hope that everybody who's been in here will be back to listen in on that court case also, because it will. It's gonna, we're just trying to keep pushing this down and showing how moronic the state is, and how unconstitutional all of this truly is. So, oh yeah, you're very welcome, OGR3. I really do like diving deep into this, and I definitely more of the 2A side of what I do for my channel. I'm not a big going out and doing a lot of gun review videos, because there's a billion people out there doing that. I'm not saying I'm not going to review firearms. I'm not saying I'm not going to, show firearms, but that's probably the smallest percentage of what my channel is about. I really like diving into the court side of it, and I live streamed the Supreme Court case on New York Pistol and Rifle v. Bruin. And so, yeah, this is the kind of stuff I like to bring for you guys, so you can hear what's going on. Be aware of what's going on with people trying to attack your rights. And so if the people that are in like Illinois, Michigan, and some of these other states that are facing the same or worse that we're facing out here, they can be like, hey, here's all this video over here. Why don't go see what they did right, what they did wrong? How can we go about fighting and winning and making sure we keep our rights available? Hey, yep, it will be G23 on 23. So, oh, absolutely, they completely overplayed their hand. They went in thinking that they were playing gin, and found out they were playing Texas Hold'em, and tried bluffing their way. And we can see the judge isn't buying half of the stuff that they're trying to throw against the wall. And OGR says, I'm honestly surprised the major hasn't been shot down already, considering current case precedent in other states. Yeah, Yeah, I've heard Michigan introduced an AWB. I don't know if it's going to go anywhere or not, but it's definitely something that we need to be paying attention to. And Cobalt says, ever since the New York Pistol and Rifle case, the GC side has been using increasingly desperate tactics. It means we're winning on the whole level theoretically, most gun laws will fall if challenged, including the NFA. Yeah. But before the NFA can ever fall, there's a couple other things that have to fall before that. So, yeah. Hell yeah, that would be cool, Smeggy. Exactly. It's what happens when the defense decides to eat the checkers while everyone else is playing chess. Yep. Listening to the state attorney or the attorney representing the state of Oregon or the attorney general's office, there's been multiple times where you hear him getting flustered, and he's trying to force the statements or the testimony in a certain direction, and he just can't get the people to bite. He tried it with the gun owner or the gun shop owner, and he tried it again with T-Rex Arms, and neither of them bit on it, and you could hear his deep sighs, like just getting irritated that he can't force them to say what he wants them to say so that he can, get his way with the courts. Thank you, Cobalt, and we'll see you back. Yeah, the court is going to be out until 1:20 p.m. Pacific Standard Time. So that's 4:20 on the East Coast if you're keeping track on that. And so, yeah, this has been pretty interesting, and I don't know how much longer once they get back they're going to keep going. I do know that they talked about closing, but so they could come back at 1:20 and we could be done by 2:00. They could come back at 1:20 and we could be done at 5:00. So I hope everyone's definitely ready to hear the state's true feelings on all of this, because I think they're going to, throw shit against the wall and see what sticks. I don't honestly see how they can provide anything in closing that's going to show that any part, not a single piece of 114, is constitutional. And so I don't see how they're going to provide anything that's going to sway the judge's opinion and keep him ruling anything, but the stay is in place until December 23rd. And so, and he could rule, that it's a partial stay on what he's already ruled, and then he could take and say, you know what, the magazine, because they're separating the issues. So he could then turn around and say, you know what, the stay on the 10-round mag ban is permanent until the case is completely heard. So we could get a split ruling on how he wants to do it. I'm not going to attempt to read tea leaves because I'm definitely not psychic. And I would hate to say, oh yeah, this is exactly how he's gonna rule, and then he comes out and rules something, different, and then I'm like, oh well, don't I look like a dumbass? Yeah, so if you have Instagram, definitely go out and follow T-Rex Arms and thank them. Say, hey, thank you for, testifying and trying to protect our constitutional rights. And if you're looking at buying, whatever they're selling, it may be worth a couple extra dollars throwing their way, because you can see they're in the fight to protect our rights, where there's other companies that may not be so willing to go and testify in court because they don't want to hurt their bottom line. So, risk to reward. Sometimes the ROI, your return on investment, you're investing your time to testify in court. You're investing your reputation with your company to do this. And so, yeah, I know I'll be looking a little more at them to see, what they have that I may want in the future, and if it comes down to I can get it at T-Rex and it's, $2 more than I can get it at, Joe Blow Tactical, I'm going to spend the $2 more and get it at T-Rex, just because they're the ones out there sticking their neck on the line. So that's the way I personally do it. I'm willing to, yes, Chris, the guy who does the videos on YouTube for T-Rex Arms was testifying right before we went to break. About 20 minutes ago, we went to break. And I would definitely, I'm going to try to go back and put timestamps in, so people that want to jump through this boring section of just hearing me ramble, they can skip forward and just hear what the actual courts are saying. Yeah, and they like I said, they were, the guy was testifying, and damn, I'm telling you one thing, Chris, when you got a few extra minutes, I'd go to the point in the video where T-Rex starts testifying and listen to that whole entire section. It's probably about an hour long, and just completely mind-blowing how well he was able to give history and pretty much tell the state attorney that he's a moron, without completely, just coming right out and saying, hey, you're a moron. It was pretty cool. So, yeah. No. So, the hearing is not over. We are in lunch break until 1:20 p.m. Pacific Standard Time, which then they'll come back and have more of the hearing and closing arguments. So that's what we're waiting on. I have it in the background, and I may have to. So I'll reopen it probably about 1 o'clock, and yeah, we're about an hour till they'll be back, and we'll hear what they have to say. Yeah, go ahead. Definitely, I would say rewind and listen, because that's probably so far the T-Rex testimony is like the best part of this hearing so far. Yeah, you're talking it passed by 0.6%, which equated to right about 25,000 votes. It's a little shy of 25,000 votes, but yeah. So, and the fact is the Oregon elections haven't even been certified yet. I don't believe they're scheduled to be certified until December 15th. So they're not even scheduled to go and be certified till like Thursday. And yet they're putting this ballot measure in effect before the elections are certified, that they've actually, finished everything. And I'm pretty sure that violates some laws also, because this isn't even supposed to go into effect till 30 days after ballot certification. And so if you went 30 days after that, it would be 30 days from December 15th. So you're talking right around January 13th, roughly, that you could then say that it would be able to go into effect. Yep, because law cannot precede passage. But yeah, so when the judges and stuff actually start looking into this and start truly paying attention, and if it's being argued in front of them, there's no way that any of this can stand. So, if I was the GOA attorney, I would definitely be saying, hey, this isn't even certified yet. But here we're already talking about the implementation of it, and the fact that it's already allegedly supposed to have gone into effect. If it wasn't for your temporary stay, they would have already been, arresting people for having more than 10-round mags that are illegal in the state of Oregon, according to this. So yeah, there's definitely going to be able to be proof of irreparable harm, because how many people are going to end up criminals because of this? Because truly, there's no grandfather to this. There's affirmative defense, which states, that you owned this prior to 114 going into effect, and that you are using it, based upon it being in your home. You knew it was a violation of the law, but, hey, it's still legal on these certain grounds. So that's definitely something that you're going to have to question, because if you accidentally, step off your property, because you go out to your car and start warming it up, and then all of a sudden, somebody tries carjacking you, and, you step on the wrong side of the driveway, and now you're accidentally stepping on your neighbor's property. That affirmative defense does not apply because you're not on your own property. So there's lots of things that are going to go sideways if they allow this to keep continuing. Yes. Yeah, this is, it's not just us. Yes, this truly affects us that live here in the state of Oregon and us Oregonians. But this also affects other states, because if we can defeat this and show how unconstitutional this is, then it will help Washington State with their 10-round mag ban, which hopefully right around the same time, right around December 23rd, they should be getting a ruling out of Yakima County on if they're going to get a temporary relief from their 10-round mag ban. The thing is their 10-round mag ban has a grandfather clause, which still allows them to possess and carry, where Oregon's violates all of that. I mean, you can't legally possess them. You can't sell them. You can't trade them. You cannot even ship them. So, yeah, the only alleged grandfather clause that was granted was for FFLs. They had 90 days, 90 or 180 days to get any alleged high-capacity magazine, so anything that holds more than 10 rounds or can be easily or readily converted to accept more than 10 rounds out of the state of Oregon. So that includes shotguns. That includes, your semi-auto rifles, your bolt-action rifles, your pistols. I mean, that includes any magazine that could be taken apart to be cleaned. Cannot be in the state of Oregon. The only way that you'd be able to keep a magazine that accepts more than 10 rounds is to be able to pin it at 10 rounds and permanently modify it. It means you'd have to weld it to only be able to accept 10 rounds. And at that point, how are you going to clean it? So, yeah. Well, so, and another part of this is here they're allegedly attempting to implement this as of December 8th. That's when they wanted to put this in place. Yet, the state House and Senate aren't even back into session till after January. So how are they going to be able to define their portion of this and implement funding? So they can't even set in guidelines. They can't do any of that until after they go back into session. And then at that point, they're going to have have a bill introduced. It's going to have to go through committees and then hit the floor, be discussed on the floor, and then be voted on, and then go to the other, if the House votes on it, it's going to have to then go to the Senate. If the Senate, does any changes, it's going to have to go back to the House. We're talking, this could easily be another 6 months to a year before all of that's gone through. And at that point, what are we supposed to be just sitting here waiting, going, okay, well, maybe there'll be a gun shop around in 3 years that I can go buy a firearm from? Maybe. Who knows? And so, yeah, there's a lot of FFLs that are going to go under because they're even if they're still selling accessories and stuff like that, there's not going to be as many sales to keep them open while they wait to find out when or if they'll ever be able to sell a firearm again. So, Mr. Derek LeBlanc is in the house. Thank you. If you guys don't know about Kids Safe, I did a live stream with Mr. LeBlanc, and we discussed it. This is a Oregon foundation. I believe it's a 501c3 out of the Eugene area, and he does amazing work educating kids on firearms. So I would definitely say go check out his website. And yeah, hopefully, I don't know if they're going to be, I don't know if they're going to be testifying or not. It'd be awesome. Let's see if I can. Oh, I screwed up and put a. Works if you pay attention. So there is a link to their website. Well, see, and yes, you could theoretically 3D print stuff. I would definitely say pay attention to the laws in your state, and remember that Oregon did away with state preemption, and so each city, county, and town can theoretically make up their own laws. Um, so they can go stricter than what the state says. You are definitely welcome. Yeah, we've got right about a little under an hour till the court goes back in. See, and the thing is I understand why some people say, "Yeah, I'm gonna leave if this law goes into effect," you know. But the thing is if everyone in every state that has unfavorable laws leaves, who's going to stay there to fight and help change, and make sure that these don't go to the next state? Because Oregon used to be free, and so did Washington. They were a lot freer than what they are. And so you've got people that have fled from California who've now moved into Oregon, Washington, because they were fleeing from taxes. They were fleeing from gun laws and stuff like that. And all of a sudden, now we're getting more and more anti 2As. So, and, people fleeing over into Texas. Yeah, Texas is right now a free state. But at what point does the influence then start changing? So, yep. So, thank you, Smeggy, for throwing out the T-Rex starts at 1 hour 50 minutes in. I'm going to screenshot that so that when I go in and edit, I can add that in there. Yeah. So I know where you're coming from, and I am in what you would call the western part of Oregon, but I'm in the southwest. And I'm south of Eugene. So yeah, 99% of Oregon is people that just want to be left alone. Let me have my stuff and you have your stuff, and if we disagree, so be it. You do you, and I'll do me, and that's the way we want to be. And we are completely controlled by Multnomah, Washington. Then we've got Lane and like Lincoln County, that are all farther leaning the opposite, where it's my way or they don't even care if it's the highway. It's my way, or we want to see you in prison for the rest of your life. That's how their mentality seems to be. There are, again, we generalize a lot, and there are people inside those counties that feel like us. And I mean, yeah, they're definitely the minority. You look at what happened the last couple of years in Portland. And you realize, why would they then go and support something that completely, will limit what they can do to protect themselves and their family? The thing is a lot of them are indoctrinated via media, schooling, and stuff, and they're led to believe that the government is going to take care of them. Yet they're also the same ones who are out there screaming, defund the police. Well, if you're going to defund the police and you're going to do away with the law enforcement, who's going to protect you? You're asking the government to protect you, but yet you're taking away your protection. Are you hoping that the military is going to come in and protect you? I don't know. I don't understand that. I've tried to figure out what their thinking is and stuff. I cannot fathom being at that point where I'm like, hey, I don't want my rights, and I don't want anyone else to have their rights, and I want the government to take care of me, but I don't want cops. I don't want to work either, but I still want you to give me money. I don't understand that. So yeah, there's definitely, I don't know how to put it, a lot of mental disorder that's happening, and it's going undiagnosed and going untreated, and that's where a lot of our problems in our society is right now. They're not being taught consequences, that every one of your actions has a consequence. May it be a good consequence or a bad consequence, it still has a consequence. Yeah. Yeah, I mean, yeah, you can't really negotiate with the cult mentality, but there are ways to present your argument without them feeling that they're being attacked. I know some people that were complete anti, they didn't think that any person should own a firearm, and now they're like, well, I may not want to ever own a firearm, but I understand why you feel the necessary of being able to have that right to own a firearm. Yeah, absolutely, Burnaby. there's times where you just got to draw the line in the sand and say, you know what? I'm not giving up. I'm not giving another inch. I'm done giving up. So we're going to stand. We're going to fight. And it doesn't have to be a physical fight. I'm not saying we need to go and be violent. You know, fighting can happen in the court system. I'd like to say it could happen in the ballot system, but we've been seeing how that works. Yeah, and yeah, that's what I'm saying is that, you know, I did say that we've been generalizing a lot, you know, just like lumping everybody. And there are people that live in, you know, we like to call it behind enemy lines. And the thing is we need to have, you know, figure out a way that we can help you guys be able to help fight from within the enemy lines. So you can actually kind of be like that cancerous, unremovable tumor that keeps growing and showing people that they really truly need to understand what their rights are there for. If everyone, you know, keeps getting beaten down saying, oh yeah, you know, you're the problem, well, just because, you know, a large proportion of your area, that your county, your city is one way, doesn't mean that you fall in that way. And I would definitely love to figure out how we could, you know, make it so that the people that are, you know, in Portland or in that area that are, you know, the constitutionalists, you know, they want to stand and protect their rights, how we could help them be able to do that more effectively. So and there, you know, it may have to be like a ballot measure that we go with. I don't know exactly how we could go about doing it. I can throw the idea out there of we need to remove the qualified immunity for the senators, the House representatives, the governor, all of them. If they feel the pressure that if I do something unconstitutional, I'm going to lose my job, I'm going to end up in jail, I am going to end up having to pay this money out of my pocket, not out of the taxpayer's pocket, things will change. And I think that's probably the only way we can really start holding the elected officials, the ones that are supposed to be representing us, and say, you know what, we're going to hold your feet to the fire. You're going to uphold your oath that you swear to protect the Constitution of the state and of the United States. So, I wish we had people that were a hell of a lot smarter on the political side here that could, you know, say, hey, this is how we can go about doing this. And maybe people will watch this and, you know, review and go, you know what, I know how to do this. and they can grab that torch and run with it. Or they say, you know what, we know how to, we know what we can do to kind of help change. And so that's what we need to do, is start, reaching out to our elected officials that we know feel the same way we do, and say, hey, what can we do to help you, do this kind of stuff? And if enough of us reach out and enough of us start putting our own county representatives, our own city council feet to the fire, they're going to have to start changing. And when they realize that, there's a lot more of us that are out there that aren't, we're not the loud, outgoing, there's a reason why we're called the silent majority. A lot of us, are like, you know what, I'm not going to really go out there. I'm not going to yell and scream, and I'm not going to, hold signs. I'm not going to show up to rallies. I'm not going to do all this other stuff, but I'm just going to wait, and I'm going to, do all my stuff through the ballot box. Yeah, that's a great thing, but they're not hearing us. So they think it's okay to go ahead and do that. And if we don't agree with it, we'll go ahead and we'll take care of that later. They need to start hearing from us, because people like Moms Demand Action, Every Town, and those antis are screaming. They're at their, representative's office, yelling, screaming, whatever they have to do to get their way. That's what they're doing. And if some of these representatives just knew, you got a lot more people backing you, stand your ground, and, we're going to be here for you, they're more apt to tell those other people that are willing to, stomp on your rights, that are willing to, let somebody else, rape and murder your family. They'll tell them, you know what? No, we're not going to do it your way. Screw you. We have our own people we're protecting. Yeah. There is the Greater Idaho movement, and everything is just like, we had the state of Jefferson movement. I don't know that it's going to go anywhere, because here's the thing is, even if we, the people, vote and say, you know what, we're done with this, we want to be, the state of Jefferson, we want to be the state of, the greater state of Idaho, it still has to be ratified by Oregon and Idaho if we're going to join, if we would to join them. If we form our own state, then it would, like, if it's just Oregon splitting, hey, we're splitting, then it's going to have to go through the Congress, and they're going to have to say, yeah, we're going to take on a 51st state, and we are going to grant statehood. So I would love to see us be able to have great representation. Unfortunately, the only way we're going to do that is by changing Salem. Truly, we can't keep letting the status quo be the status quo. We had in November, we had the greatest chance to flip the state red, and yet we split the votes. Truly, we had 3 Democrats running. We had the socialistic Democrat who won. We had the moderate Democrat and Betsy Johnson. And then, well, we had the rhino of Christine Drazen. And the thing is even the people that voted for Betsy Johnson knew she had very slim chance of winning. And yet they pretty much just threw their vote away, saying, yeah, well, so we split the votes between Betsy Johnson, who truly, looking at her voting record, was way more 2A than Christine Drazen could ever dream about being. Yeah, I mean, if Oregon would just split, they would lose so much tax dollars. Because you come into, like in my area where you got a bunch of logging. So if that would to leave, they're going to lose all that logging revenue. You've got all your farms and other great businesses that are over in the eastern part of Oregon. You lose a lot of tourist money because of Klamath Falls, Crater Lake, and places like that, which would be more of your rural area that would then be going to greater Idaho or to the state of Jefferson or whatever it would happen. And they're not going to give up. They're not going to give up that tax dollar. They're definitely tax and spend happy. We could tax the crap out of these people, and there's virtually nothing they can do except leave. And I don't see that happening. Truly, I cannot see that happening. So. Okay, sorry for the dead air. I had to get something to drink. Wet the whistle. Yeah, Yes and no, I think, because I mean, you've got a lot of the breweries, your microbreweries and everything. Um, even Bend is going, going the other way. Um, but you got what Deschutes Brewery down in Bend, and you've got Full Sail Brewery over in Hood River. The, you got Fat Tire that are, I think Fat Tire is actually out of in um, the Portland area, but I do know they have um, a brew house down in Hood River, or they at least they used to. Um, you talk about um, like Hood River would be part of what would leave, and Hood River's got is the windsurfing capital of the world, which holds what's it in the end of July, beginning of August. They hold the windsurfing um, like championship there. ESPN is always there, um, which brings in a lot of money. Um, but yeah, I mean, at an overall, the rule probably doesn't bring anywhere near as your metropolitan areas like Portland, Salem, Tigard um, bring in. Um, you know, so but and that is their larger tax basis. Is the those areas because there's a lot more people that live there. Um, so of course, with more residents, they're going to have an overall possibility of a higher tax revenue. But if you were to break it down, um, how many of those people in the Portland area are hardworking every day? Yeah, there's a large majority of them, but there's also a large majority of drain that's coming out of there. I guess that would be something to deep dive into and see um, where the greatest tax revenue is um, coming from. So I'm going to try to relog back in because I want everything working when they go back live, because that's only about roughly 25 minutes away. Um, and I know sometimes this can take, 10 minutes to finally decide to have any kind of audio. So I want to be as ready as I can be. Hopefully we don't have as much audio issues as we had in the first part. What's going on, Smeggy?
Hey, how's it going? Thanks for having me back.
You are welcome. We're right about 23 minutes before we go back into the courtroom. So, how's the doggy doing?
He's doing okay, but he's a little distressed by the state defense attorney. He growls every time the guy talks.
Good dog.
Yeah, I taught him well. So I wanted to mention a couple things. I kind of said it out in the side chat there, but just for audio purposes, definitely for anyone listening to this, go check out the T-Rex arms and, go give them a thumbs up. Tell them that, you liked what you heard type of thing. That's what I did. I had never heard of them before. So I found them on Instagram. I sent him a message that, hey, I just listened to your dude talk on the Oregon hearing and he did an amazing job. And I've never heard of your company before, but I'm going to check your products out from now on. Like, just let them know, like, they may have gained a customer. I honestly don't know if they sell anything that I want, but I'll go look. Sounds like it's like holsters and slings and things is their main stuff. I don't really have a need for right now, but either way, just giving support, I think, will encourage. And then, they're going to talk to like their other manufacturing friends or whatever. And they'll say, dude, we got an increase in sales of 200% the day after the hearing. This is a way to drive business. And so maybe some of these other companies that aren't politically motivated, maybe they're capitalistically motivated, and we can get some of the big hitters on our side as well. Like, I'd love to hear Glock at this hearing or something say, you guys are crazy. Some big company, Smith & Wesson. Well, that'd be amazing if they represented. I don't think they ever will, but it'd be kind of cool if they did.
Well, I know right now Glock is in a big, huge fight over in New York. And that's what a lot of people aren't talking about. Like when Smith & Wesson put out that letter, the letter was great. But Glock's in a huge lawsuit over in New York.
But is that, I'm not from that's the first I've heard of it. Is that like a lawsuit involving them? Like someone is suing them personally, or they're suing someone personally? Or are they in it as a witness, as just a third party, like jumping in on someone else's case?
So, they're in it like in a couple different matters. They're being sued over that shooting that happened in Buffalo, because allegedly he had a Glock pistol on him, even though he never used it. It was there. And they're being sued by another person because their firearm was used in the commission of a crime. And so New York allows this, and they're trying to use the Remington case with the Bushmaster as, hey, this is the reason why you should, allow this case to go forward.
Such a dirty tactic. Hey, we sued you even though we're not allowed to sue you, but you settled just so that we'll go away because financially it's just easier to just settle. Therefore, our case is valid and we're allowed to do whatever we want. We're going to sue a bunch of other people. Mm-hmm. That's basically what they say. And also, I guess that's an example though. Glock, yeah, they're in a lawsuit. That's because they were forced to, because they have to. It's not like they said, oh, look at this law that is infringing on people's rights. I'm going to jump in on it. Which is kind of what the T-Rex dude did. He sounded like he barely even sells magazines. They said, well, we sell a couple. So he really doesn't have a dog in the fight other than the Second Amendment right. So that's the type of mentality I like to encourage.
Hell yeah. That's why I was definitely saying, go give him a follow on IG. Follow him on Facebook.
But also tell them why you're following, because then they might just think, oh, we had a good day, but the algorithm must like us. No, not the algorithm. G23's viewers like you because of what you said and what you did.
Hey, we're here because you stuck your neck out and are trying to help, the Second Amendment community, the firearm community. That's why we're here. That's why we're, buying your products. Um, and yeah, when this is all over, I'm gonna be looking at what they offer, um, and if there's something I need, and they have it, I'm more likely than not gonna order from them over, like what I was saying earlier, ordering from like Joe Blow Tactical.
Yeah, and then the other part of it. Well, actually, I guess I have a couple more, but one of the things kind of going along with that is, and I don't know how to do this, but I would really like to encourage companies to, in states where there is some kind of restriction, like a 114 or California, New York, like any of the other 10-round mag bans and all that stuff. I'd like companies not to sell to the police force and be like, you have to follow the same rules your citizens follow. And so that's the one thing with 114. If I can say there's a bright side, it's that the cops are not exempt. Just because that's always been a sticking point for myself. Is that how come you guys can do whatever you want, but the other citizens? Because cops are also civilians. Like I hate that cops versus civilian thing. No, they are not military. They're civilians. They happen to be law enforcement civilians, but they don't get special treatment. So I do kind of like that they didn't give special treatment, because maybe the cops will actually fight for us, like on our side, instead of against, which is what they normally do, because they normally are pro gun control. At least like city cops or whatever. Maybe sheriffs normally are more to a, generally speaking. But I just say that's a bright side. I kind of like that hopefully it wakes them up and maybe they'll actually help people instead of being like, well, I got mine, so I don't really care if we ban it for you.
Yep. I'm going to step away for a couple minutes. I got to go drain the radiator. I've been on this for almost 4.5 hours.
Yeah, copy that. I'll try and pull up the chat site, see if I can talk to people out here so it's not just completely wasted air. It's a little tricky on my phone. Let's see. Comments. Let's go back to where I left off. Okay, you guys are all talking like rural versus city and all that stuff. Oh, there was one other thing that I wanted to talk about with the T-Rex guy. When the defense jumped in and was saying like, well, hypothetically speaking, is it possible that, none of these, I forget what it was, one of the rifles or one of the handguns or whatever, that none of them were sold to Oregon ever, blah, blah, blah. And then the dude comes back like, I mean, I doubt it, but, I guess theoretically it's possible, but like, common sense would say that someone would have bought this rifle that lived in Oregon. And then he's like, well, can you prove that? Do you have evidence of that? It's like, wait a minute, dude. You're the one that brought up this hypothetical. Like, I did not come prepared with evidence that somebody bought a specific type of rifle back in 1853. And the thing is, it probably is evidence out there somewhere. You just have to dig through. There's probably some journal entry or whatever in a museum that says something about, oh, went out hunting today and took my sharps with me. Well, boom, there's your evidence. But like, I think his answer was pretty good. I find it, I can't exact words, but he's like, I find it highly unlikely that none of them were sold to Oregon. And then the other part of that is, let's say it's true. Like, I don't know, like he was saying, I don't know, there's 100 people in the state at the time or whatever. It sounded like it's back when there wasn't many people out this way. So if that's the case, so what? Like, kind of the whole point is that these firearms, like, were in common use and were common knowledge, and that they're basically the same as today's firearms. Like, I think that's kind of the general thread that the prosecution was, is that the right word? Prosecution? But like the fight, yeah, I think so. Fighting against the 114. Like, that's the basic premise they were going for, was like these guns function about the same as they do nowadays. And this was even way back then when they, were writing the Second Amendment, or the state of Oregon was writing their constitution, because I think that's the whole point of fighting this in state court versus the federal case, which is also still ongoing. But the state case is like, this goes against the state constitution because they have a similar thing to the Second Amendment. And actually, most states do. And I would encourage you to look up your state and see if your state constitution has something that's similar to the Second Amendment. So I know Michigan does. I forget what number it is, like where it is in there and the exact wording, but it is something to the effect of, like, literally the right of the people or the residents of Michigan to, whatever. Shoot, I'm messing this all up. I'm trying to remember the exact wording. I'm not going to be able to, but it basically is like, the right of the people to keep and bear arms in order to protect themselves and the state of Michigan, like, shall not be infringed. It's something like that. So it's basically the Second Amendment at the state level, but a little better because it doesn't go with the whole, the militia and well-regulated, blah, blah, blah. It literally says the person, the individual has the right in order to protect themselves and to protect the state. So it's like, it's an individual right. It's about personal defense. It's about state defense. And it may even have said something in there about to protect from tyrannical governments. I don't remember that part, if it is or not. But anyways, most states have something like that. So we all know the Second Amendment, and some of the states literally just copy and paste that, and it'll be the exact same. And it'll be, Article 57-2, but it's basically just the Second Amendment repeated at the state level. Others of them twist it up and change it a little bit. And most of the time, the state levels that are changed are even more about the individual. Like, that's the only part they change, is to specifically say it's for the actual person. The right is the person. So anyway, that's just a little homework for everybody. Go check out your state, see what it is, and research a little bit into that. And I guess that must be a similar thing that Oregon, which is why this case is challenging at the state level, because they're saying, I don't care what the federal court says, like, this exact state, our constitution says you're not allowed to do this, and here's why.
Yeah, so so I am going to pull up Oregon's Constitution. You've got Article 1. See if I can find this. It's Article 1, Section 27. Which crap. It's not pulling it up.
I think it says specifically, in the year 2022, someone's going to try and pass 114, and that's not allowed. I think that's what the Constitution says. But I don't know. I guess as you're kind of looking for that or getting it to pull up or whatever, I do have a question, kind of like a point of order. And correct me if I'm wrong, but is today's argument basically just the magazine side of things, and it's like the actual fight for getting rid of it, or is this just the extending the injunction?
So, the judge already made his ruling on the first 12 parts of Major 114, where he's given the injunction held over till December 23rd. And
Okay,
so
is
now,
that for the permit stuff?
yeah, that's all the permit and everything else like that.
They're just kicking that can down the road for later. Okay.
Yep. And so, the injunction against that's going to stay in place. And so now they're arguing the magazine portion of it. So they're actually arguing this separate of, instead of saying, hey, we're going to argue the entire and whole, the judge has let it be broke down. And so
this is the
this is,
actual. I'm sorry. I'm just a little confused. Is this like the actual argument for the magazine ban injunction, or for just the ban itself? Like, if we win today, is the magazine part stripped out, or is it just if we win today, we'll argue about the magazine later?
So, it could happen either way. The judge could rule that, hey, you know what, this is clear violation, and so I'm going to throw that completely out. It will be thrown out of court, and the state loses. He can decide that he's going to only put a temporary until December 23rd, where he'll hear more arguments on it, or he can decide that there's going to be a permanent injunction against that until the entire case is settled. So that's what we're listening to right now, is the magazine portion on how he possibly could rule on this section of that part.
Okay, thank you for clarifying. I did kind of miss the first part, and I think that was when they were kind of going over like what parts were on the 23rd and what parts were today, and all that kind of stuff. So it sounds like worst case scenario for us from our point of view is like it gets kicked down the road a little bit later and we get to argue about it more. Best case, we win today and it doesn't exist anymore.
Yeah. And even if we win today, say he kicks that and says, you know what, this is unconstitutional, we know for a fact the state's going to then appeal that portion to the state.
Of course. Yeah, this is going to Supreme Court probably.
Yeah.
Years down the road fighting back and forth.
Now the thing is with California already having the AWB, the 10-round mag, and the a couple other cases that are sitting in front of the ninth, they could make it to the Supreme Court and be ruled on before this case ever even gets to the ninth. And then at that portion, it'd become a moot point, because we know that based on New York Pistol and Rifle v. Bruin, that the magazine restriction, the assault weapon ban, the roster, those are all unconstitutional. So all we're really doing is waiting. All we're waiting on is, the ninth to pull their head out of their ass and make their ruling so that it can make it to the Supreme Court.
Yeah, I think that the New York State Rifle and Pistol Association v. Bruin definitely makes the case that all that stuff is unconstitutional, but it has not made a judgment, made a decision that all of that stuff is unconstitutional. It just said when you're looking at this type of stuff, you have to use historical precedents and all that, which when you do that, our side wins. Mm-hmm. So I agree with you that all that stuff is unconstitutional. And I think that it will be found so. It's just that's not exactly what that case. Yeah. That's not the full outcome. The full outcome is may issue is unconstitutional. Yeah. That was the decision, and you need to look differently at these other cases.
Yeah, it said that you can only do a one-step test, which is text, history, and tradition, and not, any other part of it, which they've been,
not balancing of common good or whatever the heck they call that.
yeah. And so Oregon's Constitution says in Article 1, Section 27, right to bear arms, military subordinate to civilian power. The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civilian power. That's pretty fucking powerful.
Yeah, so that means it's an individual right to protect yourself and the state, and the military, like, screw you, you have to do what we say. You don't get to come in and boss us around. So yeah, that's a pretty powerful one. And under that, like, reading, I don't understand how at the state level even this could be constitutional. Yeah. Which we all already know that. It's just a matter of, I guess, getting judges to agree with us.
Yep. And, so, and I noticed that earlier in the arguing, the state brought up the federal case. The fact is the federal case is being argued under U.S. Constitution. Nowhere in the federal case, which is what the Oregon Firearm Federation is suing, and I think the Second Amendment Foundation and a couple others are also, that they are going after, the federal side. They're going after what the U.S. Constitution says, and nowhere in there are they quoting state constitution. So that's why this can be separate from the federal case, due to the fact that they're being argued differently. One's being argued at a state level, while one's being argued at a federal level. And so when he tried to say, well, Oregon law states, that they can't really be doing that we can't be doing this, and you don't have the power. Well, that other lawsuit actually has no binding over what this judge is doing and what this case is about, because this is over a state level issue, not a federal level issue. So he does have the ability. So
yeah, and we know why the defense was trying to do that, is the federal level is most likely going to come on the side of, anti-freedom, anti-rights. So that's why he wants, like, oh, we'll just let the federal judge say what we should do, because he thinks he's going to win at the federal level.
Yeah, absolutely. And if you look at what the federal judge in Portland ruled, you're like, wait a minute, do you even understand case law? Because the magazines fall under the Second Amendment. They are part of the Second Amendment. It's been ruled that way under McDonald and under Heller.
Right, and it's the first segment of today, at least on the magazine part of it, when that guy who owns the gun store was talking about magazines and whatnot. I think he made a pretty good point of basically, because of the Oregon's 114 and the part that says, may be readily converted, like, because of that, you're basically banning all magazines for all, common semi-automatic firearms. And we all know that, like, the firearm's useless if you don't have a magazine. And because of you could just take the base plate off, and then that counts as being readily convertible. It's like, I don't know. I really don't like laws that are, well, if you were to do this, then you're not allowed to have any of it. It's like, well, yeah, technically I could drive my car 200 miles an
But
hour.
just before we get started with anything
All
further,
right,
I just
well,
want
I'm
to go
gonna back
back
off
and make
again.
sure
Again,
the
thanks for
record
having
is
me.
clear
And maybe after the
with
whole thing's
regards to the
over,
temporary
if you're still
restraining
live,
order
I'll
and
jump
where
back
we're
in
at
again.
on sections 1
Oh yeah,
through 10.
we'll still be live a little bit after this is
I
over.
anticipate the state providing no later than Friday, and I'm going to say by noon, what specific areas you're asking for the court to remove the TRO on with regards to what I'll just call the Charleston, well, you know what I'm talking about.
We do.
The full criminal background checks, I think, related mostly to gun shows. I want you to identify where you think I should relieve the temporary restraining order. The remainder, with regards to the permits, I'm going to maintain until I hear from the state that they're prepared to move forward with a hearing on a preliminary injunction. I'm doing that because I, after 20 years of practice, know that there's a lot of instability in litigations, and I adopt the language of the plaintiffs that at any time the federal case could disappear, and then people's constitutional rights in Oregon could be unduly or irreparably harmed if they're not able to purchase a firearm. They're also, of course, separate litigants, and so each group has different litigants who have different interests. And so I'll leave that in place through the course of this litigation pursuant to ORCP 79A. And then on the hearing with regards to the 23rd, I'm going to have the hearing on the 23rd. I will issue a final opinion letter no less than 10 days after that hearing. So I will issue a letter no later than January 3rd, 2023 at by 5 o'clock. I'm doing that because I think the court needs to think about these things and make sure that I'm making the right decision based upon the law and the Constitution. So I just want to make sure we're all clear about what I'm doing so that we don't come back and have some haziness around it. Does this all make sense to you?
Yes, we understand the court's ruling, and with the friendly note that you provided earlier, just to make it complete in both records, the morning session and the afternoon session, this is an injunction of enforcement, not of the steps toward implementation,
Yes.
including issuing permits if the requirements are fulfilled.
Absolutely. If you're in a position to issue permits, issue permits. But I don't know that those, we'll deal with that question later.
Yes, we
I
understand
don't
your
want to
ruling.
speculate about where my mind might go with that. So you'll let us know what we're specifically talking about on the 23rd and related to the background check issue. That's how I understand it in my clearest language. Right?
We understand, Your Honor.
Okay.
Plaintiffs agree, Your Honor.
Okay. Just wanted to make sure it was clear. So let's go ahead and move on then with the defendant's response to the plaintiff's case.
Defendants call Jim Yergialitis, and he is on WebEx and should be on the participant's line.
All right, Mr. Yergialitis, will you please raise your right hand? And under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. If you'll state your name, please, and spell your last slowly for me.
Sure. James Yergalitis. The last name is spelled Y-U-R-G-E-A-L-I-T-I-S.
All right, your witness.
Good afternoon, Mr. Yergalitis. Could you tell the court what your present professional position is?
I'm currently self-employed as a consultant dealing primarily with governmental entities, private industry, and individuals in regard to the technical aspects or technical specifications of firearms and how those particular firearms related technical issues relate to application in either federal or state law.
Where did you go to college, sir?
St. John Fisher University in Rochester, New York.
And what is your degree?
I have a bachelor's degree in political science with a minor in psychology.
Could you describe for the court briefly your employment between college and your present position insofar as it relates to firearms?
Initially, after graduating with my bachelor's, I was employed by the diplomatic security service at the United States Department of State. I was there from 1986 until 1990. And following that, I moved to the Bureau of Alcohol, Tobacco, and Firearms, which was then under the U.S. Department of the Treasury from 1990 until 2013. I served in a number of capacities at DSS, at the Diplomatic Security Service. I was at the Washington Field Division initially, conducted investigations into passport and visa fraud, as well as working on numerous protection details for visiting foreign dignitaries and United States delegations that were traveling overseas that required services of the Diplomatic Security Service. And I also served 2 years full-time on the Secretary of State's protection detail from 1987 until 1989. While I was after I joined ATF, I was initially a field agent in the Baltimore Field Division, where I conducted investigations primarily for violations of federal firearms laws by multi-convicted felons in conjunction with other agencies that were part of the task forces that I belonged to. Subsequent to that, I was trained as what was known in ATF as a interstate nexus expert. In other words, we were a small cadre of agents were trained to be able to testify as expert witnesses regarding the origin, operability, and interstate commerce of firearms. I was a field agent until 2003, where I subsequently went to the ATF National Laboratory to run the National Firearms Examiner Academy, which is a apprentice program for state and local forensic firearm examiner trainees.
What law enforcement training on the technical aspects of firearms have you completed?
Well, other than every agent being familiar with the firearms that are issued to them or available to them in their individual agencies' service, when we were moved over to start a cadre of agents that were able to testify as expert witnesses in certain aspects of firearms, there was some initial training at ATF headquarters. There was additional field training where we visited numerous firearms and ammunition manufacturers in the United States. In addition to that, we were also taken over, we were allowed to go to a number of firearms and ammunition manufacturers in Europe and speak with their production personnel, their corporate historians, their engineering staff regarding what firearms were made where, so that we were able to testify to the origin, operability, and classification of those firearms.
And sir, have you also taught law enforcement yourself with respect to the technical aspects of firearms?
Yes, I have. I've instructed in the United States at the Federal Law Enforcement Training Center. I've instructed multiple sessions of firearms identification and federal firearms laws to numerous state and local police departments. And I've also instructed at the International Law Enforcement Academy in Budapest, Hungary.
You mentioned that you have toured firearm manufacturers. What are some of the firearm manufacturers that you have toured as part of your experience?
Well, domestically, Ruger, Pine Tree Castings, which is also the part of Ruger that manufactures their receivers and their rifle and shotgun receivers and pistol frames. I've been to OF Mossberg, Marlin Firearms, Remington, Bushmaster. In addition to those particular manufacturers overseas, we went to Sig Sauer in Germany. We went to Heckler and Koch in Germany. We also went to CZ, which is Česká Zbrojovka in the Czech Republic, FN Herstal in Belgium, and a few proof houses in Belgium and the rest of Europe as well. We also went to Glock in Austria, and as I stated before, a number of proof houses.
When you were going on these tours, you mentioned that you met with historians and engineers amongst others. Can you describe in a general way the content of some of those meetings?
Well, the content of the meetings were general introductions to the company's history, but in addition to that, tours of the factory in manufacturing facilities in terms of how their particular models were designed, assembled, produced, tested. So we had not only, a historical background, but almost a hands-on walk through a number of these factories, a number of which because I was affiliated later on with the National Firearms Examiner Academy and was running that training program. The students in that training program were taken on the same domestic factory tours that the agents had been on. So I was fortunate enough to go speak with production personnel and corporate historians on multiple visits to the factories and facilities in the United States.
Sir, have you also, in the course of your work with ATF, examined firearms?
Yes.
And how many firearms do you think in the course of your professional experience you've examined?
I would estimate conservatively over 5,000.
Sir, do you also keep abreast of the current market for firearms and firearm accessories?
Yes.
And can you tell the court how you do that?
Mostly through review of articles, periodicals. I have my own firearms book reference collection. I also attend trade shows. I have kept in contact with other experts that I've met through the course of not only my employment at ATF, but also my self-employment as a consultant after my government career. So it's a variety of sources that assist me and keep me informed about basically the developing trends in firearms in general.
Your Honor, at this time, defendants would move to certify Mr. Yurgalitis as an expert in the areas of the technical aspects of firearms and the commercial market for firearms.
No objection, Your Honor.
So noted.
Mr. Yurgolitis, could you describe in general terms what a magazine is?
A magazine is a ammunition feeding device or a ammunition reservoir for a firearm.
And are there both detachable and fixed magazines?
Yes.
This may be a silly question, but just for the record, what's the difference between a detachable and a fixed magazine?
One is integrated into the frame or receiver of the firearm. That would be a fixed magazine. And a detachable magazine is one which can be inserted and or removed from the frame or receiver of the firearm.
With respect to detachable magazines, what are the essential parts of a detachable magazine?
Well, they're also commonly referred to as a box magazine due to their shape. The portion of the magazine that holds the actual cartridges is referred to as the magazine body. There is a floor plate or base plate at the bottom of the magazine to provide a base for the magazine spring to force the ammunition upwards. So you have the body of the magazine, you have a base plate, you have the spring, and you have either a metal or plastic or other material or a follower made out of plastic, metal, or another material that the ammunition rests against and feeds the ammunition into the chamber due to the force of the magazine spring pressing against the base plate.
Can you purchase firearms in the United States today that come with magazines with a maximum capacity of 10 rounds?
Yes.
Can you provide some examples of firearms that you can purchase today that come with magazines with a maximum capacity of 10 rounds?
Well, due to magazine capacity restrictions in, I believe the total count is 12 states plus the District of Columbia. There are multiple manufacturers that supply or produce semi-automatic firearms that come with a magazine capacity of a maximum of 10 rounds. Sturm Ruger makes firearms. Smith & Wesson makes firearms with that capacity. Glock makes firearms with that capacity. Colt makes firearms with that capacity or less. Basically, every major firearm manufacturer that produces handguns in the United States and intends to market them in states where there are a magazine restriction, they offer models that are compliant in those particular states.
And do manufacturers also manufacture rifles that come with magazines with a maximum capacity of 10 rounds?
Yes.
I missed your last question. I was making a note somewhere else. Could you ask it again, please?
Of course. I asked if the manufacturers also make rifles that come with magazines with a maximum capacity of 10 rounds.
And I heard his answer was yes. Go ahead then.
Okay. Mr. Yurgolitis, what is a magazine extender?
Magazine extender or a magazine extension is a device that replaces the floor plate on a detachable magazine and is intended to provide additional magazine or additional ammunition capacity in that magazine.
Can you describe in a general way how an extender works in connecting with a magazine?
Well, it simply replaces the floor plate of the magazine and provides additional stowage space for ammunition inside the magazine. So they come in numerous multiple types for different models of magazines and in varying capacities.
Are there magazines with a maximum capacity of 10 rounds that are commercially available, but that will not take extenders?
Not, well, anything's possible in terms of modification, but there are really no manufacturer that currently makes a magazine where you cannot remove the floor plate and replace it with an extender.
So, Mr. Yurgalitis, are you aware that some magazines have an internal geometry known as single stack, and some magazines have an internal geometry known as double stack?
Yes, I mean, for instance, Glock makes a magazine where, although you could replace the floor plate with an extender, it would not be functional because the magazine has been modified to fit inside the grip of the firearm, but it has a reduced capacity. So it has taken a double stack magazine and made the walls thicker, basically, so that it cannot be modified. It will not accept a double stack extender on the bottom of the magazine, or it will not allow it to function.
So there are, if I understand you correctly, there are some single stack magazines that even if you could remove the base plate to attach an extender, adding an extender would not allow that magazine to function.
Correct.
And
you said some. I heard him talk about one design. Is there more than that on the market besides the one design that you talked about? The
Well,
one
Glock
production company, I guess I should say.
There are a number of manufacturers who make aftermarket magazines where they have modified the double stack magazine to a single stack.
Thank you. Go ahead, please, Mr. Wilson.
And I was going to ask a follow-up question about the Glock magazines that you were just discussing. Does Glock make a 10-round maximum capacity single stack magazine for some of their popular handgun models?
Yes.
And does that include models such as the Glock 19?
I believe so, yes.
Are you aware of any extenders that are available that would fit on a Glock 10-round maximum capacity factory magazine?
Not for a single stack model, no.
And have you looked for such extenders?
Yes, I have.
And you did not find any?
That's correct.
Mr. Yurgalitis, are large capacity magazines, and by that I mean as defined in Measure 114, magazines with a capacity of more than 10 rounds, generally used with semi-automatic firearms?
Generally, yes.
No further questions.
Good afternoon, Mr. Yurgalitis.
Hold on.
Oh, sorry.
I'll let you know when I'm ready for you to ask questions. Mr. Yurgalitis, it was brought to the court's attention that these magazines that have fixed base plates, floor plates, are subject to significantly more wear. In other words, they can't be readily cleaned the way that they can be when they have base plates, floor plates that can be removed. Do you agree with that? That they accumulate more gunk and such and become less useful over time?
Any magazine, if it possibly is, accumulates a large amount of junk in it, is possibly going to have a problem functioning.
And the typical cleaning way of doing that is to remove the base plate, floor plate, and clean the magazine through the entirety of the magazine. Is that a fair way to talk about it?
For a magazine with a removable floor plate, yes.
And that would be the typical method by which it's done currently for the majority of things on the record. I mean, in the market.
In general, yes. There are specific magazines that are not constructed in that fashion. However, that's a general way magazines have been constructed.
Thank you. Sorry. Go ahead, please.
Good afternoon, Mr. Yergolitis. Did I say that correctly?
It's close enough. Thank you.
In what state do you live in?
Maryland.
Do you have an FFL license?
No.
When was the last time you attempted to order a magazine that complies with Oregon's laws?
I have not personally, for my personal use.
For personal or for purposes of preparing for today's hearing?
I have not ordered a 10-round magazine.
So you wouldn't know whether those magazines are available to be shipped to the state of Oregon?
I have not had any shipped to the state of Oregon for me or by me.
Is there a way to modify a double stack magazine so that it becomes a single stack magazine with the wider walls as you described?
I'm certain if you had the talent or the acumen or the mechanical ability to do that could be done.
One would most likely have to send it back to the factory, correct?
I couldn't tell you.
Is that something that an ordinary person could do in their garage with tools?
Well, it all depends, sir, on what you mean by ordinary and what tools, et cetera. It's a rather open-ended question.
Let's say, how about a person who is not a gunsmith? Can someone who is not a gunsmith make such modifications to their magazine?
If they have the mechanical ability not necessarily related to working on a firearm itself, they may.
What kind of tools would they need?
I have not attempted to modify a magazine myself, sir, so I couldn't really tell you.
In your professional capacity while consulting with firearm manufacturers, have you ever asked that question?
Which question?
Whether or not a double stack magazine can be modified outside of a factory to comply with the 10 to make it so it can only accept 10 rounds.
I have not asked that specific question, no.
You testified that there are extensions for fixed magazines, correct?
I don't believe I testified to that. No, I'm speaking about detachable.
I'll ask you then, are there commercially available extensions for fixed magazines?
For shotguns, yes, for example.
Is there, are you aware of any way to modify a fixed magazine without sending it to the factory that would make it incapable of accepting an extension?
I'm sorry, could you repeat the question?
Yeah, are you aware of any commercially available way, aside from sending a magazine, a firearm back to the factory, to make it so that a fixed magazine cannot accept an extension?
It would depend on the type of modifications required and someone's particular skill level, or whether a gunsmith would be able to perform that kind of a function. So that's a possibility that that may be able to be done by a gunsmith, and there's also the potential that it might have to go back to the factory to be modified.
Do you know of any gunsmiths in the state of Oregon that perform that service?
I do not know any gunsmiths in the state of Oregon.
Have you attempted to purchase a California compliant firearm to have it delivered to the state of Oregon?
No.
So you don't know if if firearms complying with Oregon's law are available for purchase commercially?
Firearms, or there are a number of firearms for sale in California that are available for sale in Oregon.
They are. That your testimony is that those firearms are available for purchase in the state of Oregon?
The firearms themselves?
The California compliant firearms, your testimony is that those are available for sale in the state of Oregon, correct?
Well, I can give you an example. For instance, most 45 caliber or other caliber 1911 model semi-automatic pistols are available for sale in California and presumably for sale in Oregon as well.
Why would you presume that?
Due basically to the fact that they have a 7-round factory magazine capacity.
What about firearms such as, excuse me here. What about firearms such as the Beretta M9 California compliant semi-automatic pistol, 9mm Luger with a 4.9-inch barrel and a 10-round black magazine? Do you believe that firearm is available for purchase in Oregon?
And I'm going to object that this is calling for a legal conclusion.
I'm asking whether the firearm is available for purchase, not whether it's legal. I'm asking if it can be purchased and shipped to the state of Oregon. He has just testified that these firearms are available for purchase in Oregon, so I'm refuting that.
Well, sir, I believe I testified that
I'm gonna go ahead and make a ruling before you answer the question. You want to respond to that?
I think in that case, my objection would be that the question is ambiguous. From where, from whom? It's phrased in such a broad way as it's impossible to know who he is asking would sell or would not sell such a firearm into Oregon.
I would assume lawfully.
Lawfully, and if it's lawfully, then I think that calls for a legal conclusion.
Well, I think I'm going to overrule. I think the legality of sales of arms in Oregon has been a primary question here in terms of the understanding of these different folks around the federal firearms laws and Oregon's interface with it. So I'll overrule. Go ahead and answer the question, sir. If you
Sir,
still
can you
remember it, go ahead.
Well,
repeat it.
please.
Yes, my question is whether the Beretta M9 California compliant semi-automatic pistol, 9mm Luger with a 4.9-inch barrel and 10-round magazine in the color black is available for purchase in the state of Oregon.
I do not know.
Are you aware that Midway USA, are you familiar with Midway USA?
Yes,
Are you aware that Midway USA is informing FFL FFL licensed firearm dealers that Oregon has restricted the sale of magazines and therefore they cannot ship California compliant firearms to the state of Oregon?
that they cannot, Midway is informing FFLs that they can't ship the firearms, or they cannot ship the firearms without a magazine.
The question is, are you aware that Midway USA is informing FFLs that they cannot ship California compliant firearms or magazines to the state of Oregon because of ballot measure 114?
No, I'm not aware of that.
What approximately what percentage of firearm magazines are available as you described in the single stack variety so that they've been modified to not accept extensions or not function with an extension attached?
I couldn't give you a count.
Would you say
I mean,
most?
Most is a rather ambiguous term, so I couldn't. Your most may differ from my most. Your most may be 60%, might be 50.01%, but I do not have a precise number for you.
Wouldn't you agree that magazines that function as you have suggested are not common?
Well, can you define what you mean by common?
Are all Glock firearms able to accept a magazine that is single stack has been altered so that it cannot accept and function with an extension?
Any firearm that can accept a magazine of over 10 rounds is also capable of functioning with a magazine of 10 rounds or less.
Sir, I'm not asking about theoretically, I'm asking commercially available on the market today. I believe you've been qualified as an expert knowing what is commercially available on the market today. So my question is, do all Glock firearms accept a magazine that's been modified as you have described?
Do they all accept a magazine that's been converted from double stack to single stack?
Does the magazine exist for all Glock firearms that functions as you have described in the single stack variety?
Not all of them, no.
What about what about full size Sig Sauer firearms? Do they all full size pistols? Do they all have commercially available today magazines that function as you have described?
Objection to,
Hold on, there's an objection. Go ahead.
just to you, as you described, I'm getting lost into what falls in that category.
I think I would sustain that objection. I'd like you to ask the question with a little more clarity, please.
Do all full size Sig Sauer pistols accept magazines? Are there magazines commercially available for all Sig Sauer pistols that are of the single stack variety that have been modified so as they cannot accept an extension as you've described?
Can we break that question down into perhaps two separate questions, because you're kind of on a roll here and combining two at once. So if we could break that down a little bit, I would appreciate it.
You break it down. That's the judge speaking. You break it down into the two questions you think's being asked.
Well, are all all full-size Sig Sauer firearms, are there magazines available for them that are single stack? I am uncertain if there are magazines for that or by Sig Sauer that would be functioning in that fashion.
Is there another component to that answer based on the question?
Well, Your Honor, it was just a matter of trying to figure out which section of the question I was going to answer. So if there's a follow-up to that, I'd be.
Thank you. I just wanted to know. You go ahead, please, Mr. Aiello.
Are you aware of any firearm manufacturer that is selling magazines that they advertise as Oregon compliant?
I have not seen any ads specifically for quote unquote Oregon compliant magazines. So I'm unaware.
How would one modify a magazine? Are you familiar with how California magazines are modified to become California compliant?
There are a number of methods, yes.
What are those methods?
Some manufacturers have placed rivets into the magazine body to restrict the capacity. Others have placed plastic plugs in the bottom of the magazine or have a molded lower portion of the magazine that will not accept additional rounds of ammunition over 10.
Would you agree that the rivets you just described can be removed from the magazine?
That they can be removed?
Yes.
In general?
Yes.
Well, certainly.
How would one do that?
They could be drilled out or they could be pulled out.
Would you agree that that would restore the firearm to full capacity?
It may restore it to a larger capacity, but it may not necessarily be functional.
How do the plastic plugs that you just described differ from the rivets?
They're inserted in the magazine body as opposed to being put through the magazine body like a rivet or some other type of external blocking device would.
Are those capable of being removed as well?
Depending on the skill set of someone, I'm sure that it's possible, yes. But I couldn't tell you exactly how to do it.
Moving to the removable base plate, removing the base plate is part of cleaning the magazine, correct?
Yes.
The spring that you described in the magazine should be oiled to function correctly. Is that correct?
It is part of what one would consider maintaining your magazine or cleaning your magazine.
So if someone could not remove the base plate from their magazine, how would they oil the spring?
By injecting some oil into the magazine body from another aperture.
Would that be messy?
Messy is a relative term. So
would
it be oily?
The oil leak out of the firearm magazine when you are putting it down the top of the magazine.
Possibly.
Would you be concerned at all about dirt and grime pooling and combining with the oil at the base of the magazine?
I'm sorry, can you repeat that?
Yeah, if one cannot remove the base plate from the magazine, wouldn't the dirt and grime that is introduced to the firearm magazine stick to the oil and pool at the bottom of the magazine?
It may.
Without the ability to remove the base plate, wouldn't it be impossible to remove that grimy oil from the base of the magazine?
No, not necessarily. I suppose it can be blown out with compressed air, or you can put it in some cleaning fluid and there are a number of cleaners that are ultrasound cleaners that will clean out gunk, if you will, for lack of a more technical term, from the interior parts of firearms. And I presume that that can be used on a magazine as well.
Have you ever done that yourself?
Yes.
On a firearm magazine that base plate cannot be removed?
No, I have not used it on magazines. I've used it on firearms.
Okay, my question was about magazines. Would you be able to blow out the oil in the way described from a magazine? A detachable magazine?
If there was oil in a magazine and you use compressed air to blow into the magazine, presumably that would blow some of that oil out.
Would the accumulation of oil, dirt, grime, gunk, whatever we'd like to call it, at the bottom of the magazine shorten the magazine's life?
It may, it may not. It all depends on how the magazine's been used and taken care of, whether it's been cleaned before, maintained before, what kind of weather conditions it's used in. I mean, there's a number of variables other than accumulation of extra oil.
Firearm magazines should be maintained more frequently in a wet climate, correct?
I'm sorry, it should be maintained more frequently.
I'm sorry. Firearm magazines should be cleaned and oiled as you and I have been discussing more often in a wet climate to avoid rust, correct?
I'm sure that it would help.
No further questions.
Go ahead.
Sir, based on the testimony I just heard you provide, is it your professional opinion that it is possible to clean a magazine with a fixed base plate?
Yes.
Does the Glock manufacturer make models of handguns that are commercially popular?
Yes, they're very popular.
So, for example, the Glock 19 is a very popular handgun, correct?
It's one of them, yes.
And as we discussed during your direct testimony, the Glock factory magazines with a maximum capacity of 10 rounds are single stack, correct?
Yes.
You and Mr. Aiello just talked about California compliant magazines. And you described a couple of methods that manufacturers use to make California compliant magazines. Those were the insertion of rivets and a molding at the bottom. Is that right?
Yes.
With respect to the molding, Mr. Aiello asked if it would be possible to remove that molding. You said someone may be able to do it if they had the right tools. Is that right?
Yes.
Would that be something that you would consider to be easy to do?
It would be dependent upon your skill level in terms of modifying it, but it might be easier for some or more difficult for others.
Would an ordinary unskilled individual find it difficult to remove that molding?
You would need some skills certainly to do that. So if you were unskilled, that would likely be difficult or impossible.
And would you need some special or particular skills in order to understand how to remove rivets that block capacity above 10 rounds?
It would require some mechanical ability, certainly.
No further questions.
Thank you. Is this gentleman excused then?
He is.
Thank you, sir. You're excused from further testimony today.
Thank you, Your Honor.
Go ahead, please.
Your Honor, we have some housekeeping matters in terms of providing evidence to the court before we call our next witness, if this is an appropriate time.
Sure.
First, the parties would like to stipulate to the results of the U.S. Census for the population of the United States and the population of Oregon in 1850 and 1860, just for the court's reference.
Is that correct then?
Yes, Your
Do
Honor.
we have those numbers?
We do, and I can provide them now.
Okay.
In 1850, the population of the United States was 23,191,876.
You have to slow down. 23 million.
191,876.
Okay.
The population of the United States in 1860 was 31,443,321.
Okay.
The population of Oregon, according to the U.S. Census in 1850, was 13,294.
Okay.
And in 1860 was 52,465.
465. Primarily in Grant County because of the gold rush. But go ahead.
The second housekeeping matter is just to complete the record on the written testimony that has been provided. That on the defendant's side includes my declaration that was in support of our response to the temporary restraining order and its 8 exhibits, the declaration of Greg Scott filed yesterday afternoon and its 10 exhibits, and the declaration of Professor Brian DeLay.
Yes, I have those documents and they are admitted into the record.
And the defendant's
So yesterday we got 141 pages from you, along with your written response of 23 pages. And then I also received another 150 pages from the plaintiff, which is why all of you should know I'm taking this under advisement so I can make sure I understand the information contained with it before I make a final decision. But I understand I'm under a time constraint pursuant to ORC P79. I need to have an issued order no later than Friday, 5:00 p.m. to meet the 10-day requirement.
Your Honor, if I may, I do not think this objection will be necessary in light of the gentleman's name on the screen, but plaintiffs would object to the admission of Mr. DeLay's declaration and exhibits if he is not going to testify and be subject to cross-examination. It appears that he will, but if we can just verify that before admitting those.
Well, he will, but there also are a number of other declarations that have been submitted.
I'm not, yeah.
So I'm a little
I'm
confused
actually
by
gonna
that.
Well, I'm going to overrule the objection. This
Okay.
is a preliminary matter. The rules of evidence are relaxed substantially for that purpose. and I'm going to allow the declaration to come in. I think it would be useful for the defendants to at least present him so I can understand a little more carefully his conclusions.
The defendant's counsel agrees and would like to call Professor Brian DeLay to the stand.
All right.
He's available by WebEx.
Mr. DeLay, do you have a video? All right, thank you. Please raise your right hand. Under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can lower your hand. Please state your name for the record and spell your last.
My name is Brian DeLay, and my last name is spelled DELAY.
All right, go ahead, please.
Where are you joining us from?
I'm in my office in the Berkeley History Department in UC Berkeley.
Is that where you work?
Yeah.
What is your title?
I'm an associate professor of history, and I'm the Preston Hotchkiss Chair in the History of the United States.
Is that a tenured position?
It is.
In order to be promoted to a tenured position, did you have to have a record of scholarship?
I did.
And how was that record of scholarship evaluated?
Well, when I was going up for tenure, my entire scholarly record was put before colleagues here at the university who were already tenured, who formed a committee to evaluate it, wrote a report, and solicited the feedback of something like 9 or 10 external experts whose identity was hidden from me to evaluate my work candidly. And then those materials went before the entire department, who read them all and had a 2-hour meeting to discuss whether or not I deserved to be promoted and tenured. And then the results of that meeting were then conveyed to administration officials at the university, who convened 2 other committees to consider the matter before finally the chancellor, reviewing everything, approved my tenure and promotion.
Do you have a PhD?
I do.
In what discipline?
In history.
And when did you get a PhD in history?
I earned my PhD in 2004.
And have you been working as a historian since you received your PhD?
I have.
You attached your CV to your declaration. Is that CV a fair and accurate representation of your professional experience as a historian?
It is.
And within the discipline of history, do you have any particular areas of history that you focus your work on?
I'm a historian primarily of North America in the 18th and 19th centuries. And my areas of expertise within that include U.S. relationships with Latin America, Native American history, the era of the U.S.-Mexican War, and the era of the American Revolution.
Have you done any study that relates to firearms?
Yes, I have. Yeah. So for the past 12 or 13 years, that's been the primary focus of my scholarship, is the history of the international arms trade and the way that access to firearms shaped relations of power within what would become the United States and the broader Americas.
Did you draft some written testimony, a declaration in this case?
I did.
And do you stand by that testimony?
I do.
Is that declaration in front of you?
It is.
And anything else in front of you?
No.
The defendants submit that Professor DeLay is qualified under Rules of Evidence 702 as a historian.
I'm not sure what area they're qualifying Mr. Professor DeLay on, if it's just broadly.
History of firearms.
History of
based on
firearms.
his CV.
No objection.
I will. Yeah. All right.
Professor DeLay, did you observe testimony this morning?
I did.
do you agree that there were multi-shot weapons in existence in the 18th century and earlier?
I do.
Were any of those weapons commercially successful?
No.
Were any?
With one, pardon me, may I make one caveat?
Sure.
Double-barreled shotguns would have been commercially successful, but that's the only one that I can think of.
And tell me more about a double-barreled shotgun. What are its features and how did it operate?
Well, a double-barreled shotgun was, just as it sounds, a shotgun with two barrels that could be loaded with two different charges and two different bullets. And the shooter could fire one right after the other or both simultaneously.
Am I understanding correctly that that would be a capacity of 2 rounds?
Yes.
So for the 18th century and earlier, the only commercially successful firearm that had a capacity of more than 1 rounds was the double-barreled shotgun that only had 2-round capacity. Is that right?
Yes, it is.
Have you heard of a weapon called the Giradoni?
I have.
Do you agree that Lewis and Clark and their expedition carried a Giradoni?
Yes.
Were there any limitations to that weapon?
There were. So the Giradoni was probably the most advanced air rifle of the time, but it was onerous to prime. So the pump that came with it to produce the air pressure necessary to exert force had to be pumped something like 1,500 times. So it was not a simple process to prepare the gun for firing. The larger issues, however, had to do with the fact that the design depended upon precise tolerances that were not achievable with technology at the time. So the threading, for example, that connected the air reservoir in the butt of the gun to the rest of the gun. The designer and the manufacturers of these firearms in the 18th century did not have the tools necessary to make this as precise as it would need to be in order to be reliable. And so the gun was capable of shooting and exerting significant force, and it was a multi-fire weapon. But it was not a very reliable multi-fire weapon. And this was one of the reasons that it was not an especially popular gun.
Are there any notes of difficulties using the Giradoni and as a multi-shot weapon that you're familiar with?
Well, the ones that I'm most familiar with have to do with the Lewis and Clark expedition, and they did have one of these weapons with them. Apparently, they certainly had a multi-shot air gun with them, and sometimes it was very impressive. It was brought on the journey precisely in order to impress Native people. It also impressed non-Native people who had maybe heard of these weapons or maybe hadn't heard of these weapons, but were excited to see one in action. And sometimes it worked impressively, and other times it didn't. And so it wasn't the most reliable weapon on the expedition, that's for sure.
And was it a commercially successful weapon that was in common use in the United States?
No, it was not.
I want to take a quick side trip out of the history itself to some of the historical scholarship.
I actually have a question about that case, that situation with Lewis and Clark. Now, was that firearm issued by the federal government, or was it part of an independent private collection?
Your Honor, I actually looked into that to see if I could find out, and it appears that Lewis purchased that weapon as an individual in anticipation of it being useful on the trip.
Thank you. Go ahead, please.
Mr. Aiello submitted a declaration. The exhibit 4 to that declaration is a article in the Albany Law Review by Mr. Copel. Have you encountered that article before your work on this case?
I have. It's been some time since I read it, but I have read that article.
And do you recall your reaction to that article?
Well, In my estimation, the article presents intriguing information about the history of multi-shot weapons prior to the 19th century, but miscontextualizes those instances of multi-shot weapons prior to the 19th century.
Are you involved in any peer review processes in the field of history?
Yes, I am.
How so?
I have served on the editorial boards of a number of peer-reviewed historical journals, and I co-edit a series in 19th century American history with the University of Pennsylvania Press.
Do you believe that Mr. Kopel's article that was published in the All Leading Law Review would be likely to be accepted for publication in a peer-reviewed journal of history in the United States?
Not in the version that was published in the Law Review.
Why?
Because in the history profession, context is really, really important. And again, in my estimation, what the article does is it finds examples of highly exotic weapons that appeared prior to the 19th century and encourages the reader to think that these were somehow common, and they were extremely uncommon. And so that context is very important, and peer reviewers would have insisted that the author do more to recognize that prior to publication.
Okay. Let's go back to the history. In the 1850s, did multi-round revolvers exist in the United States?
They did.
And did they exist in Oregon?
They almost certainly did.
How did those revolvers function?
So the revolver had a device that you would feed rounds into, and it would the chamber would rotate with every shot, and another round would be available to fire. So it would chamber, depending on the gun, generally 5 to 6 shots.
And why do you say generally 5 to 6 shots? What do you mean by that?
So the revolver was a useful innovation in firearms technology that was picked up and experimented with by numerous different gun makers around the world. And so there were some attempts to make greater than 6 shots with revolvers. And I would even not hazard to guess, because there were many, many versions of this. But I will point out that every extra shot added size, which made the mechanical operation of the gun more complicated. So that's why the examples that I am familiar with are 5 or 6 shot weapons.
So does that mean that the maximum number of rounds that that weapon could carry at any one time was 6 or 5, depending on the weapon?
Yeah, for those versions that only chambered 5 or 6 rounds, that is the maximum amount that they could be loaded with at any one time.
And what was the firing mechanism on these weapons?
Prior to the late 1850s, the firing mechanism was something known as cap and ball. And so each chamber had to be loaded. It could be loaded in one of 2 ways. Generally, it would be loaded with powder, then sometimes with a patch, then with a ball, and then with some kind of a grease over the top of that. And then it would be turned or taken out entirely and just done one by one. And then when all that was done, a percussion cap lock or cap would have to be put onto a nipple on the other side of the chamber. And that's the process that would have to be followed before this was loaded. Now, in the late 1850s, Smith & Wesson developed the first metallic cartridge bored through revolver. And that was a very successful design that was going to become the new norm. But in the late 1850s, there were still only, they were in the thousands, and they were the only firm producing them, to my knowledge.
These cap and ball designs, how long did it take to reload a weapon after all of its rounds were fired?
It would have been highly dependent upon context and upon the individual. I think it would have been minutes, certainly, 3, 4, 5 minutes. And of course, if the individual was under stress, say, for example, being attacked or involved in a gunfight, it would have been much harder to do this effectively.
Were these revolvers semi-automatic weapons?
No, they were not.
How would they differ from a semi-automatic weapon?
Well, automatic weapons don't come into production until much later in the 19th century. And the basic principle is that they use the recoil of round one in order to eject the shell and chamber round two. And that was a major advance in firearms technology, and it originates with Hiram Maxim and the Maxim gun in the 1880s. And gun makers will be working on using that same principle for pistols and shoulder arms throughout the end of the 19th century. But that's not what revolvers do.
What do revolvers do?
Well, revolvers, when the trigger is fired, the chamber turns and another round is ready to be fired. So it's not using, first of all, there's only 5 to 6 generally, as I've said a moment ago. And secondly, it's not using the energy from the recoil of the first shot in order to affect the chambering of the next round. They also don't receive detachable magazines. This is just a fixed system, rotating system.
Okay, moving away from revolvers for a moment, are you familiar with a weapon called sharps?
I am.
And is that a multi-shot weapon?
No, that's a single shot weapon.
And it was in the 1850s, but it's not a multi-shot weapon.
Correct. Yeah, it was a breech-loading single-shot weapon developed in the early 1850s.
What about the volcanic?
The volcanic was a multi-shot weapon. It was a very early iteration of a design that was eventually going to be extremely important in firearms technology, a sort of lever-action multi-shot rifle, developed in 1855, 1856, and marketed and sold to a certain extent. But these volcanic repeating rifles suffered from a number of problems that dramatically limited their appeal.
What problems?
Volcanic repeating firearms suffered from gas leakage at the breech. One consequence of that happening is that they were very underpowered. So they were considered to be unreliable and unfit arms, for example, for large game hunting, or certainly for warfare. There was also a phenomenon that happened with some kind of alarming frequency where multiple charges would go off at the same time. It was obviously dangerous to the shooter. And finally, the final knock on volcanic repeating rifles was that they were prone to misfire, and there was no easy way to dislodge the bullet that misfired from the gun. So they suffered from numerous problems.
Were volcanics commercially successful?
No, they were commercially available, but I would not classify them as commercially successful for the reasons I've just explained.
Are you familiar with a weapon called the Spencer?
I am.
Was that available in the 1850s?
No, the Spencer came on the market in 1860.
And what was the capacity of the Spencer?
The Spencer had a 7-round capacity. The Spencer's tubular magazine was in the buttstock of the weapon. And so regardless of the size of the barrel, it had a 7-round capacity.
Okay. Was the Henry available in the 1850s?
No. The Henry also was put into production in 1860. 1860.
Did it have a detached magazine or a fixed magazine?
It had a fixed magazine.
And any particular type of fixed magazine?
Yeah, the Henry had a fixed tubular magazine underneath the barrel of the rifle.
And what is the import of something being a tubular magazine? How does that change how it functions?
Well, I think for me, the important distinction is more whether it is fixed or detachable. And the big difference is that with tubular magazines, for example, on the Henry, once the gun was empty, another round had to be loaded into it, one by one by one by one. In contrast to detachable magazines, where when the magazine is empty, the magazine can be removed and another full magazine can be inserted, in almost no time, and firing can resume. That's not how these these Henry repeating rifles work.
So it's slower to reload, is what you mean?
Yes.
Was the Henry a semi-automatic weapon or some other type of weapon?
No, the Henry was a lever action rifle. It was not a semi-automatic rifle.
I don't want to ask you to do math on your feet in court, so I'm just going to ask if you can take a look at paragraph 19 of your declaration and review that, the work that you did there, and then I'll ask you some questions about it.
Paragraph
19.
Paragraph 19.
Paragraph
Not
19.
page
It's on
19.
it's on page 9 of the PDF.
Got it. Thank you.
Yep.
Okay.
So let's start with your sense of what a fair estimate of the number of firearms in the United States was in the early 1870s.
Well, so that is something that does involve. There's no firm number. There's no agency to tell us exactly how many guns there were. But there are ways that we can at least establish a floor, and that's what I've attempted to do in this paragraph. So the very conservative estimate that I arrive at after having tried to establish that floor is 5 million firearms. But as I say in the declaration, I think that's implausibly low. That the number was probably far higher than that.
So at least 5 million firearms were in the United States in the early 1870s.
Correct.
And did you determine how many were firearms that were multi-shot firearms with capacities of greater than 10 rounds in the early 1870s?
I did.
Take us through that calculation.
Okay, so the Winchester Company, which produced the Henry and then the successor to the Henry, the Winchester 1866, the records of that company are preserved, and they're in the McCracken Research Library at the Buffalo Bill Cody Museum in Cody, Wyoming. And they have been used by historians of the company and of firearms more generally, including myself. The long-term curator of that archival collection, in a letter to a correspondent, calculated that there were 74,000 Henrys and Winchester 1866s produced between 1861 and 1871.
So were a large percentage of the overall firearms in the United States owned by civilians, Winchesters and Henrys?
No, that's not the case, no.
Roughly what do you think the upper bound of a percentage of the total firearms would be?
I think the absolute maximum percentage of large capacity firearms that would have been in the United States in the early 1870s is 0.2%. But again, that's based on my highly conservative figure of 5 million total firearms, which is almost certainly much, much too low. in which case the actual percentage of large capacity magazines in the United States in the early 1870s would be far lower than 0.2%.
Just a moment. What was the date range again? I'm sorry, I missed it.
Your Honor, it was 1861 to 1871.
Go ahead, please.
Just looking from a functional perspective, how are Winchesters and Henrys similar or different from a contemporary AR-15?
Well, they're different in a number of ways. The most important difference, in my estimation, is that, again, once the shooter finished emptying the Winchester 1866 or the Henry, they had to one by one reload the gun, bullet by bullet. And contemporary AR-15, depending on the size of the magazine, it's kind of irrelevant to the size of the magazine, actually, can be fired until the magazine is empty, the magazine is ejected, another full magazine is inserted, and firing resumes.
And going back to some of the revolvers that we talked about, handheld revolvers that I would call maybe a pistol. The pistols of the 1850s, how are they similar or different from a contemporary semi-automatic firearm using a detachable magazine?
Again, from my perspective, the most fundamental difference is rate of fire. That revolver from the 1850s, first of all, the vast majority were cap and ball, as I've described, which were very laborious to reload. But even the new Smith & Wessons that used metallic cartridges were far, far slower to reload than contemporary handguns with detachable magazines.
No further questions.
Thank you. Your witness.
Good afternoon, Mr. DeLay. When you say commercially successful, what do you mean?
The rough definition that I use for commercially successful is that a consumer who wants one of these items can go out and get one.
A single consumer.
Right.
What does common use mean?
Well, I suppose I would define common use as guns that are in circulation, that are broadly in circulation, that are not treated as curiosities or exotic weapons that people hadn't seen before.
So you just testified that commercially successful means one single purchase equals commercial success. Therefore, the Girandoni air rifle was commercially successful, wasn't it?
Sir, I think maybe I misspoke or you misunderstood me when I was trying to define commercially successful. What I meant to say, what I mean is that to be commercially successful, a weapon needs to be available enough to consumers that consumers can reliably expect to obtain one when they want one. That's how I would define commercially successful.
Would you agree that as firearm technology evolved, civilian technology led that evolution?
I wouldn't put it that way, but I suppose, yeah. If I may elaborate, if you'd like me to, I will.
Yeah, go ahead.
Okay. It is true that many, probably most of the major innovations that drove firearms technology forward in the 19th century came from individuals working in private capacities. But I think it's important to recognize that those individuals, above all, were hoping for military contracts. This isn't universally true, but it's generally true. So militaries and states, consequently, still played a huge role in what technologies were going to be encouraged and adopted and successful.
But the firearms before they were considered for military application were developed for civilian use, correct?
That's not always correct, no.
Can you give me an instance where that is incorrect?
Yes. So the Winchester 1866, for example, this is a weapon that was a very significant advance over what had come before. And the vast majority of them, Winchester made to export to foreign militaries.
Isn't it true that prior to 1859, civilians were broadly able to access the same firearms used by the military?
Yes, that's true.
You've testified about what firearms were available across the United States. In determining the commercial success of a firearm or the common use of a firearm in Oregon, how do you know what firearms were available in Oregon?
I have limited knowledge about what specific firearms were available in Oregon. And so what, as a historian in that circumstance, what I try to do is take what I know about the larger national market and extrapolate from there.
Is there a registry where the firearms that were owned by Americans were registered?
No, there's not.
You testified about several specific firearms. Isn't it true that firearm technology in the 19th century was evolving to adapt multi-shot technology during that era?
That's true.
The Sharps rifle accepted more than 10 primers, correct?
That's correct.
What are the components of a modern round of ammunition
Today,
today?
well, a priming agent, a propellant, and the bullet itself, and a case that's holding it all together.
So the Sharps rifle accepted more than 10 primers, which is a component of the ammunition modernly, correct?
It is one of the components of modern ammunition.
You testified about the volcanic rifle. Just to clarify, the volcanic rifle did exist prior to 1859, correct?
It did.
And isn't it true that it held more than 10 rounds?
It did.
The volcanic was advertised in newspapers, correct?
I am not sure, but I wouldn't be surprised if it was.
Would it surprise you? Would it surprise you that the drafters of Oregon's Constitution would have known of this firearm?
I don't know.
Do you have any reason to believe that the drafters of Oregon's Constitution did not know of this firearm?
No.
So it's entirely possible that while drafting Oregon's Constitution in 1857, the drafters of Oregon's Constitution knew that a firearm capable of holding more than 10 rounds existed, right?
It is possible.
So if the drafters of Oregon's Constitution wanted to prohibit private ownership, they likely would have done so in Oregon's Constitution, right?
I don't agree with that statement, no.
You testified about the Henry repeater being being introduced in 1860. Are you aware of any restrictions on the ownerships of the Henry repeater in Oregon around that time?
I am not.
Isn't it true that that soldiers purchased Henry repeaters to fight in the Civil War from civilian stores?
That is true.
So would it be fair to say that if the state of Oregon wanted to prohibit the ownership of the Henry repeater, it could have done so?
Well, I assume that if Oregon had wanted to do anything constitutional, it would have been able to do so.
Was the Henry repeater a 22 caliber rifle?
No, it was not.
What caliber was it?
I'm afraid I don't remember, but I know that it wasn't at 22.
Isn't it true that it was larger than a 22 caliber round?
Yes. Yeah, it was.
Are you aware of any time prior to the 20th century that firearm technology was intentionally driven backwards rather than forwards?
Nothing is coming to mind right now.
So firearm technology generally evolves, correct?
Correct.
Firearm technology generally improves, correct?
Correct.
It improves in areas such as design, correct?
Correct.
And its function improves as well, correct?
Yes.
Would you agree that firearms predating 1859 were more difficult to use than today's modern firearms?
Yes.
Modern firearms have improved in function as compared to their pre-1859 counterparts, correct?
Yes.
Has their design improved as well?
Yes.
But at the end of the day, we're still dealing with an offensive weapon that fires a projectile using a primer. I believe you said powder and accelerant and then a projectile, correct?
That's correct, as it was true in the 16th century. That was also true.
So you would agree that rifles existed pre-1859, correct?
Correct.
And handguns,
Yes.
pistols,
Yes.
shotguns.
Yeah.
So as those firearms evolve and improve in functionality, they become more easy to use, correct?
Generally, yes.
And they gain additional functions along the way, right?
Right.
Such as multi-shot technology,
Right.
semi-automatic technology,
Yes.
automatic technology.
Yep.
Would you agree that firearms capable of firing more than 10 rounds have existed since at least 1580?
Existed, yes.
I believe your declaration addresses the 16-shot wheel lock, correct?
I believe it does.
How did that firearm operate?
Well, may I review my declaration? I want to make sure I'm not thinking of the wrong one. Okay, one moment, please. I'm not sure I actually do address that in this declaration, but the 16-shot wheel lock, I think, had 16 barrels that rotated around an axis. It was a very mechanically complicated firearm.
Was there ever a version of the wheel lock of a firearm capable of firing 16 rounds that operated like a double barrel shotgun in the sense that you could fire the firearm twice, but more than 2 projectiles were ejected or were fired?
I'm sorry, can you ask the question one more time?
Yeah.
I'm not sure I completely understand.
Yeah. Are you aware of 16th century 16th century uses of firearms where they superimposed rounds on top of one another?
I am.
Are you aware of any firearm that existed that had the capability of doing so and firing 16 rounds?
I'm not particularly aware of that, but I would not be surprised to hear that such a weapon existed.
But you are aware that firearms existed that superimposed the projectiles on top of one another so that more than 10 projectiles could be fired from the firearm without reloading.
I am aware of that. Yeah.
Isn't it true that the puckle gun was capable of firing 11 rounds without reloading?
It's true that the puckle gun was capable of firing 11 rounds without reloading when it worked.
You state in your declaration that the Girandoni air rifle was not a firearm. Would you agree that it was an arm?
Yes,
The Girandoni was a weapon of offense, right?
it was.
And the Girandoni was an implement capable of being used defensively as well, right?
It was.
Isn't it true that the Girandoni could be used to fire a projectile to strike another person?
It is.
In your declaration, you talk about one such application where the firearm was fired accidentally and hit a person, correct?
Correct.
Are you aware of any definition of arm that requires a single shot to be deadly in order for it to be classified as an arm?
I am not aware of that.
Isn't it true that the Girandoni air rifle was not the only air rifle to exist in the USA?
That is true.
How many other air rifles, other brands of air rifle existed in the United States?
I'm not aware of any other brands, but I have seen advertisements of people charging people to come and see air rifles. So that's how I know that others existed.
But you don't have a final count on how many of those air rifles were in existence prior to 1859?
No, I simply know that they were rare enough that people would be charged to come and see them.
And you would agree that air pistols and other arms were created using the Girandoni air rifles technology?
I don't know about that. I'm sorry.
The pepper box revolver category was capable of firing more than 10 rounds and existed prior to 1859, correct?
Some of them were capable of firing more than 10 rounds, and they did exist prior to 1859.
And you would agree that the Jennings multi-shot flintlock rifle could fire up to 12 rounds without reloading, correct?
Yes, sir, I would agree with that when it worked. It was less reliable than the volcanic.
But it was capable of firing more than 10 rounds.
When it worked, yeah.
So your issue there is that the firearm did not function as well as modern firearms?
That's my issue.
And the Jennings multi-shot flintlock rifle was introduced in New York in 1821, correct?
I'm not sure of the date myself.
So while the while individual firearms and firearm platforms may have been rare or expensive, you would agree that the technology was known, that multi-shot technology was known prior to 1859, correct?
Objection, ambiguous as to known.
Go ahead and rephrase.
Would you agree that multi-shot firearm technology was that individuals could have been aware of the multi-shot technology?
Yes.
Was the multi-shot technology a secret?
No.
You speak publicly against individual firearm ownership, correct?
No, I don't do that.
On October 6th, you tweeted criticizing the Bruin decision, correct?
I don't remember the exact day, but I have tweeted criticizing the Bruin decision, yes.
Thank you. No further questions.
I have a couple of questions before I hand it back to you. Mostly because I'm interested and I don't get to talk to historians from Berkeley very often. During Polk's War, what type of firearms were they using that were multi-shot?
The only one that was prominent and significant in the war with Mexico would have been Colt revolvers.
Okay. And is it fair to say that immigrants over the Oregon Trail and the Trail to California had firearms with them generally?
Yes, Your Honor.
And what type of multi-shot firearms were they bringing with them across the Oregon or California Trail when they were emigrating?
My sense is that it would have been unusual for them to bring multi-shot firearms with them when they were emigrating, but those that had them probably had revolvers.
Thank you. Do you have any follow-ups to those questions?
Yeah, actually, Your Honor, one. Are you aware of any laws at that time prior to 1859 that restricted possessing multiple revolvers?
I am not aware of any such laws.
So if a revolver was capable of holding 6 rounds of ammunition, you're not aware of any laws that would prohibit an individual from possessing a second revolver also capable of holding 6 rounds?
I am not aware of any such law.
Thank you.
I'm also not a legal historian, though. I should say that.
I understood that. Go ahead, please.
We had a little bit of discussion about primer, I think, with respect to the Sharps weapon. Can you fire a round with primer alone?
No.
What would happen if you just fired with primer?
If you had a priming cap on the nipple and you pulled the trigger and there was no powder or projectile, you would get a small spark and a little bit of smoke, and that would be it.
It's like a cap gun?
Yeah.
There was some discussion of military adoption. Do you think military adoption of a firearm is significant historical evidence in the evolution of firearms?
I do.
Why so?
Militaries were engaged in very high stakes confrontations of numerous kinds, both internationally with other nation states and colonially with lots of different polities around the world. And so military advantage was something that was very much sought after. So once, for example, the militaries in the Western Hemisphere acquire repeating firearms in the 1860s and 1870s, that gives them significant advantage on a variety of different fronts. So there's a certain amount of conservatism that military is notorious for, and there's some truth to that. But the more powerful dynamic is the desire to have advantage over adversaries. And so from my perspective, the eventual adoption of a new technology by militaries is certainly a mark of the viability of that technology. And it's one of the reasons that although you can find multi-shot weapons back in the 16th or the 15th century, that European armies didn't use multi-shot weapons. It wasn't because they were indifferent to their own interests. It's because these weapons weren't reliable and they weren't effective.
And in terms of military use, where are you seeing the first military adoption of multi-shot weapons?
So the Henry is used by several thousand Union soldiers and officers during the Civil War.
And then what is the most significant early use of foreign militaries of a multi-shot weapon?
I believe that the main buyer of the Winchester 66s was the Ottoman Empire, who used it in a variety of different military contexts.
And which century of 66 are we talking here?
Pardon me, 1866. So this is the model 1866. And as I mentioned, most of the units that were produced of the model 1866 went to the Ottoman Empire for its military.
When the Oregon voters went to the polls on November 9th, 1857, would most of them have seen a volcanic?
No.
No further questions.
Thank you. Is this witness excused?
He is, Your Honor.
Thank you, doctor. You're excused from further testimony.
Thank you very much.
Well, I'm ready for a break. So let's take a 10-minute break. Get started again at 3:20. All right. Thank you.
What's going on, Smeggy? So,
Hey, how's it going? We got 10 minutes.
yep. How you liking this?
Well, I love this kind of stuff, but I'm also a nerd, so it is what it is. I wanted to kind of answer. It's a little bit easier to talk than type it all out. There was a few different people were kind of questioning, like, "Oh, we're back on history again." The main reason for that is this is the defense side of the case. This is the state side. So earlier this morning, the plaintiff, which would be like the pro 2A side, basically put up two different people, one saying, guns with more than 10 rounds existed a long time ago. So when the Constitution was written, the state specific, the Oregon Constitution, when it was written, people knew about these guns. So they didn't ban them back then. Why are we banning them now? And then, the other part of it was, oh my God, what the heck did the other guy talk? Oh, the T-Rex arms guy was talking about some of the magazines and the California compliant and not going to Oregon and stuff like that. But so this is the defense side. They brought up another historian to basically say, yeah, they existed, but they didn't work very good and no one knew about it. So that's their response to that. So I just kind of wanted to help clarify why we're going over some of the same stuff over and over again. This is the defense's response. And I'm hoping we get closing arguments soon. I don't know how many more witnesses there are.
Yeah, they didn't put up these are the people that are going to be testifying, yada yada yada. So I don't know. Yeah, we're talking what, 6 hours into this? I mean,
I would hope, since the plaintiffs basically brought up two different points, then the defense should kind of respond to those two different points. Like, okay, you have your expert witness that says this, my expert witness says that, and then the judge kind of picks like which one he believes more. And so I would hope that there's not too much more. Now, the defense could bring out 127 witnesses. This could last, 6 months if they wanted it to. I don't think they do, because it's just a preliminary thing. So it's like not the full, every little nook and cranny detail, just a general idea of trying to get the judge to side with them.
yeah, and the plaintiffs, so the 2A, the GOA, and a couple others, they've already rested their case. They're just waiting to do closing arguments, and so they're cross-examining right now. And yeah, pretty much the Berkeley guy was, anything that was brought up was, well, if and when it worked, that's probably not really a defense. You're admitting that the firearms were in use. Maybe, not everything works great. Let's talk about the Sky pistol. Hey, it's in use, but they've been known to be jam-o-matics. Does that change the fact that they're in use? Absolutely no. It doesn't change any fact.
Right. But also like that's kind of how witnesses work. That was the other thing I wanted to bring up. Like when the ATF agent guy, who was the defense's, basically their response to, the magazines being readily convertible and all that stuff, and how, well, there's all these base plates out there. So basically, this is the plaintiff's version is basically a whole bunch of mags all have removable base plates, like the most common do. You could easily take those out and put an extension in, therefore making it illegal. Therefore, you can't have the one with the regular base plate, but under the law because it's readily available. ATF's response to that from the defense side is, well, technically they make some that don't have removable base plates, or that they take a double stack and turn it into a single stack. Therefore, like, you can't put a base plate on it that can hold more than 10 rounds. So you're fine. Just buy that type of magazine. You'll be okay. Even though we all know there's only a couple of those available. Not all makers make it, all that stuff. And I forget where I was going with that point, but oh, that's what it was. People were saying, oh my God, this guy doesn't know. He keeps answering, I'm not sure, I don't know. It's not that he doesn't know, everyone. We have to remember the other side is not dumb. They just play dumb because that's what they have to. So when he was being crossed and the plaintiff lawyer kept saying, well, what about this? What about that? Well, I don't know. Well, could a commonly skilled person do this? Well, I don't have any idea what kind of tools they have. He knows damn well what the question was supposed to be and what the answer he is looking for. He didn't want to give him that answer. So he had to say, well, it depends. I don't know. The correct answer is, it's very hard for a regular person to take a standard double stack magazine, turn it into a single stack that can only hold 10 and not be changed. Whereas it's also very easy for a normal person to punch a rivet out or change a base plate. And he knows that. He just can't say that out loud. So he just goes, "Oh, maybe it depends on that." They do that on purpose. So I just want people to realize we're not dealing with stupid people. We're dealing with manipulative people.
So, if you had to read the tea leaves or make a prediction, do you think he puts the TRO back in place and leaves it till the 23rd, or do you think he allows them to have the 10-round ban?
From listening to what was presented today, and just kind of the way that the judge asked some certain questions, I think that at least, yeah, we're going to get the restraining order against the state until like further stuff. I'd love for him to just kick it out completely. I'm not sure he's willing to do that off of just one day's worth of testimony. But yes, I think today is leaning in a good direction for us. That's just my hypothesis.
That's where I'm leaning, is that, he's going to put the TRO back in place. And that's a temporary restraining order,
Yeah, basically saying you can't enforce this law yet because we're still figuring it out. Like there's still a court case challenging it, so you can't do anything until we decide yes, you are allowed to enforce it, or no, you can't. And that will come with lots more expert witnesses, lots more testimony, lots more, expert evidence and details.
Yeah, because the 23rd is the next court date at 10 a.m. And I think that's where we're going to get a lot more of the decision.
Well, I think that's going to be some of the permit stuff too, also, right?
Yeah, so that's going to deal with the first 12 parts of ballot measure 114, which deals with the permitting and all that. But he's also, this part here, the magazine also possibly could be reheard on that date. Or he may just say, you know what, we're putting this injunction against this until after the trial, this portion of them just affecting the magazines. And that's where I'm hoping he goes, is more of a permanent injunction against it. Fingers crossed that's what we get. But I know we should be getting ready to come back from court here the next, about a minute. Because he said 3:20, and it is 3:20 now. So somewhere in the next minute or two, the judge should be returning to chambers.
My one dog is patiently awaiting his return. My other one is not so patiently waiting because he keeps jumping on me and barking at me.
Oh, man. So the WebEx that they're using for this meeting, that side chat has been just popping this whole time.
May I ask how you found out about being able to join the WebEx?
So Oregon Firearm Federation emailed me all the information about it with all the access codes and everything. So I'm a life member of OFF, and as I can, I make more and more donations to them.
Please rise. Circuit Court is now in session.
I was just going to ask, is that something that's open to the public, to everyone, or just
the defendant's next witness?
Anyone can join OFF.
Have no further evidence to present on the motion.
All right.
No, I kind of meant join the WebEx thing, but
argument.
Oh yeah, yeah.
Anyway.
Anyone
Go
can
ahead,
join that
Mr.
if you
Riley.
have the link to it.
Thank you, Your Honor.
Okay, well, once again,
Your
I'm
Honor,
going to jump
plaintiffs have presented
again for
more
doing
than
this.
sufficient
Thanks everyone for
evidence,
watching.
both on their
And if
written
you're not
record
subbed to
and testimony
G23,
before
sub
this
him right now. He's
court
doing
today, for the court to conclude, consistent with defendant's interpretation of the standard, that firearms capable of holding more than 10 rounds are arms within the meaning of Article 1, Section 27, as modified by their modern design and function, that were of the sort commonly used by individuals for personal defense during the Revolutionary era, post-Revolutionary era, and in 1859. That standard comes from Delgado at 400 to 401. Additionally, we submit that defendants read the standard far too narrowly and offer our interpretation of the standard in light of Christian. Plaintiffs submit that the relevant case law before the court demonstrates that Article 1, Section 27 is not only a coextensive right with the Second Amendment, but a more expansive right. Specifically, defendants do not address the language from Oregon's Constitution that states that Oregonians have the right to bear arms in defense of the state of Oregon. That language, though mirroring the prefatory clause to the Second Amendment, even more plainly states that Oregonians have the right to be armed with modern firearms with which they could defend the state from adversaries, foreign or domestic. Exhibit 2, page 6 of the ILO Supplemental Declaration shows that the military was outfitting itself in the state of Oregon, including in Camp Harney, with firearms that were available to civilians at the time, as shown in Mr. Botkin's testimony, such as the Sharps and Spencer repeaters. That's also shown on page 5 with regard to Camp Harney. Likewise, plaintiffs submit that plaintiffs have presented more than sufficient evidence for this court to conclude that plaintiffs have a likelihood of success on the merits pursuant to ORCP 79 and the Elkhorn decision. Finally, plaintiffs also submit that the Oregon Supreme Court's holding in Christian reiterates a portion of the holding in Kessler that requires the court to look backward for historical analogs and a tradition of regulating firearms in the way proposed by the state. Plaintiffs submit that this analysis is similar, if not indifferent, from the test proposed in Bruin, or required in Bruin. However, the Bruin analysis, when narrowed to the state of Oregon, yields far fewer acceptable regulations under Article 1, Section 27. Therefore, the rights of Oregonians to bear arms is even broader than the right provided by the U.S. Constitution. Defendants have pointed towards exceptions to Measure 114, whereby Oregonians who already have non-compliant magazines will be permitted to continue to possess those magazines on their own property, as well as for certain specified purposes. However, State v. Christian, State v. Blocker, and State v. Delgado make clear that outright bans on the mere possession of protected arms is the mere possession of protected arms falls outside of Article 1, Section 27. Further, defendants point to exceptions under 114 that allow possession for limited purposes. This is not the purpose of Article 1, Section 27. Article 1, Section 27 is for self-defense and defense of the state, not for hunting or target shooting.
And on that issue, I mean, isn't the language of ballot measure 114 that any type of large capacity magazine is banned in Oregon? And that if you're caught with a firearm or a large capacity magazine at the outset or implementation about measure 114, that you would be subject to criminal prosecution unless you made a decision to immediately relinquish the large capacity magazine. And that if you do not do so, you can be arrested, charged, and taken to trial. And at the end of the state's evidence, you could show through affirmative evidence, a preponderance of the evidence, that you previously had the large capacity magazine and that you were using it in a function that comports with the exceptions. So everybody is effectively, under the law, presumed to be guilty of a Class A misdemeanor. Is that an accurate assessment?
Yes, Your Honor.
All right, go ahead, please.
Further, the affirmative defense is provided for in a non-existent statute. So whether that affirmative defense would even function is unclear as before the court today. That statute doesn't exist. So I don't know how it can say as provided for in a non-existent statute. If the non-existent statute does not provide for it, then I think we have a problem of even having an affirmative defense for Oregonians. And that is, I believe it's ORS 166.055 is the statute cited.
Okay.
Quoting from Christian, the Oregon Supreme Court has held, quote, held that Article 1, Section 27 prevents the legislature from infringing on the people's individual right to bear arms for purposes limited to self-defense. That's Christian at 30, citing Kessler. Even if this court was persuaded that defendants' hunting and target shooting exceptions were adequate, those exceptions will not survive the present generation of Oregon's firearm owners. As an attorney who practices in the probate and estate planning arena, that presents another problem. Your Honor asked at the last hearing about whether these magazines could be passed from person to person through probate, essentially. The answer to that question is that the statute does provide for that. However, you have to affirmatively prove that Grandpa kept his magazine only on his property or for these special and limited purposes. As someone who practices in that arena, I do not believe that's legally possible.
Doing something judges don't do very often. I was wrong. It can be transferred through death. So there you go. I acknowledge.
For Oregonians that do not already own a Measure 114 non-compliant magazine, they are out of luck because Measure 114 bans any future purposes, even for purposes of hunting, target shooting, or for defense of one's own property. Defendants urge that this court construe dicta from Kessler in an extremely narrow way, and that plaintiffs be required to show essentially identical firearms that were present prior to 1859. Essentially, defendants read out the requirement that the court consider how these firearms have been affected by modern design and function. However, even under defendants' extremely narrow reading of the test, the evidence before this court demonstrates not only that the drafters of the Oregon Constitution were aware or could have been aware of the firearms capable of holding more than 10 rounds of ammunition, but that also the founders of the United States were aware of such weapons as they existed in the 18th century. As Mr. Botkins testified, civilian firearm technology proceeded first, followed by the military application. Mr. Botkins also testified that the technological achievement of multi-shot firearms has been something that firearm technology has been working towards for centuries. Exhibit 8, page 13 to the supplemental ILO declaration shows that firearms capable of firing more than 10 consecutive rounds existed as early as 1580, and that repeaters capable of firing more than 10 rounds were gaining in popularity prior to the drafting of the Second Amendment or the Federal Bill of Rights. This is also shown in Exhibit 9, page 1, which was authored by David Kopel and references his brief. Moreover, page 10 of the Declaration of Mark Hainish, which is Exhibit 6 to the ILO declaration, states that 48% of firearm owners and 39 million people have owned magazines that currently hold more than 10 rounds. That's approximated to be 542 million magazines. The same declaration at page 12 shows that most modern pistols are built around a magazine capable of holding more than 10 rounds, and substantial evidence presented to the court from plaintiffs' declarations and live testimony shows that firearms capable of accepting magazines that hold less than 10 rounds are still banned by Measure 114. The test that defendants urge the court adopt comes from a pre-Christian case called Kessler, and that standard was echoed in Delgado. And it requires the court to make a finding of fact as to, quote, whether a kind of weapon, as modified by its modern design and function, is of the sort commonly used by individuals for personal defense during either the Revolutionary and post-Revolutionary era or in 1859 when Oregon's Constitution was adopted. As plaintiff's expert Mr. Botkins testified, as well as defendant's expert, these are rifles, these are shotguns, these are pistols. They've gotten better, they're less clumsy. You can reload them more quickly, but they are ultimately primer, accelerant or powder, and a projectile. They're rifles, shotguns, and pistols. Defendants read out the requirement that the court can consider the modern design and function and would require that plaintiff show an identical firearm. The court has heard testimony from Mr. Botkin and seen evidence in the record of plaintiff's petition and the supplemental ILO declaration showing that numerous firearms were capable of holding more than 10 rounds prior to 1859. In this way, plaintiffs meet even the Oregon Shooting Association's definition, which disregards the Henry repeater because it was developed 1 year later from Oregon's Constitution. 1 year after 1859, which is a nonsensical standard to hold Oregonians to. Mr. Botkin testified about the 16-shot wheel-lock, the volcanic rifle, the Girondoni air rifle, and other air rifles, the Jennings multi-shot flintlock, and other firearms that were capable of holding more than 10 rounds. Mr. Botkin also testified about the Henry repeater being used by Oregonians in Civil War that were purchased from civilian stores with the soldiers' own money. That was in defense of the state here, the nation, the Union, rather than Oregon specifically. But as part of the Union, they were defending Oregon as well. In addition to the facts plaintiffs have presented, Oregon Shooting Association v. Multnomah County actually agrees with plaintiffs that the drafters of the Oregon Constitution were aware of then modern repeating rifles, such as those identified by Mr. Botkin. Case does so at page 544. In that case, the Court of Appeals did not dispute the trial court's finding that Oregon pioneers were aware of repeating rifles, but affirmed the trial court's conclusion that semi-automatic firearms are not entitled to constitutional protection because they, quote, originated as or evolved from military ordnance, end quote. That's also at 544. The testimony before this court today shows that multi-shot firearms were not developed as military ordnance. So even under the most restrictive standard here, which would be Oregon Shooting Association, plaintiffs have met their burden. Nevertheless, the issue before this court is different from that in Oregon Shooting Association. This is not a question of function, but of number of rounds. And plaintiffs have shown that firearms capable of holding more than 10 rounds existed prior to 1859. Moving on to Christian, the Oregon Shooting Association case also added a standard that was not present in Kessler or reiterated in Christian, which is that the firearms could not have been developed as part of military ordnance. That standard was not present in Kessler. And Kessler did make reference to, in dicta, automatic firearms, chemical weapons, things of that nature, but not something that is a functional advancement in a firearm. That's what I mean by Kessler didn't say that that a semi-automatic firearm would be bannable because semi-automatic firearms didn't exist. It references a much higher degree of technological advancement than moving from a flintlock to a lever action. That's what the dicta in Kessler contemplates. Plaintiffs submit that the mandate from Article 1, Section 27 allow Oregonians the ability to access firearms that are modern and in order to defend the state. By defendant's standard, Oregonians would be expected to use antiques in defense of the state, which isn't what the constitutional provision contemplates. It would put Oregonians forced into that situation into a really difficult self-defense and defense of the state situation, because as I don't think any testimony contradicted that these firearms were difficult to reload. So plaintiffs and other Oregonians would be put to a disadvantage there. Under defendant's analysis, once the court agrees, if the court agrees that the arms in question meet the test initially proposed in Kessler, then those arms are protected arms. And as fully explained in Christian, once the court determines that arms are protected, the state is limited in its ability to regulate protected arms to manner of possession and manner of use. This limitation was initially stated in Kessler, which looks backwards to the English Statute of Northampton in 1327, which, quote, forbade persons to ride at night carrying a firearm with the purpose of terrifying the people. That's Kessler at 370. Likewise, the Kessler court also remarked that many courts have upheld statutes prohibiting the carrying of concealed weapons. These are examples of the legislature regulating the manner of possession of firearms in saying that one cannot possess a firearm for the purpose of terrifying the people or in a concealed manner. The Kessler court also cited to a 1678 Massachusetts law, which, quote, forbade shooting near any house, barn, garden, or highway in any town where a person may be killed, wounded, or otherwise damaged. That's also Kessler at 370. This is an example of the legislature regulating the manner of use of a firearm. Cannot fire the firearm where it's not acceptable to fire it.
You still can't ride through town on a horse terrifying the population with a firearm.
And
I'm just letting people know. Okay, go ahead.
the Kessler court validated these regulations on the ground that they have the aim of public safety and do not frustrate the guarantees of the state constitution. In other words, even if the regulation of the manner of possession or manner of use of a firearm can be unconstitutional if it infringes on the right to bear arms as recognized and guaranteed by Article 1, Section 27. This is essentially the same test proposed in Bruin. The Bruin test requires that the state demonstrate that a firearm regulation is consistent with the nation's historical tradition of firearm regulation. The state has and will continue to fail to cite historical regulations in Oregon or in this country supporting the banning of firearms based on magazine capacity. As articulated in the context of Christian, the United States and Oregon do have a historical tradition of disarming unnaturalized foreign immigrants and certain felons. There's also some history in the United States, though none that I have seen for Oregon, supporting the regulation of concealed carry around the time of the founding and before. Broadly, the Oregon Supreme Court, not unlike the U.S. Supreme Court, has found some historical tradition of firearm regulation when it comes to manner of use or manner of possession. Neither, however, have historical tradition of forbidding entire classes of firearms to law-abiding citizens because they have advanced technology or accept more than 10 rounds. Defendants urge this court to adopt the federal court's findings of fact in the parallel case. This court has heard and seen evidence that different evidence from that the federal court has seen. Moreover, the federal court did not permit live testimony from plaintiff's witnesses in that case, which is something this court did not do. With respect to the federal,
I think that's right. I'm going to make independent finding of facts without relying on evidence I didn't hear. I'm going to review the evidence that's been provided by the plaintiffs and the defense and make my findings of fact based upon those. I'm not going to rely on another judge's interpretation of facts.
With respect to the federal court decision also departs from Bruin in several respects.
I'm not interested in the federal decision. I've been really clear about that. I'm not making a decision under the Second Amendment. I'm making a decision under Article 1, Section 27. If you want to argue about the federal case, go argue that in front of Judge Immergit. You can move on into questions around Article 1, Section 27.
Measure 114 does not regulate the manner of possession or manner of use of firearms. It prohibits the mere possession of protected arms by law-abiding citizens. This is repeatedly found to be unconstitutional before the Oregon Supreme Court. This is included in Kessler, which is summarized in Christian at page 30 to 31, where the Kessler court struck down the ban on mere possession of a billy club even in one's own home. Blocker also concerned a billy club, but that had to do with regulation outside of the home, and that was likewise found to be unconstitutional. That's also at Christian, page 30 to 31. Delgado is very similar to Blocker, where Delgado struck down a law prohibiting the mere possession of a switchblade knife in public. That's also summarized at Christian, page 30 to 31. Here, Measure 114 goes further than any of these laws. Measure 114 prohibits the mere possession of the magazine, even if it's unloaded and not inserted into a firearm. An Oregonian can be arrested for walking down the street with an empty 11-round magazine and charged with a Class A misdemeanor, which is punishable by up to 1 year in prison or a fine of up to $6,250. Measure 114 also bans the mere purchase of these arms as well, which is something that has never been done on a statewide basis and upheld. Measure 114 also makes, as I stated earlier, the succession of a firearm magazine through a will or trust to be impossible, absent proving something I would submit to the court is impossible, that Grandpa maintained his firearm on his own property and never took it off for any unlawful purpose. In Christian, the Supreme Court reemphasized that Article 1, Section 27 forecloses the total ban on possessing arms in public in a case where it actually upheld a Portland ordinance that banned the knowing possession of a loaded firearm in public if one recklessly failed to remove that ammunition.
I want to stop you because I'm really baffled a little bit by the transfer question through death. Where do you read that there would have to be a proof that the magazine was never used in a fashion that's prescribed by ballot measure 114 prior to allowing the transfer?
Okay. Section 11, obviously subsection 5. And this is.
Okay, I see it. Subsection B, where it says was in legal possession of a large capacity magazine. So you're reading that as broadly as to say that if any previous, if there's any previous stain of criminal conduct, it wouldn't be possible to.
Yes,
I mean,
because
I really think that's a pretty extreme.
I
don't, having done probate work for quite a long time, I don't really think that that's something that would come up. It's the question, was it in their possession at the time of death? And I think the assumption would be that they had it lawfully at that point, wouldn't it?
Well, the subsection C there says, in addition to either A or B of the subsection, the owner has not maintained the large capacity magazine in a manner other than and then it lists the requirements. So that I would say that if in the probate context, it would make more sense to say transferee there. I would say that the owner would be the decedent in that instance, and then the transferee receiving the magazine through probate would have to show that the owner, because they are not yet the owner of the magazine, maintain the magazine as required under that subsection. But I don't want to get bogged down on that one.
It feels like it's a little boggy. Go ahead.
Yep. In Christian, the Supreme Court upheld a Portland ordinance banning the possession of a loaded firearm in public in a substantial part because the ordinance provided for an exception for concealed handgun license holders. No such exception exists for ballot measure 114. Going to Christian, quoting from Christian, quote, "We begin by observing that the ordinance expressly allows a person to knowingly possess or carry a loaded firearm in a public place if the person is licensed to carry a concealed handgun. Thus, the ordinance is not a total ban on possessing or carrying a firearm for self-defense in public, like those bans that this court has held violated Article 1, Section 27 in previous cases." That's Christian at 4041. The court then cites and summarizes Blocker and Delgado. At the Court of Appeals level in Christian, the Court of Appeals specifically looked at what the Portland ordinance did not do to justify upholding what the ordinance did do. Quote, "The ordinance does not prohibit a person from any conduct in home, even reckless conduct and intentional misconduct short of crime. It does not prohibit a person with a permit to carry concealed weapons from knowingly carrying a recklessly not unloaded firearm in a public place. It does not prohibit a person from carrying a recklessly not unloaded weapon in public in order to engage in justified conduct, reasonable defense of self against felonious attack. Its prohibitory scope includes only a person who has knowingly carried a loaded firearm in a public place for some purpose other than self-defense or other than defense of self or home from felonious attack, consciously disregarding the substantial risk that doing so will endanger the public safety." And that's State v. Christian 249 or App 1, Pin Site 9, 2012. Here, Measure 114 prohibits conduct at home, including transferring a magazine to another person. Magazine sales do not require background checks, so a transfer from one person to another would not generally run afoul of any other law there, but it prohibits it prohibits a person with a permit to carry a concealed handgun from doing so if that handgun or the magazine it requires runs afoul of Measure 114 like the vast majority of firearms. It prohibits all public carry of such magazines and firearms, including for the lawful purpose of self-defense against felonious attack and in defense of the state. In short, Measure 114 does everything the Portland ordinance in Christian did not do and more. Still, at this point, even if the court agreed that Measure 114 only regulated the manner of possession and use of firearms, Measure 114 still fails the Christian analysis because it infringes on the guarantees of the state constitution by banning the vast majority of firearms. As this court heard from Mr. Callaway and Mr. Botkin, Measure 114 bans the public, Mr. Callaway, Measure 114 bans the public possession and use of the vast majority of firearms for self-defense and defense of the state of Oregon. This is also demonstrated in the exhibits to, the Declaration of James Christensen. These are also not commercially available. There are simply not commercially available firearms, meeting Oregon's law, which goes far beyond what California's law did. Contrary to defendants' assertions, even so-called California compliant firearms and the magazines that accompany them are banned in Oregon due to Measure 114. The number of firearms available for Oregonians to purchase, if any, cannot be found. When regulating the manner or use of possession, the state must not infringe on the constitutional guarantee, which is a through line through the Oregon cases. In Kessler, the court stated, quote, "The courts of many states have upheld statutes which restrict the possession or manner of carrying personal weapons. The reasoning of these courts is generally that a regulation is valid if the aim of public safety does not frustrate the guarantees of the state constitution," and that's Kessler at 369 to 370. In Christian, the court stated that, quote, "As we earlier established, the legislature may specifically regulate the manner of possession and use of weapons to promote public safety, as long as the exercise of that authority does not unduly frustrate the right to bear arms guaranteed by Article 1, Section 27, and that's Christian at 38.
And to be clear, we have evidence and have heard evidence that firearms do not work unless they have a magazine.
Yes, Your Honor, and that is
It's an
also
integral part of of a firearm that has a magazine to hold rounds. Go ahead.
The Christian analysis also requires the court to look at historical analogs of these types of firearm regulations. Plaintiffs submit that the defendants have not shown any historical analog banning the mere possession of broad swaths of firearms, let alone magazines based on capacity, or even firearms based on their capacity. Ballot Measure 114 is bar none the most oppressive firearm regulation in the United States of America, and is of the sort no founder of the nation nor founder of Oregon could have possibly contemplated. In order to prevail on a motion for a preliminary injunction pursuant to ORCP 79, plaintiffs must meet the requirements of Elkhorn. On this, thankfully, the parties agree. Elkhorn first requires the court to find that plaintiffs have demonstrated a likelihood of success. Here, plaintiffs have essentially presented three arguments. The first is that plaintiffs have met their evidentiary burden pursuant to defendant's recitation of the case law, which plaintiffs submit is far narrower than it should be considered. There's also the standard of looking at the types of arms or the sort of arms available. Plaintiffs have presented evidence that the arms that existed in the 16th century were rifles, shotguns, and pistols. Those types of personal man-held arms have persisted through the centuries to today, where the firearms regulated by Measure 114 include firearms capable of taking magazines in excess of 10 rounds that are rifles, shotguns, and pistols. There's also a middle ground here where between the two arguments where plaintiffs are not required to show identical firearms, but historical analogs, such as the Sharps rifle that accepted up to 25 primers, which, as this court heard from defendant's expert as well as plaintiffs, is part of the ammunition. The primer, powder, and projectile are parts of the ammunition. So we have historical evidence of firearms that are moving that way, essentially. The court has more than sufficient materials in the written record and in the verbal testimony today to find that firearms capable of holding more than 10 rounds were known to this country and this state since the founding of each, respectively, and before. Therefore, we ask that the court conclude, for purposes of this motion, that plaintiffs have demonstrated that firearms capable of holding more than 10 rounds of ammunition meet the test as defendants have articulated it in their briefing. Insofar as plaintiffs have shown historical analogs for these firearms that existed and were known to Oregon's founders and the founders of the United States. Once plaintiffs have done so, this court considers whether the regulation in question regulates the manner of use or manner of possession of firearms. Here, Measure 114 does neither. To the contrary, Measure 114 prohibits the mere possession or carrying of magazines and firearms, which has never been upheld in the state and is specifically prohibited in every Oregon Supreme Court case. Therefore, even under defendants' narrow reading of the case law, plaintiffs have demonstrated a substantial likelihood of prevailing on the merits. Plaintiffs have also presented more reasonable readings of the case law that present a less difficult test. Plaintiffs meet these tests as well. Plaintiffs assert that they must show historical analogs but not identical firearms in light of Kessler's mandate that the court disregard modifications to these analogs and that are merely modern designs and functions. As defendant's expert testified, these firearms are essentially the same arms that have just improved in design and function. Examples of improvements in function include increasing the rate of fire, increasing capacity, and increasing lethality that have been a through line in advancements in firearm technology since the early portable cannon that Mr. Botkin discussed. To freeze firearm technology to 1859 makes zero constitutional sense and does not, and is the only right in which Oregon courts would be interpreting its constitution that way, so as to freeze it at the time of the founding. Oregon courts do not take such a rigid view in any other constitutional context, and the state's position on this issue is nothing more than a public policy preference. At the base level, the court can conclude that Measure 114 bans small arms rifles, shotguns, and handguns that were most certainly known to the Oregon founders and the United States in the pre- and post-revolutionary period. These firearms have existed for centuries and have only changed through modern advancements in design and function. Further, as plaintiffs not only have the right to bear arms in defense of themselves, but in defense of the state, it is far more reasonable to conclude that advancements in firearm technology were expected, and Oregonians were expected to adapt these technologies to the defense of the state against foreign or domestic enemies. While defendants would prefer Oregonians do so with antiques, this is not what Article 1, Section 27 contemplates. Indeed, as you have heard from Mr. Botkin, Oregonians fighting in the Civil War used their own funds to purchase the advanced civilian arms to defend the Union shortly after Oregon's founding. Additionally, plaintiffs ask that the court recognize the state's burden to demonstrate historical analogs for the proposed regulation as articulated in Christian and articulated in Bruin. When engaging in that analysis, defendants have and will continue to come up empty when searching for historical bans based on rate of fire, rate of loading, magazine capacity, or any of the functions that we've discussed today. Instead, as plaintiffs have put forth, there are historical examples supporting the regulation. There are historical examples supporting the regulation of the manner of use and manner of possession of firearms. Plaintiffs accept that concealed handgun licenses are justifiable under Kessler, Christian, and Bruin, and that prohibitions on the carrying of firearms by unnaturalized immigrants and certain felons have been repeatedly upheld, but neither support a ban on the mere possession of firearms for law-abiding Oregonians.
You want to answer the first question I think under Christian is whether the restriction is reasonable to promote public safety. You want to address that question?
Yes, Your Honor. I do not believe it's reasonable to address public safety. Magazines, firearms are capable of being reloaded, and Measure 114 does not stop the carrying of multiple magazines. It also inhibits public safety by taking arms out of the hands of law-abiding Oregonians to defend themselves.
Did you have anything else?
Yes. Next, plaintiffs must show that they will suffer imminent and irreparable harm if defendants are not enjoined from enforcing the magazine ban while this case proceeds. Plaintiffs have demonstrated that they will be deprived of their right to bear arms for self-defense and defense of the state by being deprived of arms capable of holding more than 10 rounds of ammunition immediately upon the expiration of this court's temporary restraining order. Additionally, notwithstanding this court's temporary restraining order and the federal court's 30-day stay on the permit to purchase program, tens of thousands of Oregonians are currently awaiting background checks that will be unable to receive the firearms they purchased prior to the ban because they come standard with the capability of holding more than 10 rounds of ammunition. Plaintiffs must also show that the balance of harms tilts in plaintiffs' favor. Defendants resent the enjoyment of their law and have presented speculation that an atrocity could occur if law-abiding citizens are not deprived of the right to bear arms in public for self-defense and defense of the state. The harm that defendants contemplate is purely speculative, while plaintiffs' harm is concrete and is shown in the record. The harm to plaintiffs is occurring now as they are, or would occur as soon as this court lifts it, if this court were to lift its temporary restraining order. The balance of harms favors the status quo over radical change, the individual over the government, and a fundamental right over regulation. Finally, the court must determine whether the public interest weighs in favor of an injunction. Here, Oregonians narrowly voted in favor of Measure 114. Both sides of this issue are extremely interested in the outcome of these court proceedings. However, plaintiffs have shown that Measure 114 goes further than even the state contemplated, banning the sale of the vast majority of firearms used for self-defense. Measure 114 similarly bans firearms that would undoubtedly be necessary for the defense of Oregon as a state. The confusion surrounding which magazines and firearms are banned under Measure 114 should also bear on this court's decision. As plaintiffs have addressed, finding the lowest capacity magazine for one's firearm and determining whether there exists an extender capable of extending that capacity beyond 10 rounds is extremely difficult. This will result in Oregonians facing a Class A misdemeanor, criminal charges, punishable by up to 1 year in jail or a fine of $6,250, ORS 161.635. The reality is that the criminals defendants fear may bring harm on Oregonians will continue to disregard Measure 114. The only practical effect here will be that law-abiding Oregonians will be stripped of the arms necessary to defend themselves against such atrocities while this case is proceeding. And while the case is proceeding, the measure could ultimately be found to be unconstitutional. As with the balance of harms, public interest favors maintaining the status quo while the constitutionality of this law is determined before subjecting Oregonians to the deprivation of their constitutional rights and potential criminal charges.
Thank you, sir. For the state, for the defendants, I'm sorry, for the defendants who happen to be all state actors, but for the defendants.
Thank you, Your Honor. I will discuss the first threshold question of whether these are arms based off of the test in Oregon shooting sports. Mr. Wilson will address the practical argument about whether this amounts to a total ban on numerous firearms.
Okay. I'd like you to address the public safety question too, because I do have some questions about that.
And the question is whether or not this does in fact aid public safety.
It reasonably promotes public safety. That's actually the standard. And I've reviewed your documentation that you filed with the court. And if I understand it correctly, I have some questions that I'd like you to answer.
Okay, let's start there. I never want to delay the court's questions. I mean, I can present the evidence in the record that talks about the promotion of public safety, or I can answer direct questions.
Well, go ahead. I mean, you can do that if you'd like. If I understand correctly, though, in Oregon, the annual rate, I understand that ballot measure 114 is designed to reduce mass shootings. That was what it was promoted to do.
I agree with that, Your Honor. That is the principal purpose, yes.
And my understanding, and not to diminish the personal loss of any individual person, because I have lost friends to suicide by firearms. I've buried people that were very important to me. I know that there's a substantial pain associated with that, and I don't wish to diminish the loss that people individually feel. But we're talking about a broader question around public safety, the promotion of that public safety by restraining a constitutional right to bear arms. So let me preface it that way. There's no easy way to say these things. My understanding is from your literature that in Oregon, you have a 0.3 in a million chance of being injured or killed in a mass shooting. Is that accurate?
I don't know what you're basing that on, Your Honor, sorry.
It's fine, let me get to it. Marshall Declaration Exhibit 5 shows that nationally the annual rate of mass shooting fatalities per 1 million population nationwide is 0.36 per 100,000 population. And in Oregon, under the same exhibit, it's 1 million population for fatalities of 0.3.
Are you on the Webster Declaration or the Webster article, or are you on something else?
Exhibit 5 to your declaration, Mr.
Okay.
Marshall.
Okay, and what page number are we on?
$11 and then 24 off of your charts that you provided associated with that.
Yes, I agree. That's what the chart says. And I think that we've been fortunate. I mean, that's what I'll say.
Fair enough.
These are not common events. They're extraordinary events. They're tragic events. And I want to say that I don't want to diminish any of the lives that are lost to firearms across the board. I also want to say that there is a special terror that occurs with a mass shooting that is different in kind when a single human being can go in and slaughter elementary school students. I
don't disagree with you at all. At all.
And I dropped my son off at a school, a public school that rents space from a synagogue. If someone comes in to that synagogue and shoots it up anywhere in the country, which has happened before, that is a terror to every parent who drops off a child at that school. And so I just want to say that it is a different in kind thing.
I have relatives who are people who are very close to me who work in schools, and I have children in school. So I understand what you're saying, but terror is one thing. Addressing that terror through something that impacts a right to bear arms is another thing, and there has to be some balancing, doesn't there?
Well, first off, they don't make the threshold showing that this even is an arm that qualifies as there. So I'll go to that later. But if they do, and we have to go into whether or not this is a reasonable public safety measure, that's effectively a rational basis standard. And you may say that, or the courts may say, the court can find that it is a rarity that there are mass shootings. That is still a reasonable object of regulation. And I will say that very same exhibit that you cited, Exhibit 5, says the most effective regulations to address mass shootings, multi-state, multivariate analysis, are the two that Measure 114 enacts. Number one, prohibit large capacity magazines. And number two, have a permit to purchase that has a fingerprint-based background check.
Number two, it does definitely say that. On large capacity magazines, it does not. It says that there isn't a statistical sample sufficient to make that scientific determination. They say that it seems to have an impact, and that's on paragraph, I think 42, on page 42.
Well, page 1 in the summary of research, it says handgun purchase licensing laws and bans of large capacity magazines were associated with significant reductions
That's
in the
the
incidence.
synopsis, isn't not?
It is.
It's
the
in the,
summary
it's
of its
in the, it's in
conclusions.
the conclusion, the actual conclusion of the article. It says it seems to. I mean, that's important.
It's the best public policy evidence that's been presented to the court. It's the best that I'm aware of. And it says it
I
is
agree with
one
you
of the,
that.
it is one of the, it is the only 2 ways that have been shown by public policy analysts to be able to address mass shootings.
They say that the permit to purchase is a way that they have been able to statistically show reduces mass shootings. They say on large capacity magazines, it seems to, but they cannot definitively say that to a high degree of scientific probability.
Okay.
And so, I mean, I just want to make sure we're talking about the same thing, and I want to give you an opportunity to address it for the purposes of the record, because that's what I'm looking at, and I'm trying to make a decision on whether or not it promotes public safety. I find it difficult that we have as a judge to do that, because I reminded of Frank Uraguan's statement, Judge Uraguan's statement to me the first time I tried a case in front of him. He used to sit here. He said, "Are you arguing public policy?" I said, "I am." He said, "You're delusional." And that's how I feel about it to a degree. But I do have to make these determinations, do I not?
I think no, actually you don't. I mean,
Okay.
the question is whether or not it's a permissible and rational basis. And respectfully, Your Honor, the majority of voters rejected that argument at the polls. And they are the legislature. They are entitled to make that judgment. They decided they thought it would be effective. And so you can say, well, I think that there is some degree of uncertainty in what the best learning is on this topic, but ultimately it's a legislative judgment that the courts owe deference to, and that is right in the cases relating to the reasonable judgment.
Well, let's be clear. The preamble says that pistols accompanying a large capacity ammunition magazine poses a grave and immediate risk to health and safety and well-being of the people of the state of Oregon.
Yes, they want to stop mass shootings. It's true.
Okay, well, sure.
Okay. Now, I want to also cite since the court has indicated interest in the public policy evidence, on Exhibit 3 of my declaration, on pages 43 to 50 is Professor Clavaris's analysis, a multi-state analysis that also concludes that large capacity magazines are effective as a tool to reduce mass shootings.
And Exhibit 5 of your declaration says that Clavaris's studies were limited. Go ahead.
Okay. So, I mean, in terms of empirics that we have presented in this court, that's what we presented. Okay. On the threshold question of whether these are arms at all, you start with the Oregon Oregon State Shooting Association case. A weapon must satisfy 3 criteria. 1, although the weapon may have subsequently been modified, it must be of the sort in existence in the mid-19th century. 2, the weapon must have been in common use. 3, it must have been used for personal defense. So I read my friend's argument to be that Oregon shooting sports may have missed the mark, and that he thinks that the Supreme Court had a different reading and that overread or misread Supreme Court precedent. He's welcome to make that argument in the Supreme Court. I don't think he can make it in this court. I think if you look at what the evidence presented to this court shows, the entirety of the record, I think, is quite clear that there were museum pieces that had more than 10 rounds capacity before the Constitution was adopted. But that you see that the first more than 10 round firearm that had any degree of commercial success or was really in any sort of common use was the Henry that was patented in 1860. 3 years after the Oregon voters adopted this Constitution, a year after the Constitution, or before the Oregon became a state, it comes too late. And even if you say that it didn't come too late, 12 years later, evidence shows 2 out of 1,000 firearms were large capacity magazine firearms in 1872. So that's, I mean, that's the first, I think that's kind of the end of the case from my point of view. We have no large capacity magazines in 1859 that were in common use for self-defense. I mean, I want to go through their record because I think it actually favors us quite a bit, and go through the details of the evidence that they present to provide I mean, we didn't have an opportunity to respond to this in writing. So I just want to make sure that the court has our view of these issues. So Exhibit 2, there's 3 issues with Exhibit 2. That is their record of the
Attempts to purchase a firearm, right?
It's records from the 1860s
Oh, I'm sorry.
of who,
Right, thank you.
of what the what was being purchased in Oregon by the military. First problem, too late. It's 1860s. Second problem, none of the firearms listed are large capacity magazine firearms. Third problem, the quantities are way too insufficient to show common use. So even their own evidence is not helpful to them. Exhibit 3, nothing about large capacity firearms. It's a law review article. Exhibit 4, the Copel article, the thing that started this entire line. I think I want to direct the court to the bottom of page 1 and top of page 2. The first time a rifle with more than 10 rounds of ammunition did so, meaning achieved mass market success, was in 1866. And the first time a handgun did so was in 1935. So the folks who are trying to make this argument in the federal courts, the historians that I think we dispute are even overreading the historical record to be favorable to the early introduction of these weapons, say that the introduction came too late. Exhibit 6, page 6, Colt AR-15 first became available on the commercial market in 1964, too late. Page 20 of Exhibit 7, Winchester Model 1866 that held more than 10 rounds was the first to achieve commercial success. So that's their evidence, comes back after 1860. Page 37 of Exhibit 8 is talking about the first semi-automatic in 1885. Exhibit 9 is a blog post from Copel that does the whole museum tour. But we already saw what Mr. Copel thinks, which is that the first time that there was a rifle with more than 10 rounds of ammunition that was commercially introduced was 1866. And then Exhibit 10 is the Oregon Firearms, a chapter from an Oregon Firearms Handbook from Hornback. Says nothing about large capacity magazines. So our view of the historical record is they lost. They had an opportunity to present evidence. They didn't do it. The question is, were there any of these in 1859? The answer is no, and that means that it is not covered as an arm of the sort that was available at the time of the founding of the state.
Okay, so I guess my last question on that issue is they found that the framers and the adopters through the public of the Oregon Constitution in 1857 were aware of the fact that there were multi-capacity firearms, correct?
We agree that there were revolvers, yes,
Okay.
in Oregon.
And how do you square that issue? I mean, development of these firearms over time have made them capable of holding additional capacity, but how do you square that with the analysis about the development of firearms over time?
And I think that it's not, at some point it becomes not of the sort. And I think that that is what Oregon Shooting Sports stands for. And I think that if you look at the functionality, both the number of rounds that are held and the ability to use a detachable magazine to quickly swap it out and insert even more rounds, that both of those are instances where you have an where you're having the capacity for a single shooter to deploy a number of rounds that was wholly unknown in 1859. It's a different in kind analysis. And if you look at the Clavaris Declaration, there were no mass shootings before 1954. There were no real penetration of large capacity magazines until the federal ban expired in 2004. They were in existence, they were not common. If you look at table 2 of exhibit 3.
And then with regards to large capacity magazines in mass shootings, I think the states or the defense's documents show that they're used in maybe half of the mass shootings that have occurred in America since the onset of mass shootings in America. Do I misunderstand that?
I think you do, Your Honor. I'd look at table 1 of the Clavaris Declaration. It's on which is page 6 of exhibit 3 of my declaration.
Right.
So if we're looking at 2015 forward, all but one involved a large capacity magazine.
And they're talking about this document here.
Yes, sir. Sorry, and I said 1954. It's actually 1949.
Since 1949 until May of this year, there's been 30 mass shootings.
With more than 10 deaths, yes. With 10 or more deaths, yes.
Okay. I understand. Thank you, Mr. Marshall. Go ahead, please, Mr. Wilson.
Thank you, Your Honor. Your Honor, I would like to address plaintiff's argument that Measure 114 operates as an effective ban on all firearms because magazines with a 10-round capacity can be readily converted to a larger capacity. We disagree with this argument, Your Honor, and we do so for 3 reasons. The first reason is a factual reason. The fact is that many manufacturers manufacture firearms that come standard with 10-round max capacity magazines. And the reason they do so is because that many states, other than Oregon, restrict the maximum capacity of magazines. And those states include California, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, and New York. We heard testimony today from various witnesses, including Mr. Callaway, and Mr. Yurgalitis, that many manufacturers make and sell what are known as state-compliant firearms, and that those firearms come standard with magazines with a maximum capacity of 10 rounds. There's also exhibits in the record, Your Honor, that are on the declaration of Greg Scott. Those exhibits are exhibits 1 through 9 to Mr. Scott's declaration. Those are examples of websites that show such quote, state compliant firearms for sale.
And the Glock has one that's 10 magazine plus 1, and wouldn't that be illegal under Oregon law?
No, I don't believe so, Your Honor. The magazine restriction refers to the capacity of the magazine, not the capacity of the magazine plus the firearm.
And these other states do have, in fact, have not banned, have not required, well, let me just read the language.
Sure.
Ammunition feeding devices that are permanently altered so it is not capable now or in the future of accepting more than 10 rounds of ammunition. So that would be a fixed plate that there was no capacity to alter. I mean, the argument from the plaintiffs is almost everything can be altered with minimal skill. Maybe more skill than me, but minimal skill.
I think we don't necessarily accept that interpretation of what the statute requires, Your Honor, at least when it comes to whether a magazine that is sold as a 10-round maximum capacity magazine can, in fact, does the mere fact that it could potentially accept an extender or that it could potentially be altered in such a way as to accept more than 10 rounds, does that make it illegal under the statute? And we don't necessarily agree with that interpretation, Your Honor.
How do you read that? Permanently altered so it's not capable now or in the future of accepting more than 10 rounds of ammunition?
Sure. Let's start with extenders, Your Honor. So one way that plaintiffs have made this argument is they've said, look, there are some magazines like these state compliant magazines that I've just been talking about that you could simply slide the base plate off and put an extender on. And they say because you can attach that extender, because that's a theoretical possibility, that the Measure 114 bans the 10-round magazine, even if it's not actually connected to an extender. I don't think that that is the only interpretation of Measure 114, Section 11, Sub 1, D. It is also a reasonable and constitutional interpretation of the statute to read it this way. If Your Honor sees, it says large capacity magazines, and I'm going to skip over some language just for convenience, means a fixed or detachable magazine, including any such device joined or coupled with a kit. Now, I'm highlighting that language, Your Honor, because it is reasonable to interpret that that language is intended to prohibit magazines that have been attached, have an extender kit attached to it. So I think it is perfectly fair in one interpretation to say that Measure 114 prohibits or restricts magazines that 10-round magazines that have an extender attached to them.
Well,
Now-
what about the or language right after
Well,
that?
I will come to that now.
Go ahead
Your
and
Honor.
get to there.
Okay, now coming to that, the next phrase has to do with whether magazines can be readily restored, changed, or converted to accept more than 10 rounds of ammunition. Whether a magazine can be readily converted, restored, or changed to accept 10 rounds depends on whether that person has a magazine extender readily available. The theoretical existence in the world somewhere of an extender or some change that could happen to the magazine does not mean that it is ready or readily available to the person with the magazine.
Well, it says can be readily. I mean, it's not just that it is readily, that it can be readily.
I agree, can be
And
is
that
in there.
language is significant, I think, in terms of interpreting this statute.
I don't disagree, Your Honor, but I would say that the interpretation that I'm offering you right now is a fair interpretation because there's a textual hook for it. And then I'd like to offer a few contextual reasons why that's the more likely interpretation. The first is the fact that sub 1D seems to contain an actual prohibition on magazines that have been joined, past tense, with an extender. That context seems to suggest that the phrase following the or doesn't apply to magazines that have not been joined to an extender. The second reason.
Well, wouldn't it also be true, though, that the or means each of these separate events? So it's joined together or coupled with another through kit or with a kit of such parts or can be readily restored. I mean, doesn't it try ultimately through its construction to try to capture any opportunity in which there can be any modification to a magazine to allow it to carry more than 10 rounds?
I think that's the question we're trying to figure out. And so there's a couple of other contextual reasons I think.
I'm sorry, I should have interrupted you.
That's
Please
okay.
go ahead.
Yeah. There's a couple of other reasons I think that or shouldn't be read that way. One of those reasons is that when, as Your Honor knows, when Your Honor has an option to interpret a statute in a way that could be constitutional or in a way that could be unconstitutional, the Oregon canons of construction require courts to construe the statute in a way that is constitutional.
Absolutely.
The second reason is that interpreting the statute to effectively ban all firearms seems to frustrate the exact purpose of the statute. Throughout the statute, it refers to large capacity magazines. It chooses that language because apparently it intends to enact restrictions on large capacity magazines, not all firearms. There's nothing in the preamble to Measure 114 that suggests that the purpose of the statute is to restrict all firearms, to make it impossible for an Oregonian to purchase a firearm. The purpose of Measure 114 is to restrict large capacity firearms because of their use in mass shootings. If you take that purpose and the canon of construction that Your Honor and all courts should try to interpret statutes in a way that are constitutional, it is a reasonable and fair reading of Section 11, 1D, that large capacity magazines means magazines with 10 or fewer rounds, unless they have actually been joined with an extender. And that's an important, when Your Honor has two interpretations, I want to talk about why that's important in just a moment. But before I do so, can I back up to the factual question, Your Honor?
Sure.
When we were talking about the fact that, what magazines are available and not available in the state of Oregon, one of the questions that came up is, are there any magazines that cannot take an extender that are made by major firearms manufacturers? And I want to point to a couple pieces of what we heard today. First, there is the testimony of Mr. Yurgulaitis about the factory magazines that Glock manufactures. Those factory magazines are 10-round magazines, that's their maximum capacity, and they are single stack, not double stack. Mr. Yurgulaitis testified that he was unaware of any extender that could be fitted to a single stack Glock factory manufactured magazine. What that testimony shows, Your Honor, is that for some of the most popular firearms available, the Glock firearms, there are magazines that cannot be extended. And you can purchase those Glock firearms with that magazine. They're available, as you can see in the declaration of Greg Scott, Exhibit 1. They do sell those so-called state-compliant firearms with 10-round maximum magazines, and they cannot be extended. The second piece of evidence I'd like to point to, Your Honor, is Exhibit 9 to the Greg Scott Declaration. This exhibit shows a Sentry Tactical magazine available for AR-style rifles that has a 10-round capacity and has a base plate that has been riveted to the bottom of the magazine. Now, we had some discussion today about how that would affect a magazine to have the base plate actually riveted to the bottom. And there are two elements of that testimony I want to hone in on. The first is whether magazines like that could be easily modified. There was some testimony that you could still pry the base plate off, you could remove the rivets, that sort of thing. But I would point to, when considering that testimony, Your Honor, I would point to the testimony of Mr. Yurgulaitis again. Mr. Yurgulaitis testified that rivets can be removed, but that it may take some skill or some technical knowledge to remove a rivet. And in any event, if a rivet had been removed, it may affect the functioning of a magazine. So there are magazines you can purchase commercially that have base plates that are fixed to the bottom of the magazine, and that removing those base plates, even if you have the technical knowledge to do so, may affect the functioning. I tell you all this, Your Honor, just to make the point that there are commercially available magazines that are built in such a way to try to prevent having an extender attached to them, or are built in such a way to try to prevent them from allowing more than 10 rounds. And it takes some knowledge, some skill, in order to make alterations to those magazines such that they cannot just be readily, easily restored, changed, or converted. They can be changed or converted, but it takes some skill, it takes some knowledge.
I mean, I think I heard them, at least some of the testimony was that it takes the skill of being able to use a hand drill.
I can't remember the exact piece of equipment.
It takes about 5 seconds to take the rivet out. I think that was what I heard from Mr. Callaway.
I do believe.
Strikes me as relatively readily.
If that testimony is correct, but I think you need to weigh that testimony against the testimony of Mr. Yurgulaitis, who said that it does take a little bit of technical skill to do it, and you run the risk of creating a magazine that is no longer functional if you remove those rivets.
Thank you.
I want to briefly address the testimony, Your Honor, of Mr. Callaway with respect to the vendors he spoke with. And that's also testimony that can be found in the declaration of Mr. Christensen, which was submitted with plaintiffs, but there's no testimony here today. That declaration and Mr. Callaway testified that they had attempted to purchase magazines with 10-round capacity from Midway USA. That's for both Mr. Callaway and Mr. Christensen, and then for Mr. Callaway, also from Xander's, and I think it was Lipsy's. I may have written that down wrong. And that those particular vendors would not ship their 10-round magazines into Oregon. Your Honor, even if that's true, a vendor's decision with respect to whether it would choose to sell a particular product into Oregon or not, that decision is not binding on whether Oregon's law is constitutional or not constitutional. A vendor might have many reasons that it would prefer not to sell into Oregon. And, I'd point to the testimony of Mr. Botkin, who said that his company, T-Rex, did not sell magazines into California because they, quote, preferred not to. It didn't appear to be a legal reason. He didn't testify that it was a legal reason. We don't have any testimony here today directly from Midway USA, Xander's, or Lipsy's about why they chose not to sell magazines to Mr. Callaway. And so we don't know. In any event, these are just 3 vendors. Even Mr. Callaway allowed that there may be vendors who might sell 10-round capacity magazines into Oregon. He simply didn't know because he only spoke to 3. The evidence goes only so far as those 3 vendors, and even that evidence, we don't have a clear understanding as to why they chose to not sell those magazines. As a final point, Your Honor, I'd like to address.
I just want to make sure we're all on the same
Yeah.
page. This is a preliminary question, a preliminary showing. It's not really a final, the final injunctive or hearing. So I understand the state's argument, the defendant's argument around that question. I think it's a sample size. I don't know what sample size it is, unlike some of the statistics we have in front of us today. But I do know that I do want to make sure that's clear for the record. But I understand what you're saying, and I agree with the logic behind how you're saying it. But it is preliminary.
I understand, Your Honor. And I guess I would say this then. Even if it's the case that Your Honor interprets Section 11, sub 1, sub D to mean that any magazine that could take an extender is effectively restricted by Measure 114. It would still be the case that the most popular firearm, or one of the most popular firearms in the United States, the Glock, can be purchased with a magazine that cannot take an extender, and that there are other firearms, such as revolvers, which could be sold in Oregon, even under that interpretation. And I know, to Your Honor's point, we don't know the percentages here. I say it only to make the point that we know that at least some could continue to be sold. It is not a ban on all firearms.
Understood.
My last point, Your Honor, has to do with the nature of plaintiff's challenge. Plaintiffs are bringing a facial challenge to Measure 114, and they're to Measure 114's large capacity magazine restriction. Under a facial challenge, Your Honor, hypothetical interpretations of what the law might or might not require are not, cannot be considered. The court must address that only in an as-implied challenge. Here, there is simply no factual record of an Oregonian attempting to purchase attempting to actually purchase a large capacity magazine, or let's say a 10-round magazine that could theoretically take an extender, and the state taking some kind of enforcement action against that person. That is not what's before Your Honor.
I don't think that's the way the law works. And frankly, the reality is that if this law is allowed to be implemented, at least 19% of Oregon's population would be criminalized immediately based upon the information that was provided in the pleadings and factual basis. Because 38% of Oregonians own firearms, 48% of them have large capacity magazines. If I allow it to go into effect, their possession of that is criminalized unless they make a affirmative showing by preponderance of the evidence they have a legal right to maintain and hold that weapon. That's immediate, sufficient, and I don't buy that argument for a second.
Well, if I may, Your Honor, I'd just like to explain at least where I'm coming from.
You absolutely should make your record. I know we're not stopping here. So go ahead and make your record.
Your Honor, the Oregon Supreme Court has held that for a statute to be facially unconstitutional, it must be unconstitutional in all circumstances, i.e., there can be no reasonably likely circumstance in which application of the statute would pass constitutional muster. And that quote, Your Honor, for the record, is State v. Sutherland 329 or 359 in 1999.
Yeah, regarding bail. I'm well
You
aware of that
know that one.
particular statute.
Good, Your Honor. I make this point to go back to this question about what interpretation of Section 11(1)D is the correct interpretation. Plaintiffs are suggesting that the interpretation is that any magazine that could take an extender must be prohibited. And I've suggested an alternative interpretation. So my point, Your Honor, is that there is some instance of Measure 114. There is one interpretation that is subject to a constitutional interpretation. And because that is the case, Measure 114 cannot be found to be unconstitutional simply because plaintiffs have advanced one theory about why it might be unconstitutional. There are multiple reasons, some constitutional, some not. Therefore, the facial challenge must fail. Ultimately, Your Honor, we would ask the court to deny the motion for a preliminary injunction. We do not believe on the historical evidence my colleague, Mr. Marshall, has presented, or on the factual and expert evidence that I've just discussed, that plaintiffs can make a showing that they are likely to prevail on their underlying claim. And for the reasons of public policy and irreparable harm that Mr. Marshall covered in his colloquy with Your Honor, we don't believe that defendants meet those, plaintiffs meet their burdens on those elements either. Finally, we incorporate all of our written materials into the record. Thank you, Your Honor, for your time.
Thank you. Anything further?
Yes, Your Honor.
We have another hearing today that's delayed, but go ahead, please.
Just quickly, Your Honor, Oregon State Shooting Association has never been cited favorably or at all by the Oregon Supreme Court, and the Christian case proposes a different test than is provided for in Christian. They're mutually exclusive tests. Defendant's argument essentially with regard to firearm technology advancing too far is essentially that modern firearms are more functional. They're able to be reloaded and carry more rounds. That is a modern design and function, which is provided for in the case law. Defendants said that many firearms make 10-round max capacity. The record does not support that many firearms are capable of complying. Defendants on expert declined to say most or many or a percentage. Mr. Callaway's testimony was that most do not. Quickly, just Exhibit 5 to plaintiffs or to the supplemental ILO declaration is the California iteration of a similar law, and this California's law specifically does not contain the language about or that can be readily restored, changed, or converted, and that's why these firearms and magazines can be shipped to California, cannot be shipped to Oregon. Defendant stated that we have no statement from Midway USA on why they are refusing to ship magazines here, and posits that it may be voluntary. If you look at Exhibit 1, page 3 of the Christensen Declaration, it says, quote, Oregon has quote, these products cannot be included with your order due to the following, colon, Oregon has restricted the sale of magazines that have a capacity of more than 10 rounds or those that can be adapted to hold more than 10 rounds, e.g. those with a floor plate or end plate. So we do have some indication of the reason why Midway USA is so refusing. That's also on Exhibit 2, page 2 of the same declaration, the Christensen Declaration, with regard to a firearm, a Beretta, as opposed to a firearm magazine. Defendants disagree with plaintiff's interpretation of the words overall capacity, can be, and defendants from Section 11(1)D Defendants also, as Your Honor stated, are reading out the or in that provision. The canon of construction regarding interpretation of constitutionality still requires that the interpretation be somewhat reasonable and that it be a reasonable reading, and plaintiffs submit that defendant's reading is not reasonable and requires on leaving out language to make it fit defendant's preferred definition. Defendants disputed that rivets can be removed to readily restore to full capacity, restore a magazine to full capacity. Mr. Callaway's testimony is that an individual could drill them out with a hand drill and that it would take less than 5 seconds. Plaintiffs are not asserting an as-applied challenge here. The exhibits about the vendor's decision is to show irreparable harm. Plaintiffs maintain that there is no constitutional application of Measure 114 in its bans for firearm magazines capable of holding more than 10 rounds. And Christensen, Blocker, and Delgado all say that blanket bans on arms is not permitted under Oregon's Constitution. Last, with regard to the public policy arguments here, the Christensen test requires that the public policy argument that the reason justifying the regulation still is limited to regulating the manner of possession or manner of use. This does neither. So no matter how persuasive defendants believe their public policies arguments are, they still lose, because a ban on magazines does not regulate the manner of possession or manner of use. That's still a requirement under Christensen.
Well, I want to thank both parties for their hard work and today and their clear arguments. You've given me a lot to think about. I'll issue a letter opinion no later than Friday at noon. That's what I can tell you at this point in time. Is there anything else? We're going to meet again, I guess, on the 23rd to discuss the background checks, some of the for gun shows, and I'd like the parties to confer, but we'll have that hearing if there's no outcome of conference on that. And then we'll just move from here. We still have to set a hearing for the permit to purchase process, and you folks can let me know when you're ready to go, and we'll make room for that hearing. Anything further?
Yes, Your Honor. One more thing here. I believe the court's instruction was for defendants to file in writing by this Friday with regard to the
Yes,
background
I did,
yeah.
so that y'all are on the same page about what we're talking about at the next hearing.
Thank you, Your
Anything
Honor.
else from the defendants?
No, Your Honor. No, Your Honor.
Thank you.
Oh, wow. That
That was interesting.
wasn't all day. Yeah, it was very, very interesting. So, what'd you get out of this?
I would say that the state's defense is in trouble. They don't seem to have much of a leg to stand on. Also, I've re-upped my confidence that the judge will, extend the what do you call it, like the injunction on it, because even he was like arguing with the defense dude during the closing, Also, I do want to make one point, and I think people kind of understand what I was getting at, but during the plaintiff's like closing stuff, I had some frustration in him not being like clear and concise. He had a chance. I even timestamped because I thought he was gonna just go. Basically, we're saying three things, boom, 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 and then he didn't, and he kind of got distracted. That by no means means that I'm anti-gun or anti-2A or that I even disagree with him. I just was expressing frustration that he did not speak eloquently enough, whereas the defense side actually did do a pretty good job at getting their side out very clear and concise. They were just wrong, but they were wrong, like, clearly. So I just wanted to make that point. I know G-Web's accused me of being anti-gun now, but that's okay because I think he's just joking.
Yeah, and I think there was a times where he got flustered because, like the judge was like, I don't want to hear anything about, what's happening in the federal. If you want to argue federal, go to federal, go to the federal judge, and there's a couple other times where he could have been a little more clear and precise, I do believe. But for the most part, I think that anything that the state attempted to do, the plaintiffs were like, you're a moron, and they put out, evidence showing, and even their own PhD guy from Berkeley was like, oh yeah, you're right. So welcome, G-Webs. Thank you for listening in.
I wasn't there for all of it, so I was going to say, you've been sitting there for all of it. What was worse, listening to all of that or eating that what did you have, the gummy?
Oh, the one chip challenge.
Or chip or whatever. Yeah, what's worse, eating the chip or listening to all this?
Eating the chip.
All right. So you listened to it for probably longer than I did. I went out and did stuff and came back, and this has been going for 8 hours and 5 minutes, it says up there. So I'm sure there was breaks and things in there, but in a summary, all they did was hear everything today, or did they come to some conclusion, or did more than that get accomplished or less?
So, the very first part of the day, they set the new court date for December 23rd for the first 12 parts of Measure 114, which would be the permitting process and all that, and put the TPO back in place, saying that it will stay until the next court date of December 23rd at 10 a.m. And then 99% of this.
Hold on. So the TPO is like the thing that's stopping it from going into effect was supposed to end, and they were like, no, we'd like it to keep going until the 29th. And then the defense was arguing that, no, it should just go ahead and take effect right now.
So, yeah, it would, if the judge wouldn't have replaced the TPO, the temporary protection order, stopping the permitting process, then there still would have been the 30-day stay on the federal side of that, but the state could have then petitioned the federal judge to go ahead and remove that stay. And then it would have gone into effect immediately. So he redid it until the next court hearing on the 23rd, which is the Friday before Christmas. And then after that hearing, he will wait it could take up to 10 days for him to issue his final ruling on that. So he said that he would have his decision no later than January 3rd at noon for that portion of it.
Okay, he said that today then. That was part of today.
Yeah, that was part of today. And the magazine portion of it, which is what we heard for the 99% of the 8 hours that we've been going, was we heard that portion, and he will have his ruling by 5 p.m. Friday. So in a couple days.
All right, it sounds like he's made up his mind then. If he doesn't need more time to worry about it, then until Friday. So that's Wednesday, Thursday to write it up, and then Friday he'll say his thing. I mean, it didn't sound to me like he was debating anything. He was letting them say their speak, and then he was clarifying, right? From what I could tell from the voices, it sounded like the judge was the guy in the middle. The guy who sounded like he was trying to con you into something was the defense of the bullshit attorney, and then the one that Smeggy hates is the one that sounded like he's eating a mouthful of pancakes or something across the table from you at breakfast. The attorney for the pro-gun side.
Yes.
I know what he's talking about. The guy sounded like his mouth was full or something the whole time. Like he just kept sounding like he was looking something up and his mouth was full and he wasn't ready for the answer or something. Where the other guy was trying to talk you into something, so he was all, he's playing con man, playing salesman.
Also, I think he had a plan going into his closing and everything, and then when the judge stopped him a couple times, I think that kind of threw him off track, and so he was trying to reformulate his closing like on the fly, and so there was a lot of pauses and hums in there based on the fact he was trying to like really formulate the sentence and make it so that it was easily understandable. But I think he was having a little bit of problems while with the state attorney. He just argued emotions, and so the judge really didn't get on his ass, so he got to kind of stay on his game while the other guy got kind of thrown off his. It's kind of where I see it. I mean, I could be wrong.
Yeah, well, that's where I was thinking the judge was asking the one guy actual questions like, oh, you have a thing? What's the answer to that? Okay, thanks. I'm like, where'd you get the answer to that? Okay. And then the other guy would be like, but it'll save lives. Like, why? And then he would go, okay, well, whatever. And then he would just move on. Like, he didn't ask that guy any other questions because I don't think he was as interested in that guy's position. Or I'm reading it the wrong way, and that guy didn't need to listen to that guy because it's all a big scam. It's all been paid off. It's all been figured out ahead of time. And they're just going through the motions. They're getting paid overtime to go through the theater. But I didn't get that impression. It sounded like he was listening to the one guy. The one guy was trying to answer questions, like give him resources and the references and whatever. And then the other guy was like, he didn't have nothing with references. He just would say, dumb things like, well, magazines didn't work good. And when it worked, and, that kind of stupid thing. Or he let the other guy say that, I guess. But he asked him those kind of dumb questions. Well, how many magazines did they have back in the old days? Was our side well prepared? I think so. I think the pro-gun side was what, a GOA attorney, you said? He sounded like his mouth was full, but I mean, he was right. He was on point. He sounded like he had good subject. What are the words? Like he used good approaches. Like he was solid with his awareness and he was coming with good things. I don't think there's any, like a lot of times when we're sitting here on the sidelines, we can come in with like, oh, you should have said this or you should have said that. Like he said good stuff. Like I only could think of one time where it'd been like, oh, I would have said that a little bit differently. Or like a bunch of times he was like, addressing things that were competent. Like I don't think he did bad at all, except that he sounded a little funny. But I mean, nobody gets any points against him. We're just making fun of him because we can hear their words or whatever. We can, but the judge ain't gonna hold that against nobody. I don't think.
Yeah, you know, and
Oh, are you going to tell them about how some YouTuber was on here? Everybody was going nuts because some YouTuber was on being a expert witness and he did good, right?
so that was T-Rex Arms.
So you hear
So
that? There was a YouTuber on here. There was also a point when I couldn't believe it, but the prosecuting, the people that are anti-gun and the people that are pro-gun and the judge and a bunch of people that were just in the courtroom all agreed that Glocks are the best pistols.
yeah,
For like 15 minutes, they were all just like, yeah, we can't believe how much we all agree on Glocks being the best pistol. It's basically a done deal. They made a whole ruling about it in the middle of there. Rob probably wasn't here.
Yeah, I found that interesting in the defense case is basically, well, this one
What?
convert it, therefore the law is constitutional.
yeah,
We're going to ban 98% of everything else.
No, you broke up. All we heard is like a word or two. It was weird.
So they pretty much agreed that what is it? The Glock 43, because the 43X has a 10-round mag, which also has readily available mag extension. So you can't use the 43X. I'm sorry.
Wait a minute. All right, wait, so you saying you can take the bottom part of the magazine off and put an extension on there, and then that makes it an extension?
Yeah.
I can't believe how much they talked about that. Oh my goodness.
Like, truly, I mean, how moronic do they think that we all are? That you cannot figure out how to take the base plate off. I mean, 99% of magazines that you can pop the base plate, you can just use a punch and remove them, or you can just use your finger and remove them. And if they have a rivet in them, it's not like it's not hard to take said punch and pop that rivet right out.
It's basically engines. I was thinking. I think I would have said it's like engines, buddy. Like you're acting like magazines are this thing that makes them magic, and that some guns are magic because of their magazines, and magazines enable them. They're just engines. So if you make it where you can't mess with your magazine, you're just making it where you can't open up your hood and work on your engine. So yeah, you can make a little hole and put oil in there, and you can maybe change an air filter, and you can fill it up with gas, but that's all you're going to be able to do. Maybe blow it off with water or something, but eventually that car is going to die. And if you don't know why, then you're an idiot, because that's what he was essentially like. What do you mean if you don't take a machine apart, it's going to break? What do you mean if you can't take a machine apart, it's going to break? What do you mean? And that's where the guy, I guess that's one of the times where I was like, come on, guy, be competent and say that all magazines aren't the same, you dullard. It's not like gasoline that all cars use the same gasoline. These idiots probably, I mean, I agree with Smeggy earlier that they know what they're saying. They're trying to manipulate, but they probably don't put much effort into this, and they probably don't have any idea how ammo works. So they probably think all bullet, like there's a bullet and all guns use the bullet. You know what I mean? Like they're not that bright about this stuff. So they're either being intentionally obtuse about that, or they're doing that for their long con. They're trying to make that part of it seem onerous or difficult so that the whole thing becomes a chore. And in reality, they wouldn't have put unconstitutional stuff across if the plan wasn't to move the Overton window, cost a bunch of money, distract from all the other things, like all the stuff we were making fun of Oregon about, right? Like the free drugs and the no laws against drugs and stuff, but guns are so bad, right? Like you're not worried about the heroin or the other kind of deaths, but you're worried about potential gun deaths. It's such a distraction that ain't even funny. So that whole like going on and on about magazines was sort of, I would have appreciated the lawyer for GOA to have said, let's clear this up really fast, because letting that guy go on and on about I don't know, he was just, what do you call it, like unraveling a sweater? Like he was just making something out of nothing. He was just picking apart nuance for no reason. And who even knows what magazine? If you sit here and just listen to that guy describe magazines and his idiotic idea of how magazines are, and their confusion about why it would be bad to not take apart a magazine, are they thinking about a 1911 magazine? Are they thinking about a Glock magazine? Are they thinking about like a Browning 25 ACP magazine? Are they thinking about a Sten magazine? Are these idiots thinking about an AR magazine? Do they know what an AK magazine is? And these are just like 6 magazines out of a billion magazines that are out there. So they think magazines are like I don't know. I think they really think magazines are something like a paper cup where it's like an insignificant thing that we just need to have it, like toilet paper or, filter or something. I don't think they realize that they're different, and some of them are super worried about tolerances and other ones could care less. They just don't care. And that's, again, part of the reason I think they went on and on about it, so that they can keep everything distracted or whatever, keep the thing going. Because if they would have said something obvious, then we could have just challenged them on it. This is like a soft spot or a place they can pick.
Yeah, and it was really funny that they had the retired ATF guy in there, and like pretty much everything he said when he was describing magazines and if magazines are legal, stuff like that, it was just really funny that he was pretty much making the plaintiff's case instead of helping the people who hired him. Because I didn't see any part of his testimony that helped the state in their defense of this new restriction. I mean, I could be completely wrong.
Yeah, and that's one of the things. First off, do I sound a little bit better now?
Yes, sir.
Okay. I apologize for my bad connectivity. It's just weird because I hear you guys perfectly fine, so I just assume like I have a good connection. Like I don't hear any breakups. But anyways, kind of going back to the defense's side of things of saying, oh well, magazines are sold to California, so it's no big deal. And show me where someone's been prosecuted for having a 10-round mag with a removable base plate. It's like, we can't, because that law isn't in effect yet. The whole point of it is, as soon as the law goes into effect, those people will be prosecuted. And the basic difference is, they're readily available or readily converted. And I would be interested to see, because the guy touched on it after the defense talked, the plaintiff talked like one more time, and he referenced, some page number of basically saying the difference between the California magazine law and the Oregon magazine law, and why California compliant mags can't be sold in Oregon. So hopefully his written stuff is, much more clear and can really, really nail that point home. And it sounds like the judge kind of already agrees with that point just from the questions he was doing. So, but either way, I think today was a pretty good day for the 2A side. Like, I think the position was shown pretty well.
Oh yeah, I think, like G-Webs was saying, I think the judge kind of already knows, and he's just gonna be spending the next couple of days writing up his decision. If he sticks to like what he did last time when he wrote his first, it's gonna be a pretty short and
shall not be infringed.
Yeah, it's going to be really short and really to the point, because his first decision was like 8 pages compared to the federal judge who put out, I think it was like 80 some pages for her decision. So this guy is going to be more like, here it is, here, it's all cut and dry. I'm not going to deal with the bullshit, But I'm going to probably wrap this up because I know Ghost Tactical is probably doing his live stream. And
come on, you can only do 8.5 hours of streaming a day.
Weak. I thought you were 2A. Come on.
I mean, what happened to, how long did we go during the last one? I forget. Was that the concealed or the constitutional carry case? It was like 13 hours or something.
Oh, the
You
one,
got no
yeah.
conviction.
Yeah, we did go quite long on the Supreme Court case. That was a very long live stream.
Well, thanks for doing it because it does kill a channel. So a bunch of people have been saying thanks for streaming because it's cool to have somebody. And it's going to be, it sucks because somebody's going to come along and offer a summary, get like 200,000 views, probably make a couple of, $1,300 on that video, not to mention whatever sponsorship, and everybody will buy their merch and stuff. And all they'll do is summarize, the stuff that you've been watching. So I do appreciate people that stream. You've done it before. Others done it. This is, but we've watched it from Connecticut, Illinois, Texas, Louisiana, Georgia. We've watched stuff like this, long format stuff. So this stays on the channel and it stays on the internet. So there are people that can watch it, not just like a feed from whatever they filmed it in Zoom. There's no feed from that. That just went out temporarily as a stream and it's gone. So you recorded it on this end. But if somebody else recorded it as like a C-SPAN type of generic, like I'm just going to archive it for history. I mean, I hope somebody does that. But now there's a copy that you created that's 8 hours something long that not only has your and Smeggy's jumping in. I don't know if other people jumped in and chatted like this, but then also the comments and all that in the future. I keep saying that the internet today is like back in the day when you open up a shoebox from some, you go to some storage locker and you buy a old storage locker and it's got a shoebox of old photographs and you open up those old black and white photographs and it's just little snapshots of whatever, some city or some farm or some party or some event or some ship christening. You're taking little you're looking at those photographs and getting that information about the past. AIs are going to be doing that about the, using the internet, like those old black and white pictures. So all this stuff that y'all are creating when you do these long format things, you're literally recording history the same way that some historian is going to open up a box of photographs and go, oh, look at what we just added. Instead of just having the clinical transcript of what happened, we now have some actual discussion about humans that were alive at the time. So I really appreciate this. A lot of people don't value that, but there's a lot of value there. And again, it's frustrating, I know, when you watch your channel, do what it's going to do, when you destroy it with its metrics with a long channel, like with a long video like this. Everybody, they're not doing anything to you, but when they watch this video for a moment, your metrics go to shit because this is an 8-hour video. They just watched 1,000th of your video, and YouTube values view time. So there's just no way for anybody to watch this whole thing. So it's an actual sacrifice. I appreciate the people that spend time like this. That's why I like to take a second to chat it up, because too many people are just going to, not even appreciate it. And then again, champion the suckers who are going to just summarize it for moments in a 3-minute video that people will consume 100% of. And like I say, make $1,500 from it and then move on to whatever, Connecticut or New Jersey or whatever the other subject is tomorrow, as if they're accomplishing anything more than just summarizing. So I appreciate the people that are authentic and doing it. Thanks for it.
Yeah, thanks. And I'm glad, we had like 90 people in here at one point. And I know one guy had commented way earlier before we took the hour and 20-minute lunch that he was streaming, or he was playing this at his work, at a gun shop. So, and I'm glad that, he was able to have this playing so that people could hear, what was going on and be able to, go be a part of it. And I'm definitely glad that, everybody who came and hung out, we're talking 8.5 hours. That's an entire day. I mean, I know that people didn't stay the entire time. People came in and left. And that's, absolutely okay. But I do thank them for, being here. A couple people, shared out the live stream on their community tab so that other people would know that it's going on, or they can go back and go, maybe they get home from work and then they're like, oh crap, I can watch part of this, and fast forward or whatever. Yeah, I know it's going to hurt my channel
Will be
analytics,
available.
but yeah, they'll be able to watch this whenever they want, So, and I thank Smeggy for jumping on multiple different times and helping get through some of the breaks. So thank you again.
Oh, thanks for having me. I love nerding out about this stuff. So if I can help out in any way, I will. And like I said, I did do some timestamps. I think you're going to put some in too, but probably once this turned like into an actual video, I'll just put it as a comment. And I don't know if you're going to put it in the description or whatever, but I think I got most of the changing, right? Of like, now this dude's talking. Okay, now it's this one. Now, like, I kind of timestamp that stuff. And a couple of funny moments.
Yeah, and I screenshotted a lot of the timestamps that you posted. And so once this kind of goes in, I'll go into the video on the YouTube studio side and add a bunch of the timestamps and things like that, so that people can jump ahead and just hear what parts they want to hear if that's what they want to do. And I definitely don't expect people to sit there and listen to me ramble for an hour and like 20 minutes during their lunch break, So.
Well, why not? We got to listen to the lawyer ramble for an hour with absolutely no legal basis.
Right? And so, yes, if anyone's out there and wondering, I will be doing this again on December 23rd. That court date, that one starts at 10 a.m. Pacific Standard Time, so 1 p.m. Eastern Metric Time. So we will be back, and I definitely thank everyone who has decided to hit the subscribe button, and we shall see you. Hopefully I'll have enough streaming hours to stream Saturday, so we'll see. I thank everybody.
Because StreamYard doesn't give you the hours, just get another email and log into StreamYard with a different email, and then you'll get a whole nother, 4 hours or whatever it is, 10 hours?
20,
and they'll get a whole nother 20. I was doing the show before I was paying them with 3 emails, and I had 2 shows going at the time. So as soon as one would fill up, I would just switch emails. They'll let you connect all your channels to every email. They don't care about it. It's just a worker. It's a loophole. It's a StreamYard loophole.
Okay. I will definitely probably do that, because I'm probably running low on my hours, but we should be good. Play the outro and we're going to get out of here.